those facts. So since people are still coming, we can hold on. When the number increases a little, I will chip in and talk about it, and we see what we need to do as an institution so that we don't leave those loose areas where people can easily tap in and abuse our systems. Worship Kagoya Jackie, I warmly welcome you. She's the Chief Magistrate at Bikwe Chief Magistrates Court. Thank you so much. I request that you come and chair the session, and you invite your facilitator and any other panelists if they are there. Thank you very much.
Thank you so much. Good morning, Your Worships, ladies and gentlemen in the room. I am Jacqueline Kagoya, like she has said, the Chief Magistrate. This morning we shall have a session on ICMIS and CAS data entry for evidence-based performance and planning. And I want you to join me, Your Worships, to welcome our presenter this morning, that is Mr. Sinabulia. Please, you're welcome to the podium. In the interest of time as he gets in, allow me to read his brief bio. Mr. Sinabulia is a Principal Information Management Officer working with the judiciary. He plays a pivotal role in overseeing the development, implementation, and maintenance of efficient information and records management systems across the judiciary. For the last 15 years, he has dedicated his service in information systems management and he's recognized for his expertise in implementing information systems, ensuring data security, and performing transparency, accountability within the Uganda judiciary. Mr. Senabulia holds a number of qualifications, academic, and one of them is a master's degree in information systems management from UMI, a postgraduate diploma in information systems management from UMI still, and he also holds a bachelor's degree in computer science from Makerere University, together with quite a number of other education and work experiences. In his profession, Mr. Senabulia, his career span rides over a decade, and during that period, he has held several leadership positions. Some of us have witnessed his positions even within the judiciary, and among them are computer programmer, senior information technology officer, as a principal information management officer, and some of the responsibilities are those that you have seen him doing from the other different courts where he has been. Among them is data protection, information sharing, digital transformation. He's one of the people that have led the judiciary to have a very good data system, especially for us, the judicial officers. In the community, Mr. Senabulia is attached to so many associations in relation to his field of work. But what has fascinated me most about him is that he believes that effective information management is the backbone of a financial and transparent judiciary. He is committed to leveraging technology and innovation to ensure that Uganda's judiciary operates efficiently and delivers justice equitably and promptly. Your Worships, join me to welcome Mr. Sinabulia to make his presentation.
Thank you very much, Your Worship, the moderator, chair of this session. Your worships present, distinguished participants, ladies and gentlemen, good morning. Good morning, your worships. I welcome you all to this presentation, and I'm known by the names of Joseph Sinabulia. I am the Principal Information Management Officer, and I also double as the IKIMIS Project Manager. The topic that I'm going to present on today is IKIMIS stroke CAS data entry for evidence-based performance and planning. So my presentation is going to be a little bit brief, mainly focusing on the reporting aspects of the two systems that we are using. So I want us to get enough time to have quite a number of discussions relating to the systems that we are using in as far as IT is concerned, and also have an engagement on the challenges that we are facing and the solutions that we can be able to generate out of this discussion. Briefly, my presentation outline includes a few introductions and definitions, features of these systems, the system modules, the categories of users, and then we shall have a live demonstration of these systems. By way of introduction, we mainly have three important information systems that we are using for capturing and managing data within the judiciary. Amongst them is the court case administration system, which we usually refer to as CAS. Then we also have the electronic court case management information system, which we usually abbreviate as IKIMIS. And then we have the last one that is not very common amongst us, which is the summary statistics data management system. Now, this one is hosted at the Registry of Magistrates Affairs. Whenever you submit your manual returns every month, they are captured in that summary statistics data management system, so that we can be able to combine your performance at the court level and at individual level, and be able to compare and know that the chief magistrates are either performing better than the grade 1 magistrates, or the grade 1 magistrates are performing better than the chief magistrates. Then we are also able to rate the courts and know which court is actually performing better than the other courts. So using these three systems, we are able to generate on a monthly basis what we refer to as the court case performance report for each month within the judiciary, because all the statistics that you submit to us have to be captured, and then we are able to generate the report from the system. Now, these systems mainly perform four functions. 1, capturing information. 2, processing that information. 3, storing that information. And 4, outputting that information in form of reports. Without your submissions, at certain points, we are unable to generate these reports or even provide our performance in as far as disposal of cases is concerned. That's why this matter is very important in as far as capturing this information in the system, because the finances we are given are pegged on the work that we are going to do the next financial year. We present to Ministry of Finance and say we have a total number of pending cases that we have to dispose of. We have a total number of backlog cases that we have to dispose of, based on the information that you provide us or that we generate from this system. So if you do not input this information, we are not in position to generate accurate reports. And what we generate is actually what we present to Parliament or what we present to Ministry of Finance. So at times we also find it very hard to justify the need for more funds, because the statistics that we are actually presenting are inaccurate. So that's why we need to input this information into these systems. Now, there is a slight comparison between these two systems, IKIMIS and CAS. These systems are both web-based systems. The advantage is that you can access them from anywhere. As long as you have an internet connection, whether on your phone or on your laptop, you can be able to access them. Then the difference is that with CAS, we are only able to capture metadata. That's why you see wherever CAS has been installed, we still have the manual registers running alongside the physical files. But when we introduce IKIMIS, we cease having the manual register, we also cease having the physical file. So the basis of all the statistics that we generate after introduction of IKIMIS are actually based on what we have in the system. Whatever has been put on the manual file has to be digitized and go into the system, so that we look at only one source of data. Because when we are carrying out census, we actually realize that these three sources of data are always contradicting. When you look at the manual register, it is giving you different cases. You go to CAS, you are finding a different number of cases. You go to count the physical files, they are also presenting you a different figure. So at the end of the day, you keep asking yourselves, which ones can we depend on? Is it the pending that is generated from the physical files that we have, or the pending that we captured in the manual register, or the pending that we have in CAS? So the intention of usually carrying out these exercises is to ensure that we harmonize these three systems so that they are able to speak to each other, and we only have one source of information that we can be able to rely on. But now that is actually being resolved by IKIMIS, because where we have IKIMIS, if we are able to generate that report instantly, we do not expect you to run a manual register, because we know the register is now electronic on the system. At any time of the day, we can log in and know how many cases are pending at your station, how many of those cases are backlogged, without even inquiring from whether you've captured some cases in the manual register. So that's a brief comparison about the two systems. A slight illustration of those two systems. That's how IKIMIS looks like. I'm going to be just giving a slight demonstration of the system. We said all documents that were originally being filed on the physical file and now have to be captured within IKIMIS. So there is a card that captures each and every document. There is a card for pleadings, a card for court fees, notices, affidavits. So they are categorized in each of those cards. At the end of the day, we are able to merge all those documents and come up with one PDF file that shows us the actual file that has been generated from that system. So whatever we do there has to be done electronically. Whether you are delivering a judgment, it has to be done on the system. The slight illustration of CAS, like we said, CAS is basically capturing metadata about the case file. So what we actually capture here are the names of the parties, the filing date, the judicial officer hearing this case, the case stage. We do not capture the attachments to this file. So we have two systems that we actually have to depend on. Since we only capture metadata within CAS, as per those fields that we've indicated, we are unable to store the documents that are on the physical files. That's why you keep working within that DUA environment. You have to refer to the physical file, and at the same time you have to refer to CAS. If you are updating the physical file or your register, you also have to update CAS. So if you have completed 10 cases and you've indicated them in your register, the same has to be done in CAS, so that we enable the two systems be able to communicate the same statistics. The other system that we had talked about is the one of the summary statistics, the one that is used at the Register of Magistrates Affairs. You do not actually have an interface with this system, but the statistics that usually Register of Magistrates Affairs asks for are actually posted in this system. So at the end of the day, we are able to know the number of cases that are brought forward, the number of cases that have been registered in your court, the number of completed cases, plus their modes of completion, whether it has been completed through mediation, judgment delivered, ruling delivered, dismissed, weeding out. All those modes of completion are able to be posted in this system. So this is at the Register of Magistrates Affairs, and we have a team there of data entries. Whatever manual submissions that you make in those returns, where we usually emphasize you sign against them, because sometimes you deny that they are not your statistics. So they encourage you to sign against them before submitting them. If they are not signed, they are usually referred back to you. And I think on most occasions you receive calls from the Registrar of Magistrates Affairs telling you you've not submitted or you've not signed against those statistics, because they want you to own up those statistics before we can actually capture them in this system. So that is the system that helps us to capture those manual statistics that you submit. Now, we are still faced with a challenge. Much as we are going digital, we are moving step by step, and as far as the coverage of these systems is concerned, we have a total of 273 courts across the country. So EKIMIS is only spread in 36 courts. Meanwhile, wherever we deploy EKIMIS, we have to close down CAS so that you entirely rely on EKIMIS. So that is about 13.23% of all the courts that we have to deploy to. We are given a target of rolling out to at least 5 to 6 courts each quarter. So this quarter that is ending this month, we are concluding the rollout in Chiboga High Court and the High Court Circuit and the courts underneath Chiboga High Court Circuit. So we expect that number to grow up to 42 courts because there are 6 court stations that we are targeting under Chiboga. Then for CAS, we've so far rolled out to 115 courts. They are also given a target of 5 courts per quarter. But next year, we are going to expand the rollout to be able to reach all the other courts. Out of those 115, our target is to make sure that by next year, we have reached all the courts, the 115 courts that are still remaining for CAS. So far, we have a percentage of 41.9% that we have covered in as far as CAS deployment is concerned. But our intention is to have it rolled out to all courts because we cannot onboard some of these court stations on EKIMIS before they actually run CAS. So the first step is to onboard them onto CAS. Then we migrate their metadata from CAS to EKIMIS because EKIMIS does not allow you to backdate those cases. So if you want to capture them or register them as if they are being registered today, it will capture today's date. That's why we have to enter them in CAS. If we need to backdate them and show that they were captured, were registered maybe in 2020 or 2019, we should do it in CAS so that we migrate them with those original dates at which they were registered. Now, there are 122 courts that have no information system deployed there. And the reasons are very obvious. One, they either don't have internet or they don't have even staff to run these systems. So we are still faced with the challenge of having staff deployed in these court stations. Recently, when we went to Chiboga, we reached Bukomero. The chief magistrate, the magistrate who circuits there, moves with their clerk from Chiboga to go and circuit in Bukomero. So if you are to deploy a system there, there needs to be a staff to man the system. You cannot just take the computer there, install EKIMIS and tell them EKIMIS is now running without a staff. So we have to get back to administration and report we don't have staff in this court station. Much as you want us to deploy a system there, we need a person to man this system and even assist litigants to file their documents. So those are some of the challenges that we are facing. The same applies to Ntwete Grade 1 Magistrates Court. The magistrate who circuits there moves from Chankwanzi with their clerk and they go there. They circuit there for 2 days. And there is no staff that is permanently deployed there. So when you look at some of those challenges, after making our needs assessment, we also come back and report to administration and say, much as you want us to deploy the systems there, we are ready to deploy, we have the computers, we are bringing the internet, but who is going to be supporting these tools that we are putting in place? There is no staff that is permanently deployed there. So we have to deal with HR to make sure that they provide us support staff that can be able to run the system, even in the absence of the magistrate, much as they are actually circuiting there for only 1 or 2 days in a week. So those are some of the challenges that are restricting us. But that's how far we've spread out the CAS and EKIMIS in those 273 courts. Now, what are some of the key features of these systems? One, like we said, it is web-based. You can access it from anywhere. It has a centralized database. Even if you are in Masaka, you enter your data. At headquarters, the chief registrar can be able to log in and access your reports of pending cases, your reports of completed cases without actually consulting you. So it is also role-based. Each one of us logs in with the permissions that are attached to their account. So the clerks are at times restricted in terms of the permissions and the actions that they have to perform in this system. You at times tell them to perform certain functions, but due to restrictions that they have in their permissions, they cannot do them. And it is even very worse in EKIMIS because it's very restrictive. If your role is not to allocate a registrar or magistrate on a particular file, you cannot do that as a clerk. But at times you instruct the clerks to do that work for you, yet they are restricted in terms of the roles that they have to perform in as far as the system is configured. So some of these roles are restricted and left to you alone, unless you give them your account and tell them, use my username and password, which has those permissions. That won't be done by the clerks in as far as IKIMIS is concerned. Then there are also reports that you can be able to generate out of the system. There is a dashboard that shows us quite a number of features. We shall be briefly looking at that. Among the key modules of these systems, we have e-filing, which is in IKIMIS. The case registration in CAS is done by our clerks. So as far as the permissions are configured for the clerks and the registry staff, they can be able to file these cases in CAS. But when we cross over to IKIMIS, that role now moves to the litigants and their lawyers. They are the only ones who are permitted to e-file these cases in IKIMIS. Then e-payments, that is for IKIMIS alone. You can be able to pay online. Case maintenance and updating this data, changing the case position from registered to allocated to under hearing to judgment delivered. Those are also modules that allow us to do this work within the system. And still I emphasize the permissions to do some of those actions are restricted to you, the judicial officer. Unless you officially write and tell us, grant my clerk the permissions to do whatever they want on the system, so that you become accountable for that. If they decide to close your cases today, much as you've not completed them, so that you get a higher number of completions, that's what we shall generate from the system. And the person who will be responsible will be the clerk that did that. And these are issues that usually happen in the systems that at the end of the day, some of you have been calling us back and telling us, retrieve all our rights from the clerks, after seeing that they are actually closing cases that are still ongoing. So these are issues that usually happen in the live environment, and we keep restricting the permissions that we grant them. Even uploading judgments, because for those that are on IKIMIS, when you upload, the name that will be indicated will be the clerk. Then outside there, the lawyers will post and say, the clerks are now delivering the judgments on behalf of the judicial officers. So that's why we end up restricting on some of the actions that are happening, because the system captures the name of the person who has performed that action. And later on, we might be having these things going on social media indicating that nowadays, it's the clerks doing what? Delivering judgments and rulings on your behalf. But these are restrictions that we are putting in the system. We have other modules like the reports that are generated. Those are statistical reports. We shall be having a sample of them. Then for IKIMIS, at least we've managed to put an e-archive. When you complete a case, you can be able to archive it digitally within the system. You don't have to move it to a physical archive. So those are some of the modules that we have in the system. Now, we are looking at some of the different categories of users that we have in the system. Initially, when we were beginning these systems, judicial officers used to tell us they do not have any role in the system, and they would refer to this as clerical work. But as far as the systems are concerned, you actually have a role to play in these systems, because these are your statistics. They actually portray the report of what you've done in that particular court in that particular year. In the beginning, it might look very lousy that you are not interested in what comes out of the system, but at times, Judicial Service Commission requests for some of these reports in the court stations where you are once deployed. You are saying you completed a case there, you even have a judgment for it, but when we look in the system, that case indicates another judicial officer who completed it. So we start doubting what is actually happening in the system vis-a-vis what we are presenting. There are others that were completed in the system and are not even indicating the judicial officer that completed the system, because those updates were not done on the system. So you as judicial officers have a role to play on this system. You have to allocate cases in the system so that they don't remain unallocated within the system, so that they are not completed without any judicial officer who completed them. Then you have a role of supervising all your staff. Actually, you as judicial officers, we give you global permissions in as far as watching what happens in your courts is concerned. You have permissions to view all the files that are in your court and at what stage they are, what action is being done on these files. So that is a supervisory role that we cannot take away from you. If your staff are not doing the updates, you can be able to generate these reports, make an assessment, summon your staff, and put them to task to make these updates promptly. Then the clerical staff, in terms of CAS, they are required to register these cases and perform updates as well as generate reports in the system. So they have those permissions. Then we have our ICT technical staff. I know at some of those stations, some of them have been complaining to me that you actually tell them the work of updating the system belongs to them. But at the end of the day, they don't sit with you in court. You sit with your clerk. You know what has transpired in the court. You are the ones who minute those details on the file. But now you expect a system administrator who has not sat with you in court to be able to update what you've minuted on the file. Some of your handwritings are like for doctors. They cannot even read them. And you hand over these files to them and tell them, do the updates there. So they also struggle doing this work. So we actually request you that if there are any updates that have to be done in this system, since you go to court with your clerk, employ your clerk to be able to update. That's why we invite them and train them on what they are supposed to do in the system. So that when you come out of court, they know what has transpired in court. They have even knowledge about it. They can go and update this information in the system. So our IT staff are mainly meant to train the staff and provide technical support in ensuring that the system is running 24/7, so that we do not have any downtime or interruptions that could affect the system performance or the usage of the system. Under the system process flow, we have quite a number of steps. Each of these systems, you are required to have access. Access, by the word access, I mean a username and password that grants you entry into the system. So you must have a username and password as long as you are a user to this system. Then you can be able to access the dashboards. Each one of us, as long as you have permissions to log into this system, you can be able to access the dashboard. Then you have the case registration module, which allows us to register the cases. That's why at the end of the month, we are able to ask you to give us the statistics on how many cases have been registered in some of your courts. These statistics are used for various functions. One of them, they want to find out whether these courts that are being opened here and there are actually doing any work, or there is actually any workload. You could find that in a week they register only one case, and the judicial officer has to travel with their clerk from the other court station to go to another just to hear that one case that has been registered in that court. So recently they were saying, but did we really think through why we were opening some of these courts? Or we need to actually close some of them because we are spending more than the returns that we seem to be getting from there. They can actually, these litigants who are filing one case can be directed to come and file them at those courts where you are sitting. So there are statistics that we generate from these systems and give us an idea of what is happening so that we can be able to make informed decisions. So we have a module on case maintenance and update. Then we also have the user management, which helps us to grant permissions or deny permissions. Then lastly, we are able to generate the reports from the system. So that's the process flow that usually happens in the system. Next, I'm going to have a brief illustrations of the dashboards that we are extracting from the system, because they enable us to have a bigger picture of what is actually stored in our systems. Now, these are dashboards that usually that are within our systems. It is the welcome page that you receive in your system when you log in. It is able to show you the distribution of all the total workload that you have at your station per judicial officer. So it allows you to know whether there are some judicial officers that retired that still have cases in your court, others who are deceased that have cases in your court, because these are actual facts that we've been finding on ground. They actually exist. You open a system and you are shocked to see a judicial officer who retired 10 years ago still having cases in the system. All those that have even died, they are having cases that are pending before them in the system. So at times these statistics are so ashaming, especially if I display some of them here. Then the one for IKIMIS shows us the name and the pending number of cases. So that's how it looks like. We are going to have a detailed view of that. Then among the channels of support, I know we've been interacting with some of you in your stations. There are some of you who have accepted to use these systems even without waiting for us to do the official deployment in your court stations. So just in case you need support in as far as using IT is concerned, there are those two toll-free lines. We have a dedicated call center for supporting IKIMIS and any IT issues relating to systems. So that is those are the two toll-free lines. Those are the email addresses that you can use. You post something there, there is a back-end team that addresses whatever question you've raised in as far as the system is concerned. Then the ICT department is also responsible for providing you computer resources where you need computers, internet, laptops, all those are provided by ICT, plus the trainings in as far as using these systems is concerned. Briefly, that's what I can talk about these systems. So I just want us to have a practical view of these systems before we can actually close this session, because there are certain pertinent issues I wanted to raise in this forum so that we can have something to work on at least when this conference ends, especially in our courts. Some of them have come out as audit queries. Interestingly, this month someone sent me and told me, but we are no longer seeing mediation cases that are completed on IKIMI SOCAS. What is happening? We are investing a lot of money in ADR, but where are the cases? We are not seeing the performance. And it was one of the auditors raising it. So I also went in the system and tried to generate, but I would see there are very few that are actually capturing these cases. Interestingly, some of them that have court-accredited mediators, you don't even have them on your dashboard allocated any case. So it becomes very hard for us to also defend some of those queries when they have generated the information in the system. The reports are indicating they're actually in your court. You have court-accredited mediators. They came and interviewed them, but when they generate the statistics, they appear nowhere, and they are being paid on a monthly basis for whatever mediation causes they are completing. So these are issues that are happening in our courts that we need to address here. Then the other big challenge that we noted here was the issue of unallocated cases, which was also raised by the auditors, that there are quite a number of unallocated. A case is registered, it spends over 6 months not having an allocation happening to it. So there are very many. Some of you have more than 4,000 cases, interesting, in the system, unallocated. So these are issues that we need to deal with, and I want us to just have a brief overview of some of these issues. We are going to see some of these reports. Can you please project the reports? Now, I try to sample some of these cases. When I go to these systems, I just try to get to these dashboards. And now you as a judicial officer, you are required to have a password and a username that enables you log into the system. Like I said, these systems are web-based. You can log in from anywhere and be able to access this data that is stored. Then you know how your staff are doing at the court, even how you are performing at the court, before your supervisor logs in to check what you are submitting here. When you submit at Register of Magistrates Affairs, and you know you are among those courts that are on CAS, we at times go there to see what you've actually done within the system compared with what you've submission, especially if the figures are very high and you've hit a high rate of completion. Then we also ask ourselves, what magic has happened this time round? If you have been known for being a non-performer and we just realize all of a sudden the figure shoots up there, we go and inquire within the system, what happened? Did you just close administratively? Did you just dismiss that month? Did you just do a weed out? So we have to put a reason to that performance and justify why that performance has happened the way it is in the system and in our report. So now this is a dashboard for Masaka High Court. When you look at the Masaka CM Court, when you look at the unallocated cases, they take the biggest part of the graph, 1,962 cases, not allocated. So they are there lying in the system. And when the auditors are asking me questions, at times I'll be required to come back to you and also ask you for a response so that I respond to these queries. Because they think the problem is with me who has done the system, but now there is an actual use of the system that is meant to work on these issues. Then you can see worship who? Yeites Charles, I think retired some time back, 404 cases pending before them. Yeah. So we are seeing these things happening. Her worship Mvanungi Sylvia, 114 cases pending before her. So this is the dashboard, and these are the reports that now we are able to generate from the system. When we call for this data in the system, this is what is able to give us. So when we generate some of these statistics, that's why you see at times we make several calls to you, please give us your statistics, because we are also shy about presenting such statistics. When you just look at them on the face of it, it just really ashames you. Otherwise, if we are to take this report as it is, the first queries will be, but some of these judicial officers retired. So I think we need to go back and work on some of these reports that we are having in the system. Then the other issue that we noted was in as far as unallocated cases are concerned, I tried to generate some of them. And I put comments on them. This number is not so alarming, but we can still work on it. This is for Gulu Chief Magistrates Court. We have 28 cases not allocated. Chitugum High Court, sorry, Chitugum CM Court, we have 223 cases not allocated. So it's ideally showing that allocations are not happening in these systems. Some of these cases, when you go back and dig deeper, you find that they were even completed, but they are still appearing here at that stage of pending allocation to a judicial officer. So we have to reconcile what we have in our manual system against what we have in these statistics. This is for Masindi High Court. We see Justice Issa he left Masindi High Court, I think, some time back. He has 65 cases pending before him. Tororo CM, we have 92 cases unallocated. Now, when you look at these dashboards, they're actually not showing you any mediator, but some of these courts have mediators doing a lot of work there. And we are funding them. Every month they have to be paid for the work they are doing. And they are asking us for statistics. What is the impact of mediation and ADR on reducing backlog? But we are not able to generate that. Even when we call for it, you are not able to provide it to us. You are saying the mediation is as if it's on its own, managing a small entity there, but when they come to ask for the statistics, now they are asking us to respond to some of these things, because they are now trying to generate this information from the system, and they can't get it. So we are not having any mediators here. I think it's only Mbale where I saw some mediators appearing on that list. So on Mbale, let me just look at the dashboard of Mbale. So when you look at Mbale, they actually show you some of the mediators here and the cases that are allocated to them. So their dashboard shows you the names of the mediators by their names and the cases that are pending before them. When I go through the other dashboards of your courts, I am unable to find some of this information. That means there are mediators doing work there, but we are unable to generate the statistics of what they are doing in your courts, because you are not capturing those statistics in the system. So, but at the end of the day, we have to pay them based on the statistics. You've completed so many, you've worked on so many mediation causes, so you are supposed to be paid like this. And there's a lot of investment that is going in ADR, but we can't produce the results from the systems of what they are doing. So here I am encouraging you that at least wherever we have these systems working, let's make sure we do updates on these systems. Let's make sure that we do the allocation of cases in these systems. Let's try to clean out the dashboards or the cases that we have in. If the deceased person is on your dashboard, please get inside and make sure you deal with those statistics. You are in charge of that court as the supervisor of your staff, because if you don't instruct your supervisors to do work, they will sit back and relax. So basically, that's what I had to present about these systems. But as I conclude, I have only one slide that I usually provide to my participants, especially in this age of the fourth industrial revolution of ICT. I know we are in the age of AI and so many things are happening, and they are happening very fast. So there are certain important tools that I thought we can be able to share together so that they can help you in as far as doing your work is concerned. There are quite a number, but I tried to pick out a few that I thought would be necessary for you in terms of doing your work. Amongst them, for court recording and transcription, we have taboscribe.ai. For PowerPoint presentations, you just put in the topic of what you want to present. It generates for you the PowerPoint, and then you are able to edit and put in whatever you want, including the design and everything. So these tools are available to you. If you want to do research, there's DeepSeek, which is for the Chinese. It also gives you a lot of information, not restrictive. There is also Gemini, which is for Google. You can do research there. If you want to get positive results, you can use all those four and compare whatever they are giving you on the same question. So you can get general results on a particular topic that you are researching on. Some of these tools, interestingly, if you give it the facts and the issues, it's able to generate for you a judgment. Then you think through it, using the human reasoning, but at least it would have based on those parameters that you've given it, so that it can be able to give you a draft judgment that you can think through, reflect on what happened in court, read through, amend, and in one day you will be ready with your judgment, or even just 10 minutes. So AI is going as far as it picks some of this information from precedents that are on URI. So you ask it to show you the reference, or you tell it, go to URI and give me precedents that are related to this case. It will give you those reference of those cases, because now it is able to link up with URI. So these tools can be able to assist you. Then for those of you who have handwritten notes, there is pen2print.com, which allows you to convert. You scan the document. Your handwriting should be a little bit good, not like the one of doctors. If it is very poor, the system will also generate whatever rubbish you've given it and return it to you. So it can convert your written notes or court proceedings into typed proceedings. Then you don't have to waste time typing. Some of us, our speeds are very slow. We cannot be able to type most of these proceedings, which also delays us in terms of delivering judgments. Then we have Fathom.ai, which allows us to capture minutes. It is integrated with Google Meet, and it is also integrated with Zoom. When you put it there, it records the entire meeting as it happened. For only online meetings, after recording, just in 1 minute, it sends you the results or the minutes of that meeting on your email. So you just download, get the actionable matters, and you'll be done. So these tools are already in use. Most people are using them, but some of us are not aware that the AI is going as far as this. So everything that is becoming a problem to us, there's at least a solution that can allow us move one or two steps ahead of the other, so that we save on that time. Your worships and dear participants, I thank you for listening to me, and I end my presentation here.
Thank you so much, Mr. Sinabulia. Good morning once again to your worships, those who have just got in the room. This is Mr. Sinabulia Joseph, who has just made a presentation on ICMIS. Your worships, I wanted to interest you in getting interested in handling ICMIS. One thing I know is that we cannot avoid going to all courts. We should all be there at one moment. So we can't avoid, if you say, I will never go to Buganda Road, I'll never go to Mengo, or you'll stay in Buyikwe like me, where I have no CAS, no ICMIS. It's not possible. At some point, you'll have to move. So the earlier we start it, the better. Your worships, I want to also remind you that on your desks, there are those very beautiful purple placards in purple, yes, paper. You could use that to send in your questions. For those of you that don't want to use the microphone, please, we are still ready to receive the questions. But at the moment, let's take on the questions. I think we'll have a few questions for Mr. Sinabulia. And I'll start with His Worship, Alan Gachalo.
Thank you, moderator. Thank you, Mr. Sinabulia, for that indicative presentation. Let me start from the unallocated cases. For us who are on ICMIS, but I can talk about Nakawa. I also tried to discover why I have unallocated cases so that I try and allocate them. The challenge I discovered was that when you are migrating the CAS information to ICMIS, remember there must be a physical file, so that I see a physical file and I allocate it to another person. You migrated cases which are non-existent. So I don't know whether we shall get time and go under CAS and weed out those cases which have no files, so that we can, because I fear to close a file administratively, yet I don't know whether it exists or it doesn't exist. So that's why we find we have unallocated cases. Then on mediators, I think there is a challenge with ICMIS dashboard, because we allocate them, but you find the dashboard does not reflect. So I think we need to sit down and with the IT people and see. Then another challenge, which also causes mediation not to be reflected into the system. Originally, before the rules were amended, the lawyers would file cases with mediation summaries. So it would be easy for the system to register a case and a mediation file. Now, every day I have to go under the pleadings which are filed. I print out. I again go to the filing myself. You find every day I'm the one registering. So you are a judicial officer. You are a registration officer. So I think we need to look for a way of how mediation files are registered by the parties other than court itself.
Thank you so much, Your Worship. I think let us take some more questions, and please be brief with your question.
The last question which I need to make. This one is under the exhibit card. I've discovered most of the cases, because the major problem is the cases which you migrated from CAS. Those ones which you migrated from CAS, when I try on my own scan and scan these files and put them into the system to complete it, so that when I'm at home I don't carry the physical files. The challenge is that those files reject the exhibit card, reject the exhibits to be scanned and kept there. So I don't know where the challenge emanates from. That's my
Thank you,
challenge.
Alan. Your Worship, Alule from Gulu, please. Let's have the second question. Alan has given us 3 questions.
Yes, mine is a quick one, just one only. Statistics you showed, like for example, Masaka, where some retired magistrates still have pending cases. I recall we did cost census recently, and with the help of the staff from system administrators, we cleared all these systems. How come they're still reflected? Are they not? Does it mean we did no job at the close of the census? Because all the systems were cleared. That was the purpose. But still, you are showing us all data, I think. Thank you.
Thank you so much, Your Worship, Alule. Can we have your question, please?
Thank you so much for the presentation. I wanted to inquire, how far have you gone with the reconciliation of those figures? We have challenges where, for example, you observed sometime plea bargain, 1 out of 5 wants to plead guilty, and the 4 are still there. The judge who is concluding it wants the system to acknowledge that it is a closed file, but the rest are still pending. And also, when you want to close, for example, applications, the system will give you too many options: ruling delivered, application granted, application denied. So it depends on your mood to know which one to click on, and yet it should have been one, because the result of a ruling delivered can be either rejected or denied. Thank you.
Thank you, Your Worship. You see, we have so many questions. I'll take a question from His Worship Ntalo from the High Court of Mukono.
Thank you very much, moderator.
And that will be the last, so that he responds, then we get the next batch of questions.
Ntalo Nasulu Hussein is my name, the Deputy Registrar from Mukono High Court. Thank you, you brought ICMIS to Mukono, but we have had some challenges. One, there are some buttons where matters have been referred to the judges, but the judges have not acted on them. However, all those things are still unattended to by the judges. And when we had a meeting with you, I think the judges said that you should give all these rights to registrars. Indeed, we got, by last week, I got over 700 notifications, of which we are supposed to handle the cases before Justice Mobiru and Justice Barebe. For example, me. It has become a problem that when you are working on some of them, you find that we don't have the rights, and the matters, we cannot conclude such admissions and handling like assigning their pleadings, which the judges have not done. How should we go about with that one? And also, our system, I think the routers you gave us for Airtel, are so slow in Mukono. You find yourself the whole day you are seated and you cannot do anything. It looks awkward that you must wake up at night to do the work. Can you please rectify the same?
Thank you for the question.
Maybe the last one, where there are some cases which are concluded and people come to receive orders, for example, letters of administration to satisfy them. But you find that for us and orders which were handled by the judges who were there, whenever we try, even if they have uploaded that on the system, we have failed to sign them because we don't have the rights. How do we go about with that? Thank you very much.
Let him take 4 minutes to respond to these questions before we open for the next batch of questions. I've kept 2 hands the other side.
Thank you very much, Your Worships, for these questions. I think let me begin from the last one. Your Worship, in terms of the rights that we grant you as a registrar, at least from the time of developing ICMIS, it was agreed that a registrar should have global rights and view whatever is happening in their court. Because like they are the full administrators of that court. They are able to look at all these files and they are actually supposed to have all rights on these files. So your name, if your name is indicated as a registrar on that file, you are supposed to have those permissions. If those files that were old or previously put onto the system still have the names of the previous registrars that were at that station, then you will be denied right because your name does not appear on that file as the registrar in charge to be able to act on that file. But Your Worship, today morning I sent someone to your court, to Mukono actually, on the invite of Justice Valeve. So he's going to attend to most of those issues. He's having a meeting with your staff today morning on the same. Then in terms of on the issue of the routers, we have started replacing those routers. You return the Airtel router that we gave you and we replace it with the MTN router. If they are not functioning, we have done it for some in Mengo, some in your station. I've only done it for Justice Valeve. I haven't done it for the other judges. But we shall have to replace all those that are not working because we know it depends on the network. If the Airtel has a poor signal there, then there is nothing we can do about it unless changing to another service provider. So we shall do that. I think the actions will also be dealt with in terms of signing the pleadings that come on that file. That is a technical issue that we have to deal with on our side in terms of who is allocated that file, who is assigned that file. Then the other question was coming from DR Mobende regarding reconciliation on pre-bargaining matters. Yes, this is an issue that came out from most of the meetings that we've been having with High Court. There is a small data management committee that was formed under criminal division to be able to address all the issues that are surrounding pre-bargain. So we are reflecting on creating a case category called pre-bargain. If it's a session file and one of the accused accepts to go for pre-bargain out of the 4, then we shall create for him a pre-bargain file, capture all their details there, and then we shall be able to register that as a return under the case category of pre-bargain. The way we did it for mediation, we created a mediation cause. So much as the civil suit file is there, you are supposed to file a mediation cause which is allocated to a mediator. So the same will happen here. If the session file is before someone and one of the accused accepts to go for pre-bargain, we shall create a pre-bargain file so that we also start capturing the pre-bargaining files. These are proposals that went to that committee, so it's going through approvals under criminal division. Then it will be circulated to you for further implementation. Then Masaka. Masaka, yes, we had a census across the country in all those courts. Now, what happened in the court during the court census, most of the work was not done on the system because I think the system slowed down due to the traffic that was coming in, and the proposal was taken at that time to abandon the system and do the Excel sheet. So most of the statistics that you presented in the court census was done on that Excel form that had been provided to you. Now you had to go back to the Excel from the Excel form to update what is on the system, because now the work is still there. Actually, today morning I was asking the system administrator, what is happening? This thing has been here for years. I already see Worship Yaitesi here, who retired long time with this number. They are not reducing Each and every month we find them there. No action is being. Then he told me it is only the system administrator doing or working on these files. So, Your Worship, I would advise you, bring all your clerks together, assign them work to work with the system. The system administrator alone is not going to deal with this work and complete it. If you want results, the clerks should be involved. They are historicals. They have been there at the station for some time. They actually know the positions of these files off their heads. When you start asking them, they will be giving you the positions there and then. And you'll be acting quickly. But now a system administrator who does not sit with you in court, he has to struggle reading through the file. He looks for the result. He can't find it. He abandons that one there. So I think the clerks need to be involved in order to address that issue. Then the other questions were coming from His Worship Alan Gachalo. Migration of the cases. Yes, the cases were, we usually have issues with the data that is migrated from CAS, much as we do some data cleaning. The interesting thing about it is that we count the files and we seek your guidance when you are, unfortunately that time it was not you there at the station, it was His Worship who? This one in Chivoga, the CM in Chivoga. His Worship Kakoza was the one there. So the team that we sent to do the data cleaning there combed through the files. We harmonize the physical against what is on CAS. Then we present to you a report and tell you we are not seeing these files. What should we do? You do some further investigation in your archives. If you find them, we are able to reconcile that list and reduce the number. If the number of files remains, we still bring it to your attention and tell you, this is the report of the files that we've not seen. What should we do about it? So that time it was His Worship Kakoza who was there. And if those files were migrated without the physical files, now they either gave us information that these files were among some of the judicial officers that had left the station, because some of you carry some of these files when you leave the station. And when you ask the clerks that worked with you, they said, this one went with worship so-and-so. This one went with worship so that's why they are there. So we have to find out where these files are, but at least we usually struggle to make sure that we leave only active files migrated to IKIMIS. They should be somewhere. In terms of the mediators, I think the dashboard I've indicated the one of Commercial Court is also able to show us in IKIMIS all the mediators that they allocate cases on IKIMIS. I've also indicated the one of Mbale. If their names are appearing there under the list of the judicial officers and you allocate them on the system, automatically the system has to extract this data and give it to you. Then on the issue, the last issue was on the exhibits. Yes, the exhibits, the system can allow you to capture only documentary exhibits. So you take a picture of that exhibit and then upload it on the system. Then you capture information of where the physical exhibit is stored, who received it, and the time you received it and the date. So that's how we capture those exhibits. But the card should be able to allow you to capture those exhibits because the permissions are actually with the court staff, not the external participants. Thank you very much.
So thank you so much for the first batch of the questions. I wanted to add, I am part of the team that is training staff and judicial officers in small claims, but we've also received a number of complaints in CAS, and IKMIS. One of the complaints that they usually give us is that they cannot enter a consent. If parties consent in a small claims matter, it's not easy for them to enter a consent. They only have two options of withdrawal, no feedback, and filing a small claim. If parties reconcile, what happens in the IKMIS system? Staff are ending up entering results of no feedback, and yet there is actually money being paid. So we are going to have funny results or returns showing that small claims is doing nothing, yet it's actually doing something. The other thing is that the litigants also complain that they do not get notifications when summons are signed by the judicial officers in small claims. Together with that, can I receive the questions from the end, Your Worship? Can we start with Your Worship, Conrad, please?
Thank you. Thank you very much. And thank you, the system manager for IKIMIS. I think IKIMIS has come very timely for especially the court where you're working. But one challenge appears to be very perpetual. and we've generated issues and raised it with our system admin and to your officers. Once a person appears before your court for plea taking and bail is denied, there is that forward step for bail denied. And the system, I think it has been designed that once you deny bail, it captures that the file has been concluded. So you hear the matter, write judgments, upload on the judgment card, and any attempt to close, you cannot close. So the file remain pending when you've already done your work, convicted and sentenced or acquitted, and that remains still counting on your workload pending. I don't know how best you can rectify that, because I think it is over a year that we'll fail to get solutions. Thank you.
Thank you, Your Worship. Can we receive the question from the back? Somebody had raised the hand from the back. Yes, Your Worship, go ahead, please. You have a mic? Cornelius, try to hurry, please.
Thank you. Thank you very.
Your Worship, go ahead. May we know your name, please? It's working.
Thank you very much, Your Worship. My name is Gonzaga Mbalango from Rukunji Chief Magistrates Court. Thank you, Mr. Sinabulia. The challenge we have this mediation, when you look at the system, specifically CAS, it does not appear at certain stages as Her Worship has indicated. At the time of the suit, you could find it. Then taxation, even if it is mediated, there is no provision for it. So we need to look at the system and see how to correct it. Secondly, and finally, when results are entered in CAS, we are unable to correct them. For example, if a case is concluded as dismissed, I look at the system, I know a judgment was delivered. I do not have the rights to correct it. I have to run to the systems administrator. Is it possible for us as judicial officers to be able to correct our data? Thank you.
Thank you so much, Your Worship. I think we shall give Mr. Sinabulia. Yes, I have one last burning question. Please, 30 seconds. Your Worship, or Polot, 30 seconds, please.
Olupot.
Olupot,
Olu
sorry.
and a pot.
Apologies.
Yes, my name is Pascal Olupot from Kajians CM Court. One of the challenges are amendment of names of accused persons whose names, let's say, are misspelled at police. An example is the person comes for plea taking, you do mention to them their names and their details, and they say that is not my name. Let me just give a classic example. There was someone who was called Luaga, but the police called him Ruanga. And we had two people with almost the same name. There was actually a real, let's say, Ruanga Robert existed on CAS. And then this person is called Luaga. Now the question is, how do you ensure that though it was captured as Ruanga on CAS, and he has corrected his name, he's telling you that that's not my name. How do you then capture it and correct it or amend it to Luaga on the system? Because you actually, on the system, you actually had a different person called Ruanga Robert. Thank you.
Thank you, Your Worship. I think let's give Mr. Sinabulia a chance to respond to your questions.
Thank you very much, Your Worships, for these questions. Let me begin with the first one, which was relating to small claims on IKIMIS. The actions that we expect to perform on IKIMIS, especially if they are closing a file or completing a file on IKIMIS, are granted to a judicial officer. So the clerk there won't go there and find the consent judgment delivered, because we were advised to restrict the permissions that we give to clerks in as far as closing files is concerned, because they were misusing them. Oh, okay. The issue is on the. So is that a consent judgment? So how do you close that one?
Sorry, what I was trying to explain to Mr. Sinabulia is that in small claims, there is a first stage of demand notice level, which ordinarily in a civil matter would happen in the lawyer's chambers, unlike the ordinary level of plaint and defense. So at demand notice level, people can still pay each other, and we expect returns in case people have paid each other in a small claims matter. We expect returns that at demand notice level, we have received this kind of money. Then at small claim level, this is what we've received. But they do not have an option of saying they have paid each other. The reason, we have 3 reasons for closing demand notices. The claimant has been paid, the claim has been filed in court, or there is no feedback. Now, that option of the claimant has been paid is not in the system.
Okay, thank you very much, Your Worship, for that clarification. Now, when we were mapping that process, we were advised to include two results. The case is either settled at demand note level or not settled. Now, the other details of whether they have paid or not, they have to be captured in the details of the decision. But the action that we use for closing, there are 2 options. A demand notice is either settled or not settled. If it is settled, then it cannot turn into a claim. So you cannot actually get a chance to. The system does not redirect you to creating a small claim. But if it is not settled, the moment you click that option of not settled, it will automatically redirect you to create a small claim out of it. So that's how we mapped the system. But we are flexible just in case you have a proposal that needs to be added to amend some of those positions that we included. We are very flexible and we are willing to take in those proposals. Although some of you send us misleading information, especially the clerks, they keep calling and telling you, add this, add this, add this. Then when you meet the judicial officers, they are telling you, who told you to add that? The person who told you was not knowledgeable about it. So we always have those issues. That's why these days we have to take them through the discussion of the committee. We compile a list and then present it to the committee for approval. But we are very flexible to receiving that feedback. Then on the notifications, ICMIS provides you 3 sets of notifications. You either receive a notification or an alert in form of SMS, email, or system notification. With that, you are supposed to have registered with ICMIS. Your phone number should be there, not the phone number of your lawyer. Your phone number, that means you should have an account with ICMIS. That account should be linked to the case in order for you to receive those notifications. So, incidentally, some people have not registered with their actual phone numbers. You find the phone number of the lawyer there and the person is complaining that they are not receiving notifications. Then I accept that in certain instances, especially SMS, on emails we do not go wrong, but SMSs, we go through the SMS server that is provided for by NITAU, the government SMS gateway, that sends out those bulk SMSs. That's where we subscribe. So just in case we have a technical issue with that SMS gateway server that is supposed to propagate those SMSs, we usually face challenges that we cannot be able to propagate those SMSs. And at times we are able to monitor and see them hanging on the system, but we always report to NITAU to help us do what? Address the issues that are happening on their end so that we can be able to resolve those issues. So in that case, just in case you incur some of those issues, you let us know which cases, which parties are complaining about those cases, then we confirm if their phone numbers are pegged to those cases, such that we can be able to identify where the actual issue is emerging from and be able to provide a solution. Then the issue of bail granted and bail denied. This is also something that is under criminal division, the other committee that we talked about. For the lower courts, bail applications are done orally. For the High Court, bail applications have a file called a criminal miscellaneous application. So you open it and you are able to track that the movement of that file from one step to another until bail is granted or denied. For this oral application that you have to do within the other main file, we find it very hard to track it because now when you put Actually, that position that we created was meant to be for the criminal miscellaneous application, not for the criminal offense, where you as a magistrate are granting bail, where you do not create a criminal miscellaneous application. But now that has been brought to our attention, we also have additional information that we actually want to capture about bail. There are so many, whether it is paid or not, how much is paid, which we are not capturing in the system. And Parliament is always demanding for that information because of that money that is hanging on that account for bail. Now they want details at the end of each month. Bail granted, how many? How much has been collected? So that we start tracking the details aspects of the bail that is already applied for and granted in the lower courts. So we are working on also that issue with the magistrates affairs and the criminal division to make sure that we streamline it very well and be able to track it at the lower courts. The mediation process in CAS, yes, there are certain actions that are missing. I can agree with you, because the mapping in CAS, if it's a mediation course, we expect it to carry a particular process and end. Then there is also a process of filing a taxation application, where you will find the issues to deal with taxations. Now that is also expected to be another file with its own case process mapped from beginning to end. But the problem here is you want to do all these actions on one file. And at the end of the day, you tell us you are not capturing our statistics very well. We do so many executions here, where we tell you create execution miscellaneous application. You want to do the execution on the actual civil file. So you don't find those actions there because the mapping of the process is as per the case category. If it's a taxation application, we map it from the beginning to end. If it's a mediation cause, we map it from the beginning to end. But the problem is you want to do some of these actions on the other case files where those actions are not available. So what we have to do is to streamline. If you are doing a taxation, let it be a taxation application. Let's capture it from the beginning to the end. Don't do it under the mediation, because we don't expect the mediator to do taxation there. It is you, the judicial officer. We mapped that process of mediation based on what the mediator is supposed to do, and then the other aspects are done on the other files which are supposed to be done by the judicial office. The rights to delete, I think this was the last one. Deleting, the rights to delete information. Or amending. Yes. Let me begin with IKIMIS. None of us has the right to delete or amend anything on the system. Because of what used to happen in CAS, at the time of developing IKIMIS, even me, the project manager, they said, don't give anyone the rights of deleting. So there are no actions of deleting at the front end. The deleting has to be done at the back end, only if you have access to the database with that password as a super administrator of the system. So if there is any mistake that has been done, this being an e-file, we don't want people to see us or our names appearing on those files that we are the ones deleting this information. CAS is a little bit flexible, that is IKIMIS, so none of us has the permissions. Even me, myself, as a project manager, I don't have them. Whatever you do on that file, let everyone see, because they are receiving notifications. One time a judge told us, help me close all these cases. And our names were appearing there, closing cases. The next day, the lawyers were calling us, who has told you to close my files? So we're telling them, please go back to the other judge and tell her she's the one who gave us the instruction. Good enough, she had written somewhere. So we don't want our names to appear because the system is giving them notifications telling them there is an action happening on your file. It's being done by so and so. So the rights are not available. On CAS, the clerks used to play around with those files. The way the physical files are disappearing and the way the documents are disappearing on the physical file, it is the same way they used to make those files. After making the physical file disappear, they come to the data that is on the system. They make it disappear. Unfortunately, some of you give them your rights. So if we are to give you those permissions now, and we give you the rights to delete or amend, they will be misusing them, deleting even other things that you've not instructed them to do. That's why we centrally manage those rights. Just in case there is an issue of deleting or amending something, you have to post back to us so that we can be able to assist you. At least we note somewhere we have a written communication or officially to allow us to do that. I think those were the questions. Thank you very much.
So thank you so much, Your Worship. The entire presentation tells us that it is within our hands to make IKMIS better and to make the judiciary work or whatever we do better. We should not leave our roles to the clerks. I participated personally in the census, and I went to one of the courts that I will not mention, but inside the chief magistrate's chambers, we found a heap like this of files, and I asked him, Your Worship, what about these files? Because what we were doing, we would ask the chief magistrate or the grade 1 to take out all their files, and then we start entering back into the chambers whatever we have entered. But I found a heap, and they told me, Your Worship, this one is for worship this. Meanwhile, she is the deputy registrar. They were for worship this, but she had been a deputy registrar for a year. When we opened those files, we were in shock to see that some of them just have charge sheets in them. Others have plaints, but somebody had said they were for worship this and they are kept there. So it is our role, Your Worships, to do this work. We should stop blaming clerks. The returns are ours. If the returns are good, we are the ones responsible. If they are bad, we are still responsible. Join me to thank Mr. Sinabulia for the presentation. And Your Worships, please thank the chair for chairing the session. Back to you, Your Worship. I think we are just past 5 minutes. Thank you.
Thank you so much, Your Worship Kagoya Jacqueline and Mr. Sinabulia for the good presentation. Let's give them a big hand of applause as they go back to take their seats. Today we have planned that we will redeem some time so that we can be able to leave earlier than we left yesterday. We were supposed to be going into a break tea, but we are informed that they are still laying the tables. So we have agreed that we have the next presentation in the next 45 minutes, then we go for break tea. So I take the honor and opportunity to invite His Worship Biarugaba Adams, a Principal Magistrate Grade 1, who is going to chair the session, and then he will invite the presenter to take the floor. Your Worship Adams, I welcome you. Thank you. Your Worships, in the morning I talked about something that we saw on one of our forums, where a lady has opened up a prison facility, private one, and she's detaining people. When I saw it, I laughed, and I discovered that when we don't manage our processes very well, people are bound to abuse them. We have done inspections at various courts, and we have seen mediators who are going to internet cafes to print mediation notices, and they have designed their personal stamps to stamp those documents and send them out to the community. I think that is very wrong, because a mediation notice or hearing, it's like a hearing notice, it's a document of court, isn't it? So when we allow people to start doing it from their internet cafes, everyone will know the Chief Magistrate's Court of Hoima. I'm using Hoima as an example. Then they put all the details they need, then someone has procured himself a stamp. Before you know, they're going to come to NASA, and they also get court seals, and they start using them. Mediation documents are all court documents. So as we support the mediators to do their work, let us avail them with the necessary equipments. If a mediator is accredited and you know him as attached to your court, why wouldn't he issue a hearing notice with a court seal? Is that fatal? Your Worships, I think that is a food. We can think about it. Is it fatal for them to use our court seals? They're not judicial officers. So should we be the ones to sign the mediation notices? We can think through and see how best to handle. Otherwise, I have learned that they are going to internet cafes and typing those things. And some of them have even designed stamps that they are using to invite people to come for mediation. I think it is so wrong. Our registry is just growing, like you can see, or evolving. So there are so many things that we need to fix at the beginning. Once we fail to fix them, we shall get off track. So let us think about it and see how best we shall manage it. Your Worship Adams, please take the floor. Thank you very much. I warmly welcome you.
Morning, Your Worships. I take this privilege to chair today's second session. My name is His Worship Adams Biarugaba. I'm a Principal Magistrate, Grade 1, at Natete Rubaga, and Amengo Chief Magistrate Court. I'm going to be your chair for this session, and the presenter today is one of our own. I have seen him around. I kindly request him to step forward so that we can use the 40 minutes or so to have a discussion of today's morning. If you look at our program, the topic under discussion is digital transformation, urging yearly to accelerate case management. I was trying to look at some of the keywords on the topic. They said, well, digital transformation. At least I'm sure all of us in the house have smartphones where we can all confirm to fall under this category. Then how do we leverage? How do you use this digital engine to better our best? How do we use this engine to ease our work that would take us our days, for those of us who studied some years back at universities, of going to law libraries to do the research and all that you can sit on your table and within 20 minutes you have whatever you want. How do we do this? How do we use this engine to accelerate case management? We are looking at effective delivery of judgments in a timely manner. We're also looking at the quality of judgment that speaks to the value of any judicial officer. For whatever we write down is what the public takes us to be. Ladies and gentlemen, today morning we have someone who has been in charge of this engine, who updates us on whatever happens. He needs to take us through how it's done, and I don't want to steal any of his time. Put your hands together to welcome my brother, His Worship Joel Wegoye, Senior Magistrate Grade 1 at Actuary. Thank you so much. Kindly take your floor. You will have 25 minutes of interrupted presentation, then I will guide accordingly.
Good morning, Your Worships. Today's session is going to be brief, but the disclaimer is that a complete yearly training takes longer than 45 minutes. So what is going to happen today, I'm just going to give you snippets of some new features we have added to ease your research as you do your daily work. But basically, I'll first start with a brief about Yuli currently. Yuli currently offers about 5 products, which is court cases, which is our primary product, legislations, gazette, parliamentary Hansards. But we also look at judge decisions that come from the international courts where Uganda is a party, like the IACA. Right now we report IACA cases, East African Community, the African Court of Human and People's Rights, and all other courts within Africa where Uganda is a party. We report all their decisions on the website. Now, a brief about Yuli. Currently, we have about 340,000 users per month from about 40 countries. Now, the most surprising thing that currently Uganda is not our biggest user. It is China. China uses Yuli more than Uganda. And also Europe combined uses Yuli close to how much we use it in Uganda. And before, Kenya used to be the second biggest user of Yuli, but currently Kenya is number 5 or 6 among the users of Yuli. So we go to about 40 countries, but basically it's going to be about going through the website, as you can see. I hope you'll be following. But since time does not allow, I'm going to go to the primary things I think that are very important. First, I'll ask if all of us have accounts on Yuli, personal accounts on Yuli. Yes, now we are very few here who have personal accounts. Opening a personal account on Yuli is free of charge, and it takes about 20 seconds. So what happens is, personally, as you can see, my Yuli account is already active because I managed to, it allows you to open your account. So when you go to Yuli, you sign up using your Gmail account, which will take about 20 seconds to open for you a personal account. It is entirely free of charge. But what's more important is what that personal account can do for you on Yuli. Now, as you can see, if I explore my personal account, you'll realize that I have saved documents. Now, these saved documents within the Yuli account means that I read these decisions and I would want to refer to them in the future. I don't want to go back to Yuli and start searching for the same decision. So within this space, I save the documents I read on a daily basis or the documents I frequently use. So if you have a personal account on Yuli, you can save in your personal documents or personal decisions, personal laws that you frequently refer to. And you can always access them. You don't have to go to the main Yuli website to do the same. Another thing that is very important with this account is following. As you can see, from my personal account, I follow the Supreme Court, Court of Appeal, and the Constitutional Court, which are to me, those are the core courts I want to follow. Which would mean that if a case is uploaded onto the system from any of these courts, I'll automatically get an email alert on my personal email that a case from this court has been uploaded. That means I don't have to be on Yuli to know that the case has been uploaded from the Supreme Court, Court of Appeal, or Constitutional Court. So if you have a personal account on Yuli, you're able to do this. But also, there's what we call search alerts. Now, search alerts, as you can see, the first name on my account is Malema Bidizi. The reason I put his name on my personal account, because I know he has quite a number of cases across the country, but I need to know when a decision concerning Malema Bidizi has been passed in real time, which means any of my colleagues at Yuli, once they upload a decision and I'm not around, I'll get an email alert that a case concerning Malema Bidizi has been uploaded on the Yuli website. So this will help you in a way to be to get to know whatever decision has been passed. If you're following, like the case of, we are all aware that Walukaga filed the case at the Civil Division, and if you want to know that the case of Walukaga has been passed, you just put his name there, and when the decision is uploaded on Yuli, you'll be able to get an email notification that a case concerning this specific person has been uploaded on Yuli. But another advantage of the search alerts is that it goes beyond just telling you that a specific court or a specific decision has been passed. It also helps you do research. What do I mean by this? If I am on the Yuli website and if I go back to my account and I search randomly and I say trespass to land, and then I'm saying search, you realize that it has given me 2,661 results, but you cannot humanly read through all these results. So, and let us assume that whatever I'm looking for is not within these results. What I have to do is to say, get here where the blue icon is. I say get alerts for this search. Then it will open that box and then I'll say save. What this function will do is that when you're outside, when you go and do other work, like sittings, even when you're playing football in the gym, the ULI system will be doing for you research. What will happen is that if among the results you've got, nothing you're looking for, ULI will go ahead and look for research in the database and see that it gets for you other material concerning trespass to land. To demonstrate this, I'll open my email. I will type ULI and I say search. And I'll open one of the ULI emails. This is how it will be. The system of ULI will send all the search results to your email address, which means that even when you're seated here and you need to know something, you just type in the topic and ULI will do research for you. You don't have to be on ULI in real time to actually get the results. The system does research for you. This is what we commonly refer to as AI agents, like artificial humans who are on the system who do for you research and they send the results to your email address. So you don't have to be on ULI physically to do research. Even when you're doing other things, the system can do for you research using this function. Then we shall go to the home page again. Now, it is very important that we can use the general search system and the advanced search system correctly. Most times, most people go for the general search system and they ignore what the advanced search system can do for you. They are all equally important and they can all give you the results you're looking for. But how do we use them? Usually the general search is when you just put randomly and you want the system to search through anything. And if I say land is not vegetables, and I say search because it's a common phrase in excuse. It's a common phrase in land. You see, it will give me generally any case that had said anything and any other thing that contained the word land and vegetables. It will give me cases involving that same phrase. So here you'll find that it will tell you that there are 285 results that speak to this. But specifically, if I open the case of Naomi and I look for the exact phrase of land is not vegetables and I say find, so now after searching for the topic within the general search, and it has given you quite a number of search results, what we can next do is try to search for a phrase. I'm going to put the right to life is the most fundamental of all rights. I am aware about the phrase, but I don't know which case specifically speaks to this phrase here. And I say search. And you realize that it will give me a specific case that actually speaks to this phrase. That means you can do research. You can search through the general search in general about anything, but also you can search for phrases. But this would mean that the specific phrase, you put it in quotation marks when you're searching. Then the system will be able to look for you the specific case you're looking for, or statute or whatever. Now, I'll go to the advanced search system. Now, these are majorly Boolean operators, and what I am going to do is quickly look at the Boolean operators using the case of, I'll say I want a case on land, and I want a case on fraud. And I want a case that, all cases that refer to the case of Frederick Zabwe. Now, if you look at the search results, it is giving me everything, all cases that I've ever quoted Frederick Zabwe, and the case of Frederick Zabwe itself. Now, that is where the advanced search system helps us, because you have to specifically know what you're looking for in terms of the parties or in terms of this topic. But if I say that I want cases on land and fraud, but I don't want anything to do with Frederick Zabwe, what I do, I go to the operators and I say, yes, I want land and fraud, but I don't want anything to do. I say not. Then I say search. Now you realize now it is giving me all cases that deal with land and fraud, but nothing to do with Frederick Zabwe. Now this here you just are narrowing down your search results, but that is it for the general search and advanced search. It's just about practicing, but also then if you look at our homepage as ULI, we, apart from my account, we have recent decisions, recent legislations, and recent gazettes. So without necessarily going through the entire website, you can look for what we upload on a daily basis, and you'll be able to access. And as you can see, I think currently the newest case was uploaded yesterday. That means we're a little bit up to date with what we do at ULI. So, and we try to update the system on a daily basis. Both legislations are there. But also, if you have a personal account on ULI, you can be able to access a case digest. Now, what the ULI system has, it has an AI system that automatically digests cases. It can digest a case of 600 pages within 30 seconds. So this the best example is the Kabaziruka case. When it came out, many people wanted to know what it was about. It was uploaded on ULI, and within 30 seconds, the public had a case digest. That means a case of 600 pages, you could read it in 2 minutes on ULI. So if you have a personal account on ULI, which I highly recommend, you're able to get a case digest. Now, to demonstrate this, I'll look at the case that was uploaded yesterday. The case of Ongo Farm. Ongo Farm Uganda Limited versus Commissioner Land Registration. Now you realize that because I have a personal account on ULI, I can be able to access a full case digest, which is the case summary, the issues, the holding, and the orders of the court. Now here you don't have to read the full decision. You can say, okay, I'll read the full decision, find out if the summary is important to me. But that is the case digest that we provide. And right now, I am sure that more than 50% of all the cases on ULI have been digested. What is stopping the other cases from being digested are because the documents, some of the documents that were uploaded are not machine readable, so the system cannot read the decisions. But we are trying to update the system to make sure that all decisions, all documents on ULI are machine readable, so that we can take the benefit of the AI system on ULI. Now, briefly, I'm going to go through, when you're reading a decision on ULI, what happens is that within the decision, if another law is quoted or another court case is quoted, what happens is that the system interlinks that specific law or that specific court case with that decision. That means when you're reading a decision, you don't have to open another page to look for a law or a decision. I'll go to my ULI account on some of the saved documents to I'll use the case of Kimanyuenda. If you look at this case specifically, you find that it quoted the case of Muyingo versus Lugemwa and 2 others. Now, this specific case, if you look at where I put the cursor, where the yellow mark is, you realize that it brings a highlight of the case of Muyingo, which means that I can get the case of Muyingo not by opening another page and looking for the case of Muyingo, by clicking here. As you can see, this is the case of Kimanyuenda. but the case that is being quoted is the case of Muyingo. So when I click here, the system automatically takes me to the case of Muyingo. But I also have to emphasize this is because the judge who wrote this decision correctly cited the case of Muyingo. What do I mean by correct citation? As we can all recall our research methods. Normally when you leave law school, the thing you forget first are the research methods. They taught us the Oscola system of citation of cases. What do I mean by the Oscola system of citation of cases? For Uganda, each case that is uploaded on ULI has a unique identifier. Like as you can see from the citation of the case of Muyingo, yes, there is civil suit number 24 of 2013. That we all, personally, I'm also guilty of this. This is what you'd want to quote in your decision, that I've read this case, this, and this, civil suit number 24 of 2013, and you stop there. But the unique identifier in this case is this highlighted section, that is blue. Now, that is the unique code for this specific case, and each case has a specific code. UG stands for Uganda, HC High Court, LD stands for Land Division. Now, you won't find the case from Land Division in Civil Division because currently we classify them according to circuits and divisions, and all courts around the country have unique codes. So here, once you quote that code in your judgment, the system on ULI is automatically going to pick it up and interlink it. There is no manual work required for this. But I think this is also irrelevant. I know I'm referring to a High Court decision, but it's also relevant because the discussions on whether or not to include decisions from the lower courts on ULI is happening. Decisions have not yet been made, but the discussions are happening. So it is important that when that time comes, we are doing the right things. But then for legislations, I am going to scroll through. I'm going to use two legislations in the interest of time. I'm going to use the Penal Code Act. Now, as you can see from the Penal Code Act, the document detail will give you the Penal Code as it is, the latest version, but also provides you with the history of the Penal Code Act, whereby you can know that the Penal Code Act from 1950, and you can read it as per the time it was published. Like if you look at the history, it will tell you that it was started in 1950, there was one in 2000, and can give you time to read the version of 2000 if you can see the cursor, where the cursor is. That means you can read the Penal Code as it was then. That is the importance of the history section. We also have related documents and citations. But when I go to the Penal Code Act, on the left-hand corner, on my left hand, which is, I think yes, on your left-hand corner, you realize that it provides for a table of contents. You can expand all and get all the sections within the table of contents, or you can collapse all. The reason we expand all is if you're looking for a specific section, like say claim of right or ignorance of the law, you can click on section 6 and it will automatically take you to that section. You don't have to scroll again down looking for the specific section. You can go in the left-hand corner, look at the table of contents, and you can look for the specific section or chapter under the table of contents. But why did I want to refer to the Penal Code specifically? Recently, there was a revision of our laws 2023. Now, what happened is that within some of the section, and I refer to section 116, on defilement of persons under the age of 18 years old. Now, if you look at the screen, there is a provision on the side of ULI. This specific part tells you what's changed. That means this law has been affected by an amendment or something. What changed? And this is very important because if I click on what changed, it will bring for me this icon on ULI. And this is all on you, and you can access it whether on your computer or your phone. But what's more important is what was the impact of this change? After the revision, before the revision, chief magistrates did not have jurisdiction to handle defilement cases. After the revision of 2023, in the revised editions, the red volumes, they said that the punishment for defilement was life imprisonment. Now, this would bring the offense of defilement under the jurisdiction of the chief magistrate's courts. But shortly after the revision, the government passed a gazette notice. It was a corrigendum saying that there was a drafting error on this specific section of the law, and the punishment should go back to being death. And I am also aware that some people were handling these cases after the revision under the chief magistrate's courts because of this mistake. Now, Yuli is able to give you and tell you that the revision said that it should be life imprisonment for the punishment of defilement. But there was a gazette notice that was passed. And the advantage is that within Yuli, if I close this box, I will tell, and I click on the gazette notice itself, within the penal code, I'm able to get the gazette notice that made these changes. You're able to read the gazette, whereby government was saying the revision, there were some mistakes or there were some omissions that were made, and the correct section should be that as per the gazette. Now you can find all this in Yuli. I'm aware that this gazette notice affected about 16 sections within the Penal Code Act, where they were saying that there were mistakes made. Yes. So that is one of the advantages of that. So I'll go to now on Yuli, we also have the parliamentary Hansards currently. What we don't do is pour all the Hansards as they are from Parliament. If a case discusses a parliamentary Hansard, we get that specific Hansard and attach it to the specific case, so that when you're reading, you have a complete read. You can read the Hansard alongside the specific case or section of the law that is being interpreted. Now, I'll refer to a specific Hansard of, first I'll look at the Hansard of 21st March 2023, and specifically this Hansard was dealing with the Anti-Homosexuality Act. Now, if you look at the Hansard as it is on Yuli, you realize that on the right-hand corner, where I've highlighted, we have attached the act that is being discussed by that Hansard. We have also attached the court decision that discusses the specific section of the law that was the petition was against. So you don't have to go anywhere else. Within this specific section, you can read the Hansard, you can read the law, you can also read the court case. But also, what I should have said is that Yuli now allows you to make personal notes on decisions, on laws, and all other documents that we have on Yuli. What this is that when you're reading a decision on Yuli and you're interested in that specific section of the decision or the law, I'll look at the Penal Code Act again. Now, I've read the Penal Code Act. Now, randomly I say, I comment on it and I say this is a good provision. And I say save. What this will do, as you can see, it has highlighted it to yellow, which means I've made a comment on that specific section of the Act. But it will also take it and save it in my Yuli account, so that even after 2 years when I come back, I can refer to the same comment I made. Now, you can write as many words as you want on a specific section of the law. So this is your research, because you can come back, and as you can see, when I go to my Yuli account, it has saved the penal code because I made a comment on it when I was reading it. So these are the advantages of having a ULI account. But then we also have the international courts, that is the East African Community, East African Court of Justice, the East African Court of Appeal, and the African Court of Human and People's Rights, and all other, the African charters and everything is on ULI. Now, also importantly, you should note that the judiciary has intentionally increased the amount of data we have on ULI, because currently we are doing about 4,000 documents per quarter. And right now, I may be wrong, but I can say that we have most of the decisions of our courts of records, save for the High Court that has many circuits and divisions, but for the Court of Appeal and the Supreme Court, Constitutional Court, we have most of the decisions on ULI. But what is the future of ULI from today? The judiciary is increasing the subscription from the ordinary package to the Tanzanite package. What will that do? That is going to make sure that one of the products we are going to introduce is something called the street law. Street law is whereby you can be able to read any material on ULI without using the internet. It will be an application on your phone. So whether you're in Kisoro, whether you're in Gulu, Atiak, wherever you will be able to access the same materials as a magistrate or a judicial officer in Kampala. So you won't need the internet. Secondly, there are discussions to put about 26 local languages on ULI. So it will be able to speak to someone in Acholi and any other local language that will have been provided. Now, this is going to be through the help of artificial intelligence, whereby the system can speak to anyone and explain to them a court case, a law, and any other thing that could happen. But also, there are specific sections that could be of your interest. And because of time, I couldn't go through the whole system. There's also going to be a section on ULI whereby you'll get to know all sections of the law that have been rendered unconstitutional and what the government is trying to do to correct the unconstitutionality. So those are among the things we are going to introduce, among other things. But also I must emphasize that the Judicial Training Institute undertakes free ULI trainings. And as you may have noted, we are now going to different universities and different schools to train people on how to efficiently use the system. Since this system is owned by us within the judiciary, you can just contact the management of the Judicial Training Institute at a convenient date, we can train the different courts and circuits of all courts on how to use the system. Because even when we go to the Tanzania package, which I believe will be in the next few weeks, the system is going to change. And most people will say that it's hard to use, yet the system is becoming more efficient to use. And if you realize that most legal information systems, whether LexisNexis or whatever you're providing, we almost have the same system. So if you get to understand this system, it will be easier for you to use all the other systems. Thank you very much.
Thank you so much, my learned brother Jude, for this insight on this ULI engine and its impact. I am really amazed that China uses it more than ourselves. And in most cases, that's what always happens, especially in Africa. You start something, and someone utilizes it more than yourself. So we need to really up our game so that we can first be the first beneficiaries. The president has talked about opening of personal accounts. I think before we leave this conference, wherever you meet him, if you find difficulty, you should be able to ask him to guide you on how to open your personal account. I think most of you have seen, I've seen my brother, we call him White Smoke. Sometimes before you do it, he's posting an authority that has just been delivered. Then someone wonders how he does it. It means he has a notification, he knows an authority has come, he does the reading and shares it with colleagues. So you can also be that a person who gets information faster, read it and use it for your benefit. So that means we follow what needs to be done, have those such alerts, and let these artificial humans help us to do our work. When I was listening attentively, I found out that creates the difference between working hard and working smart. Working hard always rewards the poor, while working smart rewards the rich. You toil the whole day, someone uses few minutes and gets what he wants. At the end of the day, he gets the reward. Let's all be there to dedicate our time to read. This URI web engine, you can use it wherever we are. You can be at a wedding when you're bored, you open your phone and go there to check this thing. Sometimes you lose sleep and you're like, let me check this engine and learn something there. Or you're bored somewhere and you do the same. It is possible and we can do it. Can I entertain some questions to the presenter? His Worship Gacharo, I hope you have a microphone. Kindly press your question or comment. Thank you.
Moderator, and thank you so much, Worship Joel. Don't have an account, though I use URI always, so I think I'm also going to open one. However, I would encourage you, because you have said you are always posting decisions from the appellate court. Court of Appeal normally on a daily basis, I think passes between 3 to 5 judgments, either in civil or criminal. So I think if you would enroll on their forum than waiting for the Mr. Wator and the other administrators, systems administrators to give you that information, it would be better. So I encourage you, Joel, that you take up, be added on that forum, and you access those decisions so that you can easily upload. Because I remember one time I challenged you, I came with the decision, we checked on it, it was not there, yet it was a very good decision on recent, the doctrine of recent sin, if you could remember. So kindly, you will do that. But otherwise, I thank Joel for the great work you are doing at the JTI in respect of URI, because URI has now improved. It's no longer the old URI we used to know. Thank you.
Yes, thank you so much. Yes, I see another hand there. Yes, my brother. Yes, yourself, you're the one you're looking behind. Give him a microphone.
Thank you very much, Your Worship. My name is Derek Kawana, Magistrate Grade 1. My question is in relation to, when you're reading a case, is there a possibility of you knowing whether it has been appealed and what were the results? Thank you.
Thank you so much for the question. When I'm just looking at either a hand up, because I saw to take like 3 to 4 questions and we allow him answer as we conclude our session. Any other question?
Yeah, thank you. How secure, how safe is the information uploaded on ULI? I attended a training where one of the judges shared a very sad experience where some advocates uploaded a decision on ULI, which he hadn't delivered. And it was a struggle for ULI to ensure that the decision is removed. And yet, you've just told us that ULI is being accessed worldwide, from China, from Europe, everywhere. How do we ensure that there's integrity, and how do you control that kind of abuse? And how does that even arise, that a decision gets on ULI without the judge delivering it? I was surprised to hear that, but this was a life experience shared by a judge of High Court.
Thank you so much. 2 more questions or comments, and we give it back to our presenter. The presumption is that people have understood when I don't see questions coming. So I will allow him. Yes, my brother, you have a microphone.
Thank you so much. How can we get the account on ULI?
Yes, kindly respond to those few questions, and
we see what next.
Can I just please be able to access my screen? Yes, thank you. Now I'll start with the first question from Worship Gacharo. Thank you very much. As a team, we are trying to improve day in, day out. And when you look at me here, I am not the only worker at ULI. We have our worship Marlene and our worship Adija. They just seated with us there. There's also Cornelius behind, and also there's the longest serving staff at JTI is called Benjamin Molingoki. What we normally do, we try to access as many platforms as we can. And I can state without fear of contradiction that we are on all platforms where a decision that is not on ULI can be released. Whether it is ECMIS, whether it is WhatsApp groups, we are on all those platforms. And we try to do it on a daily basis. Then the second question, and because of time, we couldn't go through the entire system, but I'm going to just demonstrate, you'll allow me to demonstrate using one court case. I'm going to use the case of Wakanyira. I've used the general search because when you put a search request, the AI system brings for you possible results. Now I'll open the Supreme Court decision. Now this is the Supreme Court decision of Ben Kavuya. As you can see, it is still loading, it has loaded. Now if you look at the highlighted section, this Supreme Court decision tells you that it has overturned the Court of Appeal decision. Now within the same space, when you click here, you will be able to know when you go to the Court of Appeal decision, the Court of Appeal decision tells you that it overturns the High Court decision, and you can get all the three decisions in one space. Now we started with the Supreme Court cascading downwards. But even if you look at tribunals, even Tax Appeals Tribunal and all other tribunals, or URSB, even their cases that have been overturned or upheld on appeal are being interlinked. Now, because this is a manual process, a ULI person has to know the decision and correctly mark it as either upheld Okay, as you can see, I was told to expand so that the people at the back can see this. As you can see, this is the Court of Appeal decision. It will tell you that this decision of the Court of Appeal has been overturned by the Supreme Court, but also it will tell you that the Court of Appeal decision overturns the High Court decision within the same space. Now, we have done this with currently about 1,000 cases, and hopefully by the year end, all cases on ULI will be interlinked. Now, this is where we beat all other law reporters. We are trying to improve the quality of our data and make it more meaningful. How safe is the information on ULI? I am aware of the statements made because I was in touch with a specific judge and the magistrate who are handling that specific case. Now, what ULI is safe from is we try to protect as much as possible from attacks from outside. But some errors come in because of human error. Some matters come in because of human error, and because we receive, currently we can, on a good day, we can receive about between 200 to 400 decisions. So a decision can be uploaded within those decisions, and you have not tracked it. You get it? But that issue was corrected. All I can say is that the system is safe, and it is our system. It is not the JTI system, the judiciary system. This is a system we have used from law school, media uses it, and every other person. So it is our system. What we have to do is try to endeavor and make sure that it is safe for all of us. But as we are, all cases on ULI are authentic, because now we put signed decisions by the judges and the justices. Now, how do you open an account on Yuli? I am going to just demonstrate by logging out of my account. Now, I've logged out of my account and I'm going to go to the home page. As you can see, I don't have an account that's open on the Yuli website. So what I'll do, I'll go to Yuli on this blue icon up here at the top that says login is where you click. Are we, some members trying to go through the same process so that I can wait for them? Yes. Yes. Let me have the team at Yuli. Cornelius. Yes,
Chair.
worship.
Before we shift, I just want to chip in, then we can go to the next.
Okay.
There is where a bit want. Thank you, Your Worship. I realized where I had something to add on the question that came, that how do you ensure that this information is right or a case is on appeal? You have given a good explanation, but also to add in, it is easy. Worldwide, this is what happens. One, Yuli is expected to have final judgments of court. And two, always there are experts like you and the other staff to always keep an update, professional update, which you have highlighted. Then three, there is always where you are, there is part of legal counsel. I think the colleague who was putting it to you, that some of these decisions would be maybe suspect, or how do you know that the matter is on appeal? This is ideally what is expected in Yuli worldwide, that your office is always on alert. Then lastly, what comes in mind always is to be in touch with the access to information, court records. So, Your Honor, I thought that was also good for me to help you, and we move. Then in conclusion, basically, that is how a decision moves to Yuli. And the protection of information in Yuli worldwide goes by international standards. Thank you. So I think we can go to the next. We're a bit such that.
Thank you very much, Your Worship. But Your Worships, opening an account on Yuli takes about 20 seconds. If you can open your Yuli on your phones, we can go through the process of opening accounts, and then we can leave it at that. Then when you need further assistance, the Yuli team is around and they can always assist you. Now, as I was saying, Yuli provides the login at the top, blue. Are we all there? Now, when you say login, Yuli will either say login using Google, and I'm sure more than half of us have Google Gmail accounts. Are we all there? Now, when you go login with Google, it is the easiest way to log in, because it provides another option whereby you open a Yuli account. By that Yuli account will not be able to give you email alerts because it will be on Yuli on the website. So can we click login with Google? If there's anyone having challenges, the team from JTI is moving around. Now I've successfully logged in to my account using my Gmail account. You've realized that it doesn't require my name because it uses all the details on my Gmail account to open an account on Yuli. Have we all done it? Yeah, now you'll all have all the benefits of Yuli once you have this system. So thank you very much.
Thank you so much, Your Worship, Joel. I think most of the questions have been answered, and this session is coming to an end. My brother, I see as if like you have a burning issue. Yes, you have a benefit of 30 seconds.
Thank you very much for the opportunity. Thank you, Your Worship, for the presentation. Mine is a suggestion. I notice that on Yuli we do not have decisions of magistrates courts. Now, I say this alive to the fact that we are not courts of record, but we have decisions of tribunals on Yuli which are not courts of record. I want to make a case for having some decisions of magistrates courts. Some time back, I had a matter to do with domestic violence, and I combed all sources and could not find any decision of a superior court on domestic violence. Yet I'm sure there are decisions that have been made by colleagues. Sometimes in deciding a matter, you may want to look at a judgment written by a court exercising original jurisdiction. And there are cases where only magistrates courts exercise original jurisdiction. So we may not have all the decisions, but I think that some of our colleagues write decisions that merit appearance on a platform like Yuli, and that would not be without precedent, because I've looked at the versions of Yuli in other countries like Ghana, and they have pages for lower court and district court decisions. So I would think that it is something worthy considering. Thank you.
I think the presenter hinted on it, that they are still considering whether to upload decisions from lower courts. So that means when that opportunity comes, we expect at least some of us to write some good judgments which can be referred to. Ladies and gentlemen, I'm profoundly honored and exceedingly humbled to be your chair today morning. This session comes to an end. Thank you so much for your active participation. I take it back to the administrators for effective communication. Thank you so much.
Please give the chair a big round of applause, Your Worships. Thank you so much, Your Worship Adams. And another big round of applause to His Worship Joel. He has done a lot in terms of uplifting Yuri and letting us know how to use it. Your Worship, thank you so much, including us who seem to be senior to him. We are learning from him, so we don't take that for granted. Your Worships, we are going for break tea, and we purpose to be here at midday so that we can go for the next session. The tables are well laid. You can pick your tea, and then we come back at midday for the next program on our agenda. Thank you very much, Your Worships.
Made observations that inconsistencies and disqualifying in the reading and interpretation of documents. And therefore, we feel that we needed a uniform and consistent approach in the handling of these matters.
No one thing. Then it is important to get into the handling of these situations. As we know, aviation is going in this country as we sit here, it has created cases in the community, cases in the families, but those are not the cases, that's not the training we are conducting. The one we are having, accredited investigators, and post-accredited investigators who handle only cases that are identified. That's the jurisdiction under which the Chief Justice appoints intervention investigators. So the point I'm trying to make is that I need to explain why this is happening. And then the solution to my case, under the deal report 2024, we can think that the case is new in our society as a result of this business. But there is also a related as compared to the case of the for Christians, you can look at the Matthew chapter 5, verse 1. You can also look at the Quran. All this shows that we are classification and consideration. And better still, you can look at that is Article 126. The adjudicating cases both of the civil and criminal nature, the court shall something to the law applied to the just shall be done or respecting of the assessor or the minister. B. Just shall be made. C. Adequate compensation shall be awarded to the wrong. D. Reconciliation between the parties shall be promoted. E. Substantive just shall be blind without undue regard.
Mediation involves defined statements and techniques to facilitate communication and negotiation between parties in this. So you have to convince them and tell them the benefit of mediation. Rather than going through litigation, which may take 3 years, will be possible to ruin the relationship and bring back. And in the end of it, even if you win, you have lost because you have lost. So it is very. What is the Registrars' task apart from that? It's one is protecting the parties, building credibility, very important. The mediator must establish trust with the parties first. If they trust you, they will talk. And then the mediators and the parties must determine the terms, define the terms of mediation. Then you need to have the convening matter. You must have an agreement to be made. And then after that, you make the mediation agreement. After that, you come to parties. So, how do you need to come to a round table? That's an achievement. People who are fighting, we don't want to see either parties but never sitting in the same table. In fact,
as we know,
I recall before the Honorable Chief Justice constituted this, the committee that made proposals that we are going to consider together. We made observations that we had inconsistencies and disparities in the management of education relations. And therefore, his view was that we needed a uniform and consistent approach in the handling of election disputes.
the main issue was affidavits. What do we do with these affidavits? That actually the Parent Act talks about actual hearings, not affidavits evidence. And that affidavit evidence was mentioned in the rules. And that the Parent Act should override.
Look more at the gray areas rather than what is settled. What is settled, that one anyone can find. But what is unsettled and what actually causes the disputes? It has a lot to do with those gray areas where people sometimes feel dissatisfied with the ruling of the court or with the law as it is.
Having handled election petitions, and I know many of you, especially judicial officers, that have know one thing, that it is important to get into the handling of these petitions when you're fully armed with the law. Hence the issues of consistency, which His Lordship, the ED of JTI, has talked about coming to play. We have had several discussions with the ED about delivering a training that is hands-on and practical. And that speaks areas that a judicial officer will find themselves confronted with during the process of adjudicating over these petitions. And they are unique. Election petitions are unique. And every cycle, you find the law has shifted a little sometimes, positions change. And without a pure, and I say pure because I'm talking about a synthesis of what is the position of the law. Of course, that does not tie the hands of a judicial officer from exercising their discretion and developing the jurisprudence. However, it is good to start from a point of certainty. In one of the petitions that I handled, authorities were thrown at me left, right, and center. And one of the advocates on the other side, when confronted with this authority, he said, the problem is that everything is on Uli.
Unfortunately, nothing is talked about the people component of this dispute. People component starts from the person who is going to resolve the dispute. Preparation, self-management. You had to tell your people, know the judge. What sort of judge is that one? There are judges you have to prepare. Others you prepare, you are wasting your time. The judges must be told, you are judging, but you are also being judged.
That gives them the ability to be judicial activists when they go into the court. Yeah, this is what these cases are saying. If we have best practices, then we'll be able to go in court and say, yes, we are aware that hitherto, this is what has been stated as the law. But as judges, we have found it lacking, and therefore you develop the law even when you are in court. The practical aspects of ADR is in election petitions. Would like to see more of that. We are very interested in seeing how we can have those disputes resolved in that way. What's the timeline for receipt? Because time is everything in election disputes. The features on the register were a big thing. The features. Do we have the features that lend to authenticity and validity for evidentiary purposes? Are they specified? When is day one of the 15 days?
I can go vote counting, affidavit evidence, this ADR somebody raised. And by the way, ADR is very, very, very important for a trial, or on any trial.
Politics, the context in which we are dealing with is now a matter of do or die. So they must hang on to someone. Someone must take the blame somewhere. And that someone should never be them. Now they want to pass on the problem to the court in some cases. In other cases, it's genuine. So you must, how do we train our people to understand some of those dynamics in their preparations? Our people are the safeguards of this institutional reputation at their different stations. How are we preparing them? There are very many other components. But above all, they have to know that they have to be alive in order to adjudicate. Times of elections, tensions are high, etc. So you can't rule out even pressure. Our people have also to be trained. How do you manage pressure, working under pressure, under trying times? It impacts eventually how our decisions are taken. Someone may say X is the answer. Y will say X is the answer. They believe the other one and disbelieve. So we need to prepare our officers to manage, first of all, themselves and manage stakeholders. My name is Mzamil Chibedi. I'm a member of the Judicial Training Institute Governance Council. As the council and our staff, we are very grateful to each one of you for finding time to come and participate in this important milestone.
I recall before the Honorable the Chief Justice
As we know, mediation is going on in this country as we sit here. People are mediating cases. In their villages, people are mediating cases in their families. But those are not the case. That's not the training we are conducting. The one we are having is for court accredited mediators, and court accredited mediators do handle only cases that have been filed in court. That's the jurisdiction under which the Chief Justice appoints court accredited mediators. So what the point I'm driving at is that we need to explain to people why this diversion. And there is justification in my view. Under the Hill Report 2024, only 10% of the courts of the cases being in our society are resolved through courts. But there is also our religious literature. As you know, the majority of Ugandans are religious people. For Christians, we can look at Matthew chapter 5, verse 24. We can also look at the Quran, Surah 49:10, and I quote, brotherhood and reconciliation. All these show us that we have justification for reconciliation. But better still, we can look at our constitution, and that is Article 126 of the Constitution. 2. In adjudicating cases both of a civil and criminal nature, the courts shall, subject to the law, apply the following principles. A. Just shall be done to all irrespective of their social or economic status. B. Just shall not be delayed. C. Adequate compensation shall be awarded to victims of wrongs. D. Reconciliation between the parties shall be promoted. E. Substantive justice shall be delivered without undue regard to technicalities.
Mediation involves defined stages and techniques to facilitate communication and negotiation between parties in disputes. So you have to convince them and tell them the benefits of mediation. Rather than going through litigation, which may take 3 years, it will be costly, it will ruin the relationship, and it will bring bad blood. And at the end of it, even if you win, you would have lost because you would have lost relatives. So it is very important. What is the mediator's tasks apart from that? It is one is contacting the parties, building credibility. It's very important. The mediator must establish trust with the parties, trust. If they trust you, they will talk to you. And then the mediators and the parties must determine the terms, define the terms of the mediation. Then you need to have the convening materials. You must have an agreement to mediate. And then after that, you make the mediation agreement. After that, you thank the parties for having agreed to come to a round table. That is an achievement. People who are fighting, who did not want to see eye to eye, but now are sitting in the same table. You thank them to encourage them.
I recall before the Honorable the Chief Justice consulted the committee that made the proposal that we are going to consider today. He made observations that we had inconsistencies and disparities in the management of adjudication of election disputes. And therefore, his view was that we needed a uniform and consistent approach in the handling of election disputes.
The main issue was affidavits. What do we do with these affidavits? That actually the Parent Act talks about actual hearings, not affidavit evidence, and that the affidavit evidence was mentioned in the rules, and that the Parent Act should override.
To look more at the gray areas rather than what is settled. What is settled, that one anyone can find. But what is unsettled and what actually causes the disputes, it has a lot to do with those gray areas where people sometimes feel dissatisfied with the ruling of the court or with the law as it is.
Having handled election petitions, and I know many of you, especially judicial officers that have, know one thing, that it is important to get into the handling of these petitions when you're fully armed with the law. Hence the issues of consistency, which His Lordship, the ED of JTI, has talked about come into play. We have had several discussions with the ED about delivering a training that is hands-on and practical. And that speaks to all the key areas that a judicial officer will find themselves confronted with during the process of adjudicating over these petitions. And they are unique. Election petitions are unique. And every cycle, you find the law has shifted a little sometimes, positions change. And without a pure, and I say pure because I'm talking about a synthesis of what is the position of the law. Of course, that does not tie the hands of a judicial officer from exercising their discretion and developing the jurisprudence. However, it is good to start from a point of certainty. In one of the petitions that I handled, authorities were thrown at me left, right, and center. And one of the advocates on the other side, when confronted with this authority, he said, the problem is that everything is on Uli.
Unfortunately, nothing is talked about the people component of this dispute. People component starts from the person who is going to resolve the dispute. Preparation, self-management. You had to tell your people, know the judge. What sort of judge is that one? There are judges you have to prepare. Others you prepare, you are wasting your time. The judges must be told, you are judging, but you are also being judged.
That gives them the ability to be judicial activists when they go into the court. Yet this is what the case, these cases are saying. If we have best practices, then we'll be able to go in court and say, yes, we are aware that hitherto, this is what has been stated as the law. But as judges, we have found it lacking, and therefore you develop the law even when you are in court. The practical aspects of ADR is in election petitions. Would like to see more of that. We are very interested in seeing how we can have those disputes resolved in that way. What's the timeline for receipt? Because time is everything in election disputes. The features on the register were a big thing. The features. Do we have the features that lend to authenticity and validity for evidentiary purposes? Are they specified? When is day one of the 15 days?
I can go vote counting, affidavit evidence, this ADR somebody raised. And by the way, ADR is very, very, very important for a trial, or on any trial.
Politics, the context in which we are dealing with is now a matter of do or die. So they must hang on to someone. Someone must take the blame somewhere. And that someone should never be them. Now they want to pass on the problem to the court in some cases. In other cases, it's genuine. So you must, how do we train our people to understand some of those dynamics in their preparations? Our people are the safeguards of this institutional reputation at their different stations. How are we preparing them? There are very many other components. But above all, they have to know that they have to be alive in order to adjudicate. Times of elections, tensions are high, etc. So you can't rule out even pressure. Our people have also to be trained. How do you manage pressure, working under pressure, under trying times? It impacts eventually how our decisions are taken. Someone may say X is the answer. Y will say X is the answer. They believe the other one and disbelieve. So we need to prepare our officers to manage, first of all, themselves and manage stakeholders. My name is Mzamil Chibedi. I'm a member of the Judicial Training Institute Governance Council. As the council and our staff, we are very grateful to each one of you for finding time to come and participate in this important milestone.
Your Worship. Your Worships, good morning once again. Your Worships, good morning once again. May I request Her Worship Chief Magistrate Daphne Avery to come and give us an opening prayer. Your Worship, you're welcome.
Thank you very much, Your Honor. Let us humble ourselves for a prayer.
When we speak about adjudication today and case management, we are speaking about our core business, right? We are speaking about what we do on a daily basis. We are speaking about what we took a judicial oath to undertake, isn't it? So it is our daily work. It is what we held the Bible or Quran and swore to do, to adjudicate cases and to manage cases. What do you then think is the place of leadership in adjudication and case management? Yesterday I shared on the law reform group in Seychelles, they have brought a law where advocates now working methods, and somebody talked about accountability.
Those key influential factors that would enable us achieve those expectations be taken into consideration. Thank you very much.
I want to congratulate you for coming this far in this year. We are almost coming to the close of the year, and we should thank God that we are alive. My Lord DCJ Emeritus Justice Butera, you are welcome.
Question number 1, we start with mediation. When parties file their cases in court, in your court, they expect the cases to be heard. They expect to receive a judgment from your court. How do you convince them to go for mediation instead of litigation?
If any of you has a dispute, approach your leader, discuss it, and have it resolved.
I assure them that they are entitled to a hearing, a full trial, because they are before me for that purpose. But I invite them to acknowledge that a full trial may take so much time as opposed to mediation, and at the same time it may cost them much more than they may spend if they opt for mediation.
The judiciary is mandated to independently and expeditiously adjudicate cases
Your worships, good morning once again. May I request
I was telling someone for the first time in our lives, we're going to have a cocktail at 4 p.m. and we go home. If members second it, we finish and go early. If you want nightlife, we start it at 8 p.m., right? So I take the honor and opportunity to invite our worship Patricia, who is going to be our chair during the next session. Our worship Amoko Patricia is a private legal secretary to the chief registrar. And she's going to invite the panelists to come and take us through the next item on our program. Your worships, I humbly request that we take our seats. I welcome you so much, Your Worship Patricia, and please carry on. Thank you.
Thank you, Your Worship, Zuleika. Your Worships, ladies and gentlemen, good morning. Are we together? Are we settled? Professor is ready. The first topic and the only topic this afternoon before lunch is on performance management. Performance management is close to my heart. I have had the very interesting privilege of being the first secretary to the Performance Management and Awards Committee of the Judiciary. Performance management is a core concept in human resource management, and you're going to hear a lot more from Professor. So the topic is performance management as a tool of effective delivery of justice and judicial accountability at the lower bench. With us this morning into the early afternoon is a guest presenter. His name is Professor Gerald Kagambirwe Karyeja. He is a professor of public administration and management at Uganda Management Institute and has 30 years experience in research, consultancy, and executive training in public management. He holds a PhD and a Master of Philosophy from the University of Bergen. For those who do not know where that is, like I did not, it is in Norway. He holds a Bachelor of Arts from Accra University as well. Professor is the president of the Africa Association for Legislation. He serves on the International Accreditation Committee for Public Administration, Education and Training, and is a member of the Africa Association of Public Administration and Management Council. He also serves on the Julius Nyerere Leadership Center and on the UMI Governing Council. He has authored, researched, supervised, edited, and lectured extensively. His lecturing has gone beyond the classrooms of UMI to as far as UPDF Senior and Staff College in Chimaka and beyond. Professor has contributed to key national policy reforms and is also a regular media commentator. Your worships, ladies and gentlemen, please join me in welcoming Professor Gerald to the stage. You're welcome, Professor.
Thank you so much, Chair, Your Worship, Your Worships. This morning we are going to have a brief interaction on performance management as a tool of effective delivery of justice and judicial accountability at the lower bench in Uganda. I'm grateful to have been given this opportunity to come and share my thoughts, insights, or remind ourselves
of the critical nature and importance of performance management, linking it to the delivery of justice and also judicial accountability, which means that we are dealing with three major concepts and looking at how they interact to improve or to help us meet our mandate. So Uganda's judiciary, from what I've read and experienced, among other things, you emphasize efficiency, which is doing things better, accountability. There are many ways in which we can appreciate the word accountability, but basically, I can say to be accountable, it means that you are responsible and also you are answerable. And there are just four components that can, in a simpler way, remind us of what accountability is. That when you are accountable, you are asked questions. They may be asked by yourself or others, formally or informally. You may listen to them or you may not. But when these questions are asked, answers are provided by what we do and what we say and think. When answers are provided, the third component is that a judgment is made. And when a judgment is made, we're either rewarded or we are sanctioned. Where there is power, we are sanctioned and rewarded substantively. Where there is not, we lose legitimacy, we lose trust, or we gain trust and we gain legitimacy. So you are key to public trust in the justice system. Because in public administration, we refer to you and others, like me and others, as street-level bureaucrats or street-level agents of the state, meaning that you are at the point of service delivery. When we appear before you, that's the interaction of the judiciary. That's the face of the judiciary. That's the experience of the judiciary. And trust is built or it is destroyed at that stage. And therefore, it's important that there is effectiveness and there is impact in the way you deliver the justice. So our key concept is performance management. And there are very many related words on performance management, which basically comes from two words, performance and management. And to perform is to do. So given our mandate, given our responsibilities, what we do is our performance. So you can excel or otherwise. And management is the corporate human interaction through structure and systems to ensure that performance is done, occurs, happens. Of course, from the detailed paper, you'll see a number of definitions of performance management. But I will highlight one that was given by the Honorable Justice, Principal Judge Emeritus Bamwine, that within the judiciary, performance management is about a modern, strategic, and integrated approach that establishes a shared understanding of what is to be achieved and how it is to be achieved. So the words that I have highlighted, which are in italics, modern, meaning that it's over times, it's contemporary. And sometimes contemporary things can be taken as passion, as rituals, or for granted. But sometimes also they are very substantive. And I want to take the proposition that in this case, it is substantive, it's contemporary. Strategic, meaning that it is at high level. Integrated, very many components involved. But most important, it's about the what. And the what is the delivery of justice. And the how, which is also the way we do things. So the procedural issues and the substantive issues is the question at hand. And in order to manage the procedural issues, the how we do things, and the substantive issues, the outcomes of what we do, restoration of justice, punishment, establishment of freedoms, compensation, the outcomes of the decisions that you take by virtue of your authority and mandate, those are the substantive issues. So the combination of how you do it and what you do, the way it is managed, is what performance management is all about. And it relies critically on clear goals. Each and everybody has roles and responsibilities. And if there is clarity of the roles and responsibilities, then performance management is easy, because we can attribute the contribution even to an individual. One of the key issues in performance management is attribution and contribution. As an individual, you have a role to play in the judicial system. The judiciary has a role to play in the nation. And we are all aiming at Vision 2040, NDP 4. Now, how do we say that the change in access to justice, the change in the trust in the judiciary can be attributed to your magisterial area, to your jurisdiction, to your decisions, to your actions? That's what performance management is about. How do we point out that it is because of you? Attribution. How do we know the proportion that you have brought to the table? The contribution. Some people contribute so much, others contribute so little. And in some sectors or in some spaces, others even don't contribute at all. And this is reflected in the performance indicators. We are monitored, and then there is feedback and corrective action. The ultimate aim of performance management is to take corrective action. Sometimes it is perceived to be punitive, but here we are talking about corrective action as the end game, as the end state of performance management. And performance management can be enhanced, can be improved, can be worked upon through training, through digital tools, through proper resource allocation and optimization, in order to improve the way we do things, in order to improve the capacity of the judicial system, and the ultimate, which is delivery of justice. This is our working definition of performance management. A brief conceptualization of delivery of justice, for which you are the experts and the agency. My understanding is that it is the process through which legal institutions provide fair, accessible, and effective resolution of disputes, where everybody is equal before the law, but ultimately, the judiciary has to be responsive to societal needs, meaning that there is a higher calling that goes beyond the law. The delivery of justice goes into other spaces and streams. It goes into the political arena. It goes into the societal arena. One can say that one way of looking at how we take our decisions and actions is through two logics. There is the logic of appropriateness, doing something because it's the right thing to do, and the logic of consequentiality, doing things because of what is in there for us. Regardless of the logic that one may think has determined the way you have taken decisions as a judicial officer, to what extent are you responsive to the economy, to the politics, to the social structure, to the cultural nuances? Because you have a tool that cannot be reached by the law, and that is autonomy and discretion. The way you dispense your autonomy and discretion as you follow the law, there's no guideline, there's no instrument by man that can fully capture one's autonomy and discretion in terms of decision making. So my reminder today is that let's look at that space as the space where responsiveness to societal needs plays. And again, almost the same way it can be enhanced, but the ultimate outcome, the ultimate lasting impression is to strengthen public confidence in the justice system. Because confidence is the result of interaction and experience, but it is also a perception, and it has to be cultivated. The other concept is judicial accountability, various definitions by scholars, but our working definition this afternoon is about mechanisms that safeguard judicial independence to ensure that you justify decisions in line with legal principles and democratic values. Again, the dichotomy of the law and the society. Since we are in a democratic dispensation, you will be tested against the extent to which you have upheld the legal principles, but also the democratic values of the land. And that is how, at the strategic level, you are held accountable. And this is about legitimacy. Legitimacy is being accepted, being appreciated, being taken as critical. It's about independence, not being influenced. Reasoned decision making, which is the reason we come to courts of law, but also the understanding that there is an oversight mechanism, which is of course in the judicial structures and administrative structures of the judiciary, and the different courts and the different mechanisms that you have. So this again is to reinforce public trust, the integrity of the judiciary, and to increase accountability in the judicial practice. So we can see from these three concepts that the bottom line is about society. The bottom line is about public trust, public confidence, legitimacy, the reason for which the judiciary was created, because it carries out a function which citizens, as individuals or as a collective body, cannot and will never execute. And thus, having the judiciary as an indispensable entity in the way matters of man are handled in a democracy. So when we look at the interplay between these three concepts, we notice that performance management is about the individual, the team, the magisterial area, the group, the unit for which you are in, and how it meets the strategic goal of the judiciary, the reason for which the judiciary was created. So each one of us makes a contribution that can be attributed to us as an individual and as a team to meet the strategic goals which are embedded in your strategic plan, the Constitution, and other documents you are very familiar with. Then, delivery of justice emphasizes issues of fairness, issues of access, and issues of dispute resolution, as judicial accountability emphasizes legitimacy and responsibility. Now, when these three interact, what does performance management bring to the table? It brings structure. It brings tools. You can have an analogy of a skeleton. The performance management is the skeleton on which the judicial system runs. You can have the administrative structure, you can have the procedural structure, you can have the judicial structure of the different courts and how they are escalated and so forth. So this structure provides tools, it provides the process for planning, setting goals, having the work done, having that work done monitored, evaluated and assessed at individual level through performance appraisals, at structural level through inspections, and evaluated so that we learn what we have done well, we escalate, we share with others, we institutionalize. And what we have not done well, we take corrective action, we improve, we avoid next time. So these are the tools that hold the structure. Performance is about those tools. So performance management, the way we do things and how we do them and what comes out of them is held together through performance management. So you may have committees You may have different ways of appraisal. Formerly, we have the very secret appraisals. Now we have open appraisals. Government of Uganda is going to the balance scorecard where everybody appraises everybody else. Delivery of justice brings on the table the substantive outcomes of performance. When you do your work well, then those that come to you, they get freedom. Those that come to you, they are punished for wrongdoing. Those that come to you, they feel that they have been heard. And therefore, justice has been substantively delivered through what and how you do it. Then judicial accountability is about the safeguards. Power left unchecked is very dangerous. And so it is assumed that the same also applies to you. Therefore, you have to be responsible. You have to be independent. Independent of capital. We're in a capitalist world. Independent of political interference and intervention. Independent of security threats. Independent of biases and persuasions, whether intellectual, moral, religious, or whatever. Because you are held at a pedestal that you are thought or expected to be apolitical, amoral, and this brings legitimacy. So these three concepts, I thought that those who were preparing this annual conference wanted us to reflect how and the extent to which the structure of how we are assessed on what we do, how we are supported on what we do, how we plan for what we do, how we account for what we are doing, how we report on what we are doing, how we are punished and rewarded for what we have done, the structure. Then the outcome of what we have done. How does the society feel that we are responsive? And the increased experience and interaction by the citizens with our courts, our decisions, our actions. How does it increase public trust? How does it reinforce the idea that we are indispensable in a democratic dispensation? That people can run to us, and even when the decision is against them, they are happy and confident that it was fair. From the various documents, a number of reforms have been done. From the literature, I've learned that the backlog is going down, the disposal rate is going down, is reducing. New high court circuits are expanding. You have the automated case management system, which you are very proud of as a judiciary, and which seems to be giving dividends. There is increased recruitment at your level, the lower bench, and a number of innovations to ensure that there is increase in access and quick service delivery through pre-bargaining, small claims, and alternative dispute resolution. There are 4 performance indicators that I thought we could also still reflect on as individuals and as teams. They are borrowed from the US court tools. Some of you are familiar with it. So in terms of performance, what is our clearance rate? When we look at the cases that come in and the cases that are going, how fast do we create space for new cases to be handled compared to the ones that already we have getting out? This has been found as very helpful performance indicator for the kind of work that you do. The time to disposition. What's the percentage of cases resolved in the time frame? Of course, case waiting here also has to be put into consideration. One dealing with a land problem in Ruero may have one land problem which takes so long compared to disposing of maybe another 10 cases of a different matter before court. So for each case, to what extent do we take trouble to estimate its time frame? And after estimating its time frame, to see the extent to which we've been able to dispose it off within that time that we had estimated. The age of pending caseload. How old are the old cases? The cost per case. In government, we go for value for money. So, what is the average cost of processing a case in terms of time, in terms of resources, in terms of opportunity cost? I would want to encourage us to, among other indicators, as we use these ones as well, to know that they can increase our appreciation of how we are performing. So you know the extent to which you use them and in relation to those others that you use. But at the end of the day, these seem to be at a higher level, very critical in appreciating the performance of such cadre. A brief linkage of performance management to effective delivery of judicial services. Three major, you can call them four, aspects came out for me. One is about time. When the structure, the planning, the indicators, the goals, the systems, the procedures, the automation of the performance management structure is well done, then most likely, or it will also improve on the reducing of delays and backlog. It will improve accountability. When people ask themselves about the decisions and actions that you've taken, would they feel that you used your discretion and autonomy to respond to democratic values, to respond to societal values, to follow the logic of appropriateness, that which society considers to be the right thing to do, that is a higher calling over and above the law? Maybe one other way of understanding higher calling is those who are religious, they say that the Lord has called me to be a judicial officer. Those who are patriotic, they say patriotism. Me, I'm a patriot. Those who are persuaded of the superiority of their profession, they say that, what else could I do as a distinguished land friend? And so forth. So that calling, whether spiritual or otherwise, that is over and above the law, is where public confidence lies. Because people's confidence is largely formed by their experience, by their moral astuteness, by their political acuity, by their level of understanding, by their biases and preferences, but above all, by their humanity. We are in an era where many human beings have ceased being human. And I think you've experienced this more than many of us. I've seen a number of accountability mechanisms, and you are familiar with even many more. Your inspectorate of the courts, your court open days, your anti-corruption strategy, the complaints desks, hotlines, CCTV monitoring, and so forth. These increase public confidence. These improve accountability mechanisms. So for us as the citizens, we just encourage you that do much more of this. You're faced with a number of challenges. Even with so much done, so much more is still challenging us. There is a persistent backlog. There are corruption risks. There have been elements of political interference, perceived or real. Many judicial officers feel that they get, at your level, they get in training for 1 month. JTI may consider giving them a longer induction, or maybe now the situation may have changed. Because people believe that the law alone is not sufficient to make them execute their work better. Appraisals. In some organizations, performance appraisals have become rituals for which we wouldn't want to be the same in your situation. They are filled out, but no feedback. They don't have the impact that they should have. No rewards, no punishment, no improvement in training, no promotions. So when people see performance appraisal tools, which are part of the structure, not informing decision making, it undermines performance management. There is a challenge of public mistrust. I saw one of the books on perceptions as I was entering and attitudes. Recently, UBOS carried out a survey. Staff shortages, but you are doing better than other institutions. And actually, that also becomes a challenge if you look at the ecosystem. For example, when I was facilitating the DPP's office to write their strategic plan, one of the challenges is that they are not matching you. Where there is a magistrate, there is no resident state attorney. So, and I think that also affects your work. So staff shortages both within you, but also within the ecosystem. Complex case loads, which require case weighting. That all cases are not the same. Some are more complex than the others. So how do we raise the level of complexity of registrars and magistrates to match the complexity of the cases? But also where we have high levels of complexity amongst yourselves, how do you lower your complexity to manage less complex matters and not make them appear so complex? We have a number of opportunities before us, which I'm not going to point out, but basically digitization and training. Some recommendations. Let's strengthen the capacity of the judiciary further. You're moving well, you negotiated well, you have one of the best administration bills. You're one of the agencies of the government that I think are rapidly improving in terms of recruitment and infrastructure. Government recruitment is at 46%. I don't know the judiciary, you are slightly higher. Strengthen the judicial situation room. Enhance peer training amongst yourselves, because people have different experiences. I don't know to what extent you have opportunity to benefit from each other. Enforce accountability mechanisms beyond the open day, beyond the CCTV cameras. Align resources. Sometimes most of the planners in governments are economists, with due respect, so they make models and resources are distributed pro rata, but there's need to increase understanding of the various cases and situations and locations, and the distribution of resources is proportional to the case weights and the contextual situations that people face. Performance management, the way we are measured, the way we plan for, the way we are assessed, the way we allocate resources, the way we are rewarded and punished for what we have done is a mirror of strength and gaps. My call is that let's commit to justice that is delivered and not just promised. People see justice by experiencing it and not hearing about it. The more you perform, the more you do what you are supposed to do in a way that you are supposed to do it, build stronger public trust and confidence. Strong performance, stronger judiciary, strongest public trust. Thank you so much for listening to me, for God and my country.
Thank you very much, Professor. I'll invite you to take a seat right here next to me. Professor has spoken not only as a professor who has taught on the subject of public management and performance, but also as a member of the public who I believe is sometimes partakes of the service of justice from us. And I loved how he ended when he spoke about justice being an experience. What is the experience of justice you are serving everywhere across the country? For me, is a question that we should all answer. He spoke about performance management, and when he said it is the what and the how, the what we all know. It's in our vision, it's in our mission, it's in our diaries, it's in all PRO and his team have belabored to brand extensively. So we see the vision, we see the mission everywhere across the institution. But the how isn't that, it is not that easy a question to answer, and I'm sure you'll agree with me. And so I'd like to start the plenary. I'm sure we have very many questions for Professor on this subject, especially perhaps in relation to reward and recognition. At least for me, it sticks out like a sore thumb. Peter is smiling. And I know that what gets rewarded is more likely to be repeated. I think it's time that we can put questions, comments, and all else to Professor while he's here. The session is 15 minutes. Kindly, let's stick within that time. I'll take 5, and then we can go on from there. Kindly let us know your name and where you're from for the benefit of those that may not know you. Thank you very much. Any question? Any comments? Any appreciation? Yes, Your Worship, Toloko.
Thank you, Professor. I think mine will just be in form of appreciation to Professor. What you have delivered today, I think we have perceived it well, and it is what we are expected to do. This takes me back to the foundation of performance vis-a-vis the work we do. In some of your other presentations I have always followed, indeed today, it is our luck that you have come and delivered what we expected. Indeed, when you look at the issue of management is not an easy thing to do. It needs your time, it needs your perception, and it needs a lot in it. Going by what Her Worship Patricia has echoed to Professor, indeed, we look at these issues as far as reward is concerned. In most institutions, yes, it is a good thing, and it helps to motivate those managers while they are doing their work. Lastly, Professor, I think since to me it is your first time to have met some of us here, but we have met you in other forums. I think judiciary should continue to engage you such that we can learn from you, because there is a lot of wisdom in all this topic called the performance management. It is worldwide, and if you were to take us through, I'm sure we can leave this place at around 10 p.m. And with those few words, Professor, I just want to thank you. Thank you, and we meet again.
Thank you very much, Your Worship. Toloko. Yes, Your Worship.
Thank you, Professor. My name is Owino Paul Abdonson, Chief Magistrate, Kamuli. Professor, I join issue with my colleague to thank you for the good presentation you have given us. It is very educative. It has actually covered most of what we have trained in and what actually we have been doing throughout. We take recognition of very many factors, especially how we treat the public and the feedback in terms of management. Also, case disposal rates and trying to avoid backlog. On addition to that, Professor, I was considering your discussion based on the theoretical frameworks which inform management and judicial accountability. And for instance, when you look at the public agent theory, where the magistrates and judges are agents of the public and given authority to act on behalf of the people, these activities require tools of trade to enable the officers perform their duties efficiently and effectively. And whereas the expectation on output is what you have been discussing, it is my view and submission that they should be enhanced with facilities, because you'll consider that other parts are not covered with internet, they are not covered with ECMIS, and you find that performing duties as expected may vary or may be relative from one station to another because of maybe limited resources and differences in structure. Because to perform these duties, there are tools that an officer is expected. For example, you may need to visit a locus or to visit the place where a land dispute is, but also you need a means of transport to get there. You may need to report very fast to the headquarters about a particular case disposal by way of CAS system. And you may find that in other stations, these facilities have not yet been installed. So this also calls for a robust digitalization, as you were saying, and having this station access these facilities. Then, as her owner was presenting, is that there are stations that are performing better than the other. There should be a motivational and a reward system to attract others to benchmark. But the statistics may show better performance and differences with other stations. If these remain unrewarded, they demotivate. There should be a mechanism of motivation. Even a letter of appreciation to that particular officer would be very important in the circumstance. Then, when you look at the judicial accountability theory, you will find that there is a lot of political influence into the judicial work. We are entering into an electoral process where, on the other hand, you have the legal framework and you have to apply the law to the facts. But then you are also being shaken from a different direction. And then it also measures on your performance. It is a factor which we may not agree, but it happens. And it has affected different or various judicial officers in one or the other. So what would you guide in such circumstances? Here we are guided, follow the law. But on the ground, you find such factors affecting your performance and many others. Otherwise, we are so grateful and we shall always desire to meet you again. We have really benefited from your presentation. Thank you.
Thank you very much, Your Worship. Owino, is there any other before Professor responds? Professor?
Yes. The last one. Yes, my name is Pascal Olopot. I'm a magistrate grade 1, Kajansi Chief Magistrates Court. My question to Professor, first of all, Professor, thank you so much for the elaborate presentation. My question has a lot to do with something that was mentioned throughout the day yesterday, that the cabinet has been able to sit and has okayed the proposal to enhance the jurisdiction of the lower bench, in particular magistrate grade 1s and chief magistrates, to hear cases that are beyond, let's say, from 20 million maybe to 50 or to 100 for magistrate grade 1s, and for CMs maybe from 50 million to 100 million or let's say 200 million. And it's almost foreseeable that it means that we are going to be handling more cases as courts of first instance. The question is, what motivation is being prepared in that line. And to put it in perspective, one of the things that you mentioned as a recommendation is that we must align resources using case weighing and data. The data shows that the highest performance in the judiciary is from the lower bench by statistics. And yes, we also more in number, but here the issue is going to be that we are going to handle much more cases, which have a larger case weight. In particular here, I'm foreseeing land cases, mostly, let's say, in Kampala and Wakiso, where land is a bit more expensive. Magistrate grade ones and chief magistrates are going to be handling more land cases, which have been maybe at the high court level. But that is more workload. How shall we ensure that we are effective? We don't increase backlog, but we are also motivated to do that work. One of the recommendations that Chief Justice gave is that there is potentially going to be a recruitment of more magistrates, maybe particularly CMs and magistrate grade ones. But what about the inside tenants? Does recruitment of more magistrates itself resolve the potential increase of backlog because of increase in jurisdiction? Or the tenants can be motivated more by allowance or in whatever way, and we shall be up to the task to deliver justice to the Ugandans. Thank you so much.
Thank you, Professor. Before you respond, did I see a hand, Your Worship King? Okay. Any other? Professor?
Thank you so much, Your Worships, and thank you so much for your appreciation. I am really pleased about it, and I'm grateful. Your Worship Owino, the question of the principal agency theory and the idea of matching the infrastructure systems with the decisions. One time I was having a conversation with one of your worships, and he told me he had to go to the locus, but the funds to go to the locus came 3 months after the case was supposed to be disposed of. So I think there is a lot of recalibrate. If performance management is going to be managed well, the planning, the support supervision, the increase of discretion and autonomy in decision making for managerial judicial officers has to be heightened. The availability of flexibility in how much one can be able to handle and redistribute and then answer later in terms of funds, for example, has to be also increased. So it's that performance management, as you said, you were spot on, can only function well, the skeleton, the structure, can only function well when it exists. And it exists because it is relying on something. And what is this something? It is relying on resources, it's relying on infrastructure. That's why the capacity and capability and infrastructure is my first recommendation. The physical access is very helpful to ensure that the rest of the judicial access is done. There are certain skills. You talk about the political space and how political interference or intervention or whatever one may want to call it affects judicial work. That's why I emphasize the idea of supralegal alertness, the high calling, which goes into societal needs and democratic values. There is one skill which is emphasized in the public administration sector, It's called the political acuity. For somebody to become a commissioner upwards in government, they test their political acuity. But we don't teach it. We don't teach it in public administration schools. People just experience it. They get accidents and learn from them. Others, they get scores and benefit from them. I want to encourage the Judicial Training Institute, if it is not already having training on political acuity, to have it as part of their curriculum. These are skills on how to manage the political space. Politicians are very interesting because they have two major spaces and you have the third. We have three arms of government and they occupy two. The executive, which our brother Pascal has referred to, and also the legislature. But in execution of their duties, their ultimate prize and aim is the next election. Anything that doesn't align is not given consideration. It can even be fought. So how do we increase the capacity and capability of judicial officers to navigate political space, since they are supposed to respond to societal needs and also to democratic values in order for them to be accountable, to be legitimate, to be understood, to be appreciated. So that's my recommendation. Your Worship, Pascal, on what is matching the increased responsibility, I think that whoever is in charge of performance management at the judiciary, they are going to look at the decision cabinet has taken and recalibrate distribution of workload, distribution of resources, distribution of power and authority, and match it. In performance management, there's also what we call job enlargement and job enhancement, meaning that the same person can be given more responsibilities or be given more capacity to do work, but also we are being told that digitization and other tools can also help us reduce our workload. So I think that such major decisions can only be effective if they are followed through with evidence and data to reconfigure how resources are allocated, how rewards are distributed, and how sanctions are executed. Thank you.
Do we have any other questions? If there are none, kindly, Your Worships, ladies and gentlemen, let's join hands to appreciate Professor Gerald. Professor, thank you very much for joining us this afternoon. Thank you for your time, and see you again next year. Merry Christmas. PRO, or Worship Zuleika, I hand the floor back to you.
Please give a big round of applause to Professor as he takes his seat. Another one for Her Worship Patricia for chairing the session. Thank you so much, Your Worships, and all participants present. Your Worship, there's a proposal that we have our next presenter so that we can go for lunch when we have wound up all the business for the day. Is that okay? Because we believe we've just had break tea and we are still okay. Yes, please. Let me work with the team from JTI to see if Madam Susan is here. Then she can come in. If she's not here yet, I'm told she was on her way. We could start on the rapporteuring to know the way forward, a bit of it, as she comes, because I'm told she's about to arrive. I believe Mr. President is here. His Worship Kawesa, President Emeritus. He's supposed to be chairing that session. Tony, please let us know if our facilitator is in the house or how much more time she needs to get here. We are told she's in the parking lot. She's going to join us very soon. We can be discussing amongst ourselves to see what we have learned, what our take-homes are for the day. How Patricia hinted about the reward system. We are looking forward to the same because so many people really work hard and their efforts go unrecognized. Isn't it, your worships? We want to know and understand how people work. Some people are working smart, others are working hard, but still we can benchmark on all of them to know how best to position ourselves because there's so much to learn from everyone. Salary enhancement in respect to jurisdiction, I'm not sure, because I remember during the year 2012, I think, we had an enhancement and files were sent from High Court and we took over. I remember I was a grade 1 in Masaka. I had files of 1981 when I was a baby. They were allocated to me. So I don't know. It will depend on how much resources we have and how much can trickle down. But let us be positive. The money will come. PS told us yesterday, didn't he? We need to be positive about everything. Let us not be worried about cases coming to us and we don't have money. The more land matters you have, you'll get facilitation to go and visit locals in court, isn't it? The more money you have, the more cases you have and you need data, I think the more bundle they will give you to be able to dispose them of. Because I believe that time we shall be using AI. That's not the point. Are you sure? What do you know that is happening? Don't be scared. The money will come, honestly. It will. When we joined as grade 1s, I remember we were earning 450, then we went to 600. I don't know how many of us were here at that time. We were earning 600,000 and we were okay. 600. Then we went to 1 million. We were very happy. Then I think it came to 1.6. We were very excited. Every time, everything that comes, we are happy to have it. So we just have to be patient. Things are going to get better. And at least now we have these WhatsApp groups where you can know what is happening in Kampala. Those days there was no WhatsApp. You would not even know what is happening at head office. You'll just be there and see some 200 coming on your account. Then you don't know where it is, how it is coming through. You don't know what it is for. But now at least there is communication that comes through. Because when we are not positive, we shall lose it all. Let us be patient. Let us be positive. Even those positions where we think people are getting a lot of money, we shall eventually get there. It's just a matter of time. I don't know if the money will still be the same, but I think it will have even increased more. So let us just keep working. Yes, I think there are signs that our facilitator is about to get here. So when she gets in, we shall invite the President Emeritus to invite her on the floor, and then we shall go into the next program. I am also informed that members of top management that will be coming to close us up are also following up on what is happening this side. When we are ready, they are ready to come and we close. Then we have lunch at once. After lunch, we have the cocktail and then go back home. Otherwise, we continue to thank the JTI team. I have had an opportunity of working with them this year, and I've seen how much effort they put into organizing a training. Oh my goodness. It's so laborious that you cannot believe when you see them just here. You think they just sit, invite you, and you come. They take a whole 2 weeks preparing for just one training. So I request that we please join hands and give a bigger hand of applause to our worship Lydian and the team headed by Professor Andrew Justice Kauka. And we believe that the nature of the trainings are getting better every day that we come. So we believe and hope that we shall also get better in terms of how we work. They are training us to work smart. Today we were signing in using QR codes. The other day on Open Day, people were filing their complaints using the QR codes. We were giving our questions here, unlike that time when we would write them when we are about to go back home. I think we are getting better as an institution. Surely we are. Those of us who have been here for some time know where we have come from. That is why we have not lost hope, and we know, and we see where we're going to. Somebody is saying because you are where you are, it is not true. I'm not any better than anyone. All of us are like the same, aren't we? No, you can still be working up country and be okay. Personally, I can work up country and be okay. Actually, I find up country more peaceful than this jam in Kampala where you have to move. You're not sure what time you're going to get home. You're not sure what time you're getting to office. So it's not about working either in Kampala or up country. All of us are okay. The good thing is that we have jobs. And we are employed by one of the best institutions in Uganda. So we should thank God and be grateful for what we have. Your worships, you are laughing. Why? Unfortunately, we are giving chorus answers. Worship Nashtende, what are you saying? The
judiciary and the 450,000 payment as salary was those years when we joined. So we should actually be so grateful.
Speak louder, my dear, so that people can hear. Carry the microphone. Should I come and help you? She's saying she was here when we were earning 600,000. So she sees things are getting better every day. And honestly, they are getting better. But even when we compare ourselves with our counterparts, apart from those other bodies that used to threaten us, which some have been merged now and are no longer there, but other people are getting less money than we do. We never used to have cars. We would move on foot. Sometimes you take a border when you are a little rich. But we survived and we are here, we are. So we need to just keep positive. Your worships, I have been guided and informed that the venue we are using for lunch is the same venue for the cocktail. So when we delay to have lunch, they'll take a while before they can set it up. And also, Madam Susan is here, but they are thinking that we would have lunch. Then as we do the closing ceremony, they will be organizing the venue for the cocktail, and then we finish at once. So I have been guided that I should ask you to go for lunch. They are still laying the tables, but they are almost done. So let's go and pick our lunch. Between 1 and 2, then we come back. We do the last session. We go into the closure, and then we go for cocktail. The venue for the cocktail will be ready in about 2-3 hours after lunch. So you're welcome for lunch. And I think lunch is going to be served in the same places we had it yesterday. The protocol team can please guide us on where we're going to have lunch. Thank you very much, Your Worships, and see you at 2 p.m. for the next session.
this diversion. And there is justification in my view. Under the Hill Report 2024, only 10% of the courts, of the cases being in our society are resolved through courts. But there is also our religious literature. As you know, the majority of Ugandans are religious people. For Christians, we can look at Matthew chapter 5, verse 24. We can also look at the Quran, Surah 49:10, and I quote, brotherhood and reconciliation. All these show us that we have justification for reconciliation. But better still, we can look at our constitution, and that is Article 126 of the Constitution. 2. In adjudicating cases both of a civil and criminal nature, the courts shall, subject to the law, apply the following principles. A. Justice shall be done to all irrespective of their social or economic status. B. Justice shall not be delayed. C. Adequate compensation shall be awarded to victims of wrongs. D. Reconciliation between the parties shall be promoted. E. Substantive justice shall be delivered without undue regard to technicalities.
Mediation involves defined stages and techniques to facilitate communication and negotiation between parties in disputes. So you have to convince them and tell them the benefits of mediation. Rather than going through litigation, which may take 3 years, it would be costly, it would ruin the relationship, and it will bring bad blood. And at the end of it, even if you win, you would have lost because you would have lost relatives. So it is very important. What is the mediator's tasks apart from that? It is one is contacting the parties, building credibility. It's very important. The mediator must establish trust with the parties, trust. If they trust you, they will talk to you. And then the mediators and the parties must determine the terms, define the terms of the mediation. Then you need to have the convening materials. You must have an agreement to mediate. And then after that, you make the mediation agreement. After that, you thank the parties for having agreed to come to a round table. That is an achievement. People who are fighting, who did not want to see eye to eye, but now are sitting in the same table, you thank them to encourage them.
As we know, mediation.
Your worships, good morning once again. May I request Her Worship Chief Magistrate Daphne Avery to come and give us an opening prayer. Your Worship, you're welcome.
Thank you very much, Your Honor. Let us humble ourselves for a prayer.
When we speak about adjudication today and case management, we are speaking about our core business, right? We are speaking about what we do on a daily basis. We are speaking about what we took a judicial oath to undertake, isn't it? So it is our daily work. It is what we held the Bible or Quran and swore to do, to adjudicate cases and to manage cases. What do you then think is the place of leadership in adjudication and case management? Yesterday I shared on the law reform group in Seychelles, they have brought a law where advocates now working methods, and somebody talked about accountability.
those key influential factors that would enable us achieve those expectations be taken into consideration. Thank you very much.
I want to congratulate you for coming this far in this year. We are almost coming to the close of the year, and we should thank God that we are alive. My Lord DCJ Emeritus Justice Butera, you are welcome.
Question number 1, we start with mediation. When parties file their cases in court, in your court, they expect the cases to be heard. They expect to receive a judgment from your court. How do you convince them to go for mediation instead of litigation?
If any of you has a dispute, approach your leader, discuss it, and have it resolved.
I assure them that they are entitled to a hearing, a full trial, because they are before me for that purpose. But I invite them to acknowledge that a full trial may take so much time as opposed to mediation, and at the same time it may cost them much more than they may spend if they opt for mediation.
The judiciary is mandated to independently and expeditiously adjudicate cases, protect, defend the Constitution, and ensure that fundamental freedoms are fully respected and enforced, and promote the rule of law.
I am especially honored, my Lord, to warmly welcome you. You have graciously accepted to officiate at this conference. Your Lordship's presence underscores the judiciary's unwavering commitment to accountability, to integrity, and the continuous improvement of justice delivery for all.
The theme of the conference, enhancing judicial accountability and access to justice, which was, by the way, also the theme for the National Court Open Day, it underscores the judiciary's commitment to delivering transparent, efficient, and people-centered services, rebuilding public trust, and ensuring that justice is actually reachable to all Ugandans.
I'm glad to officiate today at this annual Registrars and Magistrates Conference for this year 2025. Indeed, this is the last time, unless something happens between now and mid-January to cause you to meet again. This is the last time I am addressing you as Chief Justice. So this is quite important to me. I congratulate those of you who were either admitted to the judiciary or were promoted this calendar year, 2025. For those who've come into the judiciary this year, most welcome. For those who got promotion, congratulations. People would say, including we judicial officers, the judiciary is the third arm of government. That is not true. The judiciary is not the third arm of government. The judiciary is at par with Parliament, and is at par with the executive. So when you talk about the judiciary, you're talking about the magistrates. You're the pillars on which the roof, as the courts of record are. They provide shade, yes, but without the pillars, they'll be useless.
Your Worships, good morning once again. May I request Her Worship Chief Magistrate Daphne Avery to come and give us an opening prayer. Your Worship, you're welcome.
Thank you very much, Your Honor. Let us humble ourselves for a prayer.
When we speak about adjudication today and case management, we are speaking about our core business, right? We are speaking about what we do on a daily basis. We are speaking about what we took a judicial oath to undertake, isn't it? So it is our daily work. It is what we held the Bible or Quran and swore to do, to adjudicate cases and to manage cases. What do you then think is the place of leadership in adjudication and case management? Yesterday I shared on the Law Reform Group
Here's how developers at Perplexity and NVIDIA are prompting AI 10 times faster. You're prompting Cursor over 100 times a day, but typing detailed context
mukwano siba nkusabira bamukyaki ng'omusumba noonya solution esinga kuba ensonga kugonda abasawo ekirwadde kyabalema nsigaza gwe kunzijanjaba kati n'essuubi sirina kuba kapapulo kapudde ebyesanya kiremya kuba nsaba kimu kunzikyukira kuba weweka gweweka wenjagala wemera sefuna era sikulaba nizeka sikulaba nizeka sikufuna mukwano mbadde nkugamba newankubadde oli wala omwoyo wange talikoowa aliba naawe end of time omutima nsiba ngugamba gumiikiriza luli kyanajja kunzikiza ndyeyo munda empuliro gogo bwe gukoona amaanyi nsiba nga sonda kuba amazimo ndyeno munda bwe nzigwamu amaanyi n'enkita katonda mbeera weweka mukwano nsiba nkusabira bamukyaki ng'omusumba noonya solution esinga kuba ensonga kugonda abasawo ekirwadde kyabalema nsigaza gwe kunzijanjaba kati n'essuubi sirina kuba kapapulo kapudde ebyesanya kiremya kuba nsaba kimu kunzikyukira kuba weweka gweweka wenja mukwano nsiba nkusabira bamukyaki ng'omusumba noonya solution esinga kuba ensonga kugonda abasawo ekirwadde kyabalema nsigaza gwe kunzijanjaba kati n'essuubi sirina kuba kapapulo kapudde ebyesanya kiremya kuba kusaba kimukunzi kyukira kuba weweka gweweka wenjagala wemera sefuna sikulaba nizeka sikulaba nizeka sikufuna mukwano badde nkugamba newankubadde oli wala omwoyo wange talikoowa aliba naawe the end of time omutima nsiiba nkugamba gumiikiriza luli kyanajja onzikiza ndyeyo munda empuliro gogo bwe gukoona amaanyi nsiiba nga sonda kuba amasimu ndyeno munda bwenzigwamu amaanyi n'enkita katonda mbeera weweka weweka wenzagala wembeera nizeka sikulaba nizeka sikufuna the feelings I have are so true I love you I love you I love you Maria, Maria, Mariana. Oh, Mariana. Oh, no, no, yeah, Maria. Oh, Mariana. Oh, no, girl, me love how you talk so. Girl, when you talk, me can't tell you shut up. Simply fine when you talk, baby. When you talk, me just so black out. Jagalanzi Jeff, your body, but no visa, baby, got no passport. No money, boo, no visa, too. But baby, me give you the comfort. Oh, Mariana. Hey, Maria, 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 Mariana. Mariana. Big woman thing, baby killer, bite me, Dracula. Sing you from afar with my killer binocular. You speak vernacular, Guagala, you a killer. Me know say so many men I want you back to killer. She tell me she could love me, but she how could I see that when she got no ID, no idea? My Mariana.
Your worships, we request that we please come back for the afternoon session. To the conference hall. We have 2 or 3 main activities that we have to handle before we break off. We have a closing ceremony that is going to take about 1.5 hours. We have a facilitator who has 1 hour. And then we can do about 5 to 10 minutes of rapporteuring to know what we have resolved. And then we shall close and go into the cocktail. So I request that we please come in and take our seats. Our facilitator is ready here in front, waiting for us to turn back to the conference hall. And then she starts on her presentation. So please tell a friend to come back to the conference hall. Thank you. We welcome you back from the lunch break. Let's please take our seats, Your Worships. Your Worships at the back, please kindly take your seats so that we can be able to start on our session this afternoon. Our presenter is here with us and she's supposed to be somewhere else after 1 hour from now. So kindly take our seats. The protocol team, the participants are complaining about the excessive heat in the room. Can we have the AC on? Her Worship Nashtende is complaining that she has her AC in Masindi, but she's finding Kampala very hot. The protocol team, let's please fix that. I take the honor and opportunity to invite our senior colleague, the President Emeritus Ujoa. He has a lot of publications. He's going to carry the books along with him. So he's a writer in that regard. Your Worship Kawesa, I warmly welcome you to chair the next session this afternoon. And we request their worships to please take their seats so that we can be able to start. Mr. President Emeritus, I welcome you to take the floor. Your worships, join me in welcoming His Worship, the President Emeritus, to invite the presenter to come and also take her seat. Your Worship, you're most welcome and a very good afternoon to all of you, Your Worships.
Yes, can we have our presenter come and take her seat? Good afternoon, Your Worships. I'm not hearing you. Yes, I know chairing a session after lunch is not easy, but kindly let us try to be attentive, because this is a very, very, very important session on judicial wellness and productivity. So, my name is Godfrey Kawesa, a Deputy Registrar, Lira High Court, and I'm very, very humbled, privileged, and honored to be part of this conference today. There is a reason why I'm saying that, because we come from very far. It's not easy, but we are getting there. So, you will allow me to give context to this topic titled Judicial Wellness as a determinant of effective decision making and court productivity. You will recall that during the previous Registrars and Magistrates conference of last year, the Honorable Chief Justice decried the fact that despite the fact that the judiciary budget was going up, performance was not improving. And despite the several reforms, like the plea bargain, the mediation, and the like, performance was not commensurate with those inputs. Therefore, he tasked us to do research to interrogate what the problem was. And some of us who are research-minded went down to we started doing research and were able to crack the problem. And that is culmination of some of this work that we have here today, which are 9 publications. But before I further introduce our guest, I would like to report to members that I am a member of the Global Judicial Support Network, headquartered in London, UK, where we look out for the wellness and well-being of all judicial officers across the globe. Details will be coming in that regard. We also contributed to the drafting of the Nauru Declaration that culminated in the United Nations adopting 25th July as the International Day of Judicial Well-being. Then, in August of this year, I was humbled and privileged to represent you at the first United Nations symposium or conference on judicial well-being and integrity in Papua New Guinea. And of course, several issues came up. A report will be coming to that effect, but key was the fact that we were able to interrogate the question of financial stress and the judicial stress bedeviling judicial officers across the globe. Then we are having a commentary on the Nauru Declaration that is being drafted under the Global Judicial Wellbeing Hub, chaired by Honorable Justice Wimalasena Rangajiva of the Supreme Court of Nauru. It will be coming up, I think, next year. That said, judicial wellness, the topic of judicial wellness has not been in our traditional civil service. It is something that is beginning to take traction, because you know very well that when the public look at a judicial officer, he is supposed to be strong, infallible, financially sound. They look at us in the courtroom. They have not looked at what we go through before we come to the courtroom. And actually that is an area for further research, because we go through a lot when we are not in the courtroom. I am happy that the topic of judicial wellness is beginning to take traction across the globe. So, with us here today are 9 publications. This is a culmination of 22 years of advocating for the judiciary that we are seeing today. It comes from far. So I'll briefly go through these books because they relate directly to the topic at hand. The first one is Stress Management and Resilience Among Judicial Officers. Briefly, the finding is that many of us suffer from stress, especially post-traumatic stress disorder. Many of us suffer from things like non-communicable diseases, diabetes, hypertension, and many of us are surviving on drugs. So, are we in position to judge others effectively? And some of us are abusing substances like alcohol. I don't want to mention the others. Then the other book is Bullying, Harassment, and Discrimination of Non-Judicial Staff. Unfortunately, some of us do bully non-judicial support staff. And that one contributes to the well-being of the non-judicial support staff. Then the other book is Bullying, Harassment, and Discrimination. You will agree with me that some of us have faced discrimination. I know these topics are not so palatable, but someone has got to mention them if the judiciary is to improve. Yes, I'm talking about people who have spent over 20 years in up-country stations, and that is normal, while others are in stations that are, and that is also normal. There's an element of discrimination there. Then the other aspect is judicial bullying of advocates in Uganda, myth or reality. You have seen the conflicts between the ban the bench, the Samakadis, the radical new ban they like. So this one interrogated that kind of arrangement. The other one is Automation of Justice Delivery. This is one of our latest books, integrating artificial intelligence in Uganda's judicial processes. Your worships, if we do not innovate on how we are executing the business of adjudication, we shall remain forever stressed. And that one will contribute to judicial well-being. The other one is Delayed Justice, Case Backlog in Uganda, and the Right to Due Process. We all know that we have that elephant of case backlog. And in this book, we try to advance some recommendations on how we can overcome that. Another one is Beyond the Courtroom, Transformative Justice for a Better Uganda. Your worships, you have to start looking beyond the courtroom, because retirement is round the corner and the like. So if you don't prepare well, are you stagnating at work? Are you facing a disciplinary challenge? Are you facing fear? Because one of the challenges we are facing as judicial officers, unfortunately, is that many of us live in fear. So in this book, we try to answer all those sensitive questions beyond the courtroom. Then the other one is The Future of Justice, Innovations in Uganda's Judicial System. Your worships, and especially those ones just joining the judiciary, our struggle for a better judiciary for the last 22 years is embedded herein. You will know how AJA, the Administration of the Judiciary Act, was enacted. You will know how the current salaries that we are now enjoying came to be. It was not a bed of roses. Some of us had to stake our necks. Of course, working in tandem with the Chief Justices and you yourselves. You remember what the action we took in 2017. To date, some of us are facing effects. That's why some of us have spent 20 years up country. And it is normal. And we are saying it's normal, it's okay, we shall work. But we shall not relent in pursuit for a better judiciary. Then finally, Uganda Judicial Attitude Survey. This is very good for us, especially top management, to know how judicial officers and the support staff think about their leadership and other aspects. So, my lords and your worships, yes, in case we have any lords here, those ones who are not lords yet, receive it. I am calling upon you to partake of these books so that you get to appreciate where we're coming from. I am donating this set to the Judiciary Library. You can find it there. I'm also going to ensure that every member of top management receives a set for action. You can also find these books on my website, www.godfreykawesa.org. These books also have audio versions, and they have been translated in other languages like Chinese, French, German, and other local languages with the time, funds permitting. So without any further ado, the other challenge I wanted to talk about before I call in the presenter is that many judicial officers are suffering from work-life balance issues. We're failing to balance between work and our lives. What am I talking about? We have a number of broken families because of this distance. We have judicial officers who are failing to reproduce because of distance. So all these ones, you find them in these books. Yeah, broken families because of distance. And this is all because, unfortunately, for the past 20 years, we have been advocating for a human resource manual, which has not yet been enacted. We are talking about policies like the deployment policy. That one is very, very key. There is a lot of outcry over there. The Honorable Chief Justice had promised that before he leaves, the deployment policy will be in place. When I was still in President Ujoa 4 years ago, we drafted that policy together with the human resource manual, tailored for the judiciary, and we handed it into the top management. But to date, it has not yet been enacted, and it is a source of injustice, and it is leading to poor performance and affecting judicial wellness. I hope I've given the topic context. So now, to discuss the topic further is none other than Miss Susan Tashobia. She has got a lengthy CV. In the interest of time, I'll try to cut it short. But she's one of the judiciary counselors. She's a counseling psychiatrist. She's experienced. She's an executive director, Rapport Counseling SMC Limited, which provides workplace counseling and employee assurance programs. She has an experience of 13 years in the field. She provides counseling services to Office of the Auditor General, the Parliament of Uganda, Bank of Uganda, the Judiciary, and other private organizations. Join me in welcoming our presenter for this topic. Thank you.
Thank you so much, Your Worship, for that introduction. Allow me to further introduce myself. I think there was an error. I'm not a counseling psychiatrist, but I'm a counseling psychologist. It's a joy to be back this afternoon to join you as you celebrate the end of the year, but also go through what the year has been through this wonderful conference. And from the background he has given and the work he has done together with his colleagues on wellness, This afternoon, we'll be looking at how you can take care of your wellness as a judicial officer for optimum productivity and decision-making in the courts, as that is your business on a daily. And so we are going to be talking about employee wellness. I believe you are all judicial officers or judicial employees. And therefore, employee wellness has become a very important thing in the workplace, because every workplace relies on human resource, and this human resource must be in the rightful state of mind for them to be able to produce as required or to give out productive results. And so we'll quickly look at what wellness is. Okay, I believe everyone is able to see what is projected. So wellness can be defined in very many ways, and I've come up with a few definitions on wellness, but I want to go with one that was suggested by Pfizer, which says that wellness is an act of practicing healthy habits on a daily basis to attain better physical, mental health outcomes, so that instead of us surviving, we should be able to thrive. I want to believe that the judicial officers, the kind of work you do is more stressful than any other work. And sometimes we want to believe that you do the same work as we do, though in a different parameter. You listen to people's challenges, you work on deadlines, you work with so much pressure to deliver. Sometimes you may not find time for yourselves. And as your colleague has mentioned, some of the examples he was mentioning, we have already experienced that through some of the officers who have received psychosocial support from us. And therefore, those are not new things from you and from your colleagues. There's a lot of pressure. You listen to people's challenges when they come to court. You witness tempers and emotions rising, people not listening to their colleagues during mediations sessions and other court sessions. And I know that that may not leave you the same person. Sometimes you may want to think about the decision you're going to take after listening to these people. You don't want to be biased, but yet there's a conflicting opinion somewhere. So taking care of your wellness and being alert about that helps you to make rightful decisions and productive deliveries that have integrity, things that you have thought through and not just acting out of emotions and the circumstances that you are going through. So that requires you to take care of yourselves as well. As you take care of those courts that you have been charged with, you need to pay attention to yourselves and know that you're the most important person in your lives. And therefore, that's why wellness is very important in your work, in your lives, because before you come to work, you are an individual, and this individual is what you bring to the team. If this individual is not well taken care of, it's going to be a problem to other members of the court that you work with. You're going to become a challenge to the people that you lead, those who are your subordinates, those you work with, if you do not take care of yourselves. So let's look at wellness as simply an act of practicing healthy habits on a daily. And I don't know how many of us do pay attention to this. Wellness as well is linked with health, as I've mentioned. Health is properly defined not as an absence of illness. You may look healthy and you think you are healthy when you are not healthy. You may say, because I am not suffering from any diseases, I am okay. And that is not true. If your mental wellness is not okay, is your physical wellness is not okay, you are not going to be okay. And that is interlinked with health. And according to World Health Organization, it defines wellness as a complete state of physical, mental, and social well-being, and not merely the absence of diseases. So if you're not suffering from any illness, do not say you are okay if you're not paying attention to your wellness. So wellness and health, as I've mentioned, they are interlinked, or they are linked together. Wellness is simply an active process of living fully engaged life at every level of being. As an officer, as a judicial officer, if you're in court, or if you're at your workplace, at the courts where you work, how well are you? What is your state of being you are executing your duties from? Are you struggling? Are you thriving? Are you taking care of your other areas of life? Because we are not only focusing at the workplace. We are looking at your personal life. We are looking at your family life. We are looking at the other areas of your life that makes you a holistic person. So wellness simply looks at the holistic health of an employee, that they are able to execute their duties without struggle, and if there is any struggle, they are able to find help and support to get back on their feet. It is also becoming aware of and making healthy choices towards healthier state of life. This is going to take us at looking at the 8 pillars of employee wellness that makes it holistic, and it is what we want to advocate for this afternoon, that you as an individual, as an officer, you need to pay attention to your wellness. This is our wheel of wellness. We have social wellness, we have environment wellness, we have occupational wellness, we have intellectual wellness, spiritual wellness, etc., as we shall be looking at them. So we are going to start by looking at your physical wellness. How well do you take care of your physical? And many times when we talk about physical wellness, people think about exercising, hitting the gym. How many of us think like that? Please put up your hands. At least I have some people there. It's more than that. Physical wellness looks beyond the activities, the physical activities we do. It encourages you to look at your holistic wellness of your physical. What you eat, do you do checkups? Do you know that maybe you're struggling with some illnesses, but they haven't manifested? He mentioned about non-communicable diseases. It is public knowledge that we all know that many judicial officers suffer from non-communicable diseases because of working long hours. We have heard about backlogs a lot on media and in the news. And so that may sometimes force you guys to work overtime. It may force you to work beyond your limits. It may make you work past your working hours. And sometimes when we do that, or when you do that, you find that you have no time to take care of yourself in terms of your physical. And then the non-communicable diseases come up, the physical illnesses come up. We have had many people struggle with back problems because of sitting for long hours. So we want to encourage you this afternoon to take care of your physical wellness. Think about the exercises you can do for your health. Think about going for that medical checkup. I don't know whether you have medical insurance, but those are some of the things you need to pay attention to. Go and do a full body checkup. We have had doctors encourage us to do that, but many times to our disappointment, we find it very difficult, or we pay no attention to our physical health, and we never use our privileges from our workplace, like taking care of your physical, using that medical insurance to know that everything is okay. There are also things like what we take into our bodies. For example, people who take a lot of substances or who abuse substances, that may impair your decision making at your workplace. You may find it very difficult to cope with your work or even relate with other people. So we need to make sure that we have a check on some of these things that we do. And these may cause us challenges like insomnia, which is lack of sleep, and sometimes others get over too much sleep, which we call somnia. So your sleeping patterns can be affected if your physical health is not okay. So we want to encourage you and tell you that your wellness starts with you. Taking care of yourself, it is your responsibility. The judiciary will provide such services to support you, but the core or the primary person or responsibility lies in your hands. We had someone talk about life-work balance. Sometimes you may want to compromise your health because of the kind of work you do. You need to learn and know that, this world can exist without you, but you cannot exist without it, right? So that means we need to make sure that we put and do everything that we need to have in place to be able to to thrive in this world with good health. Annual medical examinations are encouraged in this case. Exercising is encouraged, and eat a well-balanced diet. Let's avoid foods that do not have any nutrition value to your wellness. Secondly, we have emotional wellness, and this is associated with you understanding yourself or self-awareness. How well do you react to events that happen to you? Pleasant ones and non-pleasant ones. We have challenges where people are going through a lot of challenges in the present world today, things stemming from homes or from our families affecting us, challenges from the workplace challenging us, and other challenges, as you may know or as you are aware of. So emotional wellness simply looks at how you as an individual understands yourself, reacts towards this thing. How do you respond? How do you act? And how do you feel when certain things happen to you? So you need to pay attention to that and have the ability to understand and manage your emotions and feelings. Sometimes we may be caught off guard, but as a judicial officer, how do you react if you get a client who pisses you off? They are accusing you of a bribe and yet you have not taken it. How would you respond to that? Those are things that I want you to think about and reflect on your emotional wellness. Are you the one who is always triggered and they know if they say this in court, they'll get you off guard? And so some people can use your tempers and emotions to weaken your kind of decision or the decision you're going to make over a certain matter. So it's very important that we learn who we are as individuals. Self-awareness is very important. If you know that you're the one who can be easily triggered, learn some coping ways and better ways of managing your emotions so that people do not use it against you or take advantage of your weakness. Because again, all of us have these emotions. It's only how we manage them and we be better people at our workplace. Social wellness. This is equally important. After your long days of work, you need to relax. Your worships. I need to learn these words very well. So, ladies and gentlemen, as you spend time working, apart from the work you do, we are naturally social beings. So you need to connect with other people, you need to interact, you need to make meaningful relationships that will help you to relax and also be in your normal reality or as a human being. I know, again, out of a few interactions with you, sometimes you may be restricted on how you interact with other people, the places you go to, and that may infringe on your freedom sometimes, and you find that you're missing some other part of you that does not come out freely to be who you are. So when you create good social networks and you pay attention to your social wellness, you're going to bring that component out of yourself, and you'll be able to boost your wellness and your well-being. You're happy and you're able to look forward to going back to work and achieve productivity. We have needs and we crave for healthy relationships. So social interactions and social connections or connectedness is very important in the societies where you work. It does not mean that if you need to keep a social distance as a judicial officer, you cannot interact with the community where you are staying or where you're working. Once in a while, you need to reach out, you need to interact with them to be able to understand the people within the area where you work, and then purpose to find and create meaningful relationships and friendships that can boost your well-being. And while maintaining healthy social ties is very critical to your social wellness, we must be selective with the people we socialize with. I think I've talked about that. Not every connection you make is really good for you, because you need to also be aware of the sensitivity of the work you do as judicial officers and know when to set boundaries and what kind of connections do I make? Do they add value? Do they uphold my integrity as an officer, as a judicial officer in the court where you are stationed? Then we also have spiritual wellness. Spiritual wellness is not to be taken for religion. When we talk about spiritual wellness, people may think, oh, me, I am a Muslim, I am a Christian, I am ABCD. No. It simply means that you find meaning through the things that make sense. If you have a power that you believe in, because we believe in different powers, if it makes sense and it creates a sense of purpose for you, please pay attention to that, because it's very important. Someone will tell you, me, when I am stressed or I'm going through a certain situation, this is what I do. I meditate. I talk to my God. I do this. I talk to Allah. Please pay attention to that. Through the meditation, you find your happiness, you find your wellness and your well-being in finding purpose in whatever you are doing. So a spiritually able person seeks meaning and harmony between what lies within as well as the forces around them. So find out what is that you find purpose or meaning in, and then surround yourself with it and run with it. Intellectual wellness. I think today the conference you have been having is part of the intellectual wellness. I believe there's one or two things that you have learned, or it has stimulated your thinking. And therefore, we encourage employees to pay attention to their intellectual wellness. This is where you basically look at, things that add value to you, to your career. Intellectual wellness encourages creativity and mental stimulation, something that, causes you to think beyond what you have been thinking about. Think more, be triggered, be stimulated, and be creative. So looking at, for instance, adding a course maybe on what you have been doing, like our colleague was sharing. Through that research, he has been stimulating his mental wellness and mental well-being, and it helps them to think and add something positive to their thinking. So reading books, learning new skills is very important. Do not say I'm a judicial officer and that is it. We are living in a world where we can multitask and we can have as many careers as we can if we are open-minded. So as judicial officers, we encourage you to be open-minded in terms of intellectual wellness, learn more and contribute to other areas, not necessarily your career as a judicial officer. That also helps you to relax. If, for instance, from your busy weekday, you start maybe teaching at your church, a Sunday school class, or any other activity, your social circles, there are those groups where you find there are activities you can participate in. By contributing, that helps you to boost your wellness, and it helps you to add another skill, and therefore you can survive beyond the judicial work that you do. And that brings happiness and increases your wellness as an individual. Then we also have occupational wellness. And this one I would like to ask you and maybe hear from you. Are you satisfied with what you're doing as a judicial officer? Can you answer me by show of hands? Those who are happy, please put up your hands. Well, thank you, quite a number. So should I assume that those who have not put up your hands, you are not satisfied with what you do? Can I hear the answers? Yes? Well, occupational wellness helps an employee to look at what they are doing. Are you satisfied with what you're doing? Does it bring fulfillment? Some of you may have applied for these jobs and you reach there and it's not making sense. It is not satisfying you. So if you find yourself in that state, what do? You either are going to seek help and adjust your mindset, and if that does not work and you're not satisfied, we would still say you can resign and look for another thing that brings fulfillment. So occupational wellness simply looks at your work, what you're doing as an officer, as an employee. Are you satisfied? If you're not satisfied, what is causing the dissatisfaction? Are you able to attend to it so that you enjoy what you are doing, so that it brings that fulfillment? Happiness with and within work. Work-life harmony is very important. If you're not satisfied with what you're doing, that means your life out there is also going to be very difficult, because there's no satisfaction from this place where you spend most of your time. So we want to encourage you this afternoon that make an evaluation of yourself and find out where you stand as a judicial officer in order to attain occupational wellness. If there's anything you can do about it to improve, that is very good. If you need support, we are here to support you. But make sure that you are happy at what you're doing. That's when you're going to be productive and contribute positively to the judiciary. Do you have a safe and comfortable work environment with an understanding with your colleagues? Your worship has talked about the people you work with, the non-judicial officers or your support staff. We have had many cases of those support staff seeking psychosocial support because of the poor working relationships with their supervisors. You find someone is failing to work because they have failed to get along with their supervisor, and the supervisors are making it difficult for them to thrive, and therefore they are just surviving. And again, I know that it is vice versa. Some of those support staff can equally make your work difficult. But we want to say this afternoon, evaluate yourself. Try and have an understanding with the people you work with, because you are not working in isolation. When there is harmony, when there is a good work environment, everyone is going to thrive and everyone will be happy and be productive. And there's this important one, financial wellness. As judicial officers, how well are you taking care of your finances? Are you receiving your pay every month, end of year, there's nothing you have used your money for, nothing there to show, and every day you're complaining or you're wondering, what's wrong? Why can't I keep some money on my account? Why can't I have some developments? As an officer, as a judicial officer, your financial wellness is very important. I have actually come to realize that apart from how careful we are with taking care of our other areas of wellness, financial is very important. There's a way it boosts our wellness and our well-being. So when we take good care of our finances, then we are happy people. You are working, but when the money comes, you're sending it to the village, someone is calling you. Have you paused to also reward yourself as someone who is making this money? Or everything is, I am keeping for the children's school fees. So with financial wellness, some of the things you need to look at is how you can also enjoy your money, the person who is making it. The person who is making the money. But plan for it, plan your expenses, plan your investments. If you have some debts, please pay them so that you can have a peace of mind and you're able to do your work without interferences. I have been privileged to work with very many government officials. I have had an experience where someone comes to hide in your office for a session because money lenders are coming to their workplace to arrest them. I hope we are not experiencing this as judicial officers. So plan your money and enjoy it and be happy. Environmental wellness, this simply focuses in the place where you are operating from. Is the environment where you're working from conducive? Does it foster your, or does it promote you, or does it promote your well-being so that you can execute your duties in a safe environment? Here we are looking at how you arrange your office, how your office is protected, especially the kind of work you do. Are you safe? Where you stay as a judicial officer from work, where you're protected, where it is safe. Are you safe? Or you're staying in a kafunda where you have to jump some houses, and in so doing, sometimes you may break your legs. So please pay attention to where you stay, where you do your work from, and that will help you to be comfortable and do your work without thinking or worrying about anything. It also looks at the conservation, energy consumption. It looks at the cleanliness of the environment where you stay. So these things seem simple, but they are not as simple as they may sound. And that's what I had for you this afternoon.
Yeah, thank you very much. A very big round of applause for our presenter this afternoon. Yes, presenter, you may take your seat, please. Yes, of course. No, you can join me here at the high table. Thank you. Of course, the presenter presented on the topic of judicial wellness and how it can affect productivity and decision making. She reminded us that one of the most important factors of production is the human resource. You see, the English have a saying that you may take a horse to the well, but you may not force it to drink. That is very, very important. You know what I'm talking about. In other words, we should nurture the human resource well if you want productivity of the judiciary to be enhanced. She also reminded us about the several types of wellness, such as physical wellness, emotional wellness, social wellness, spiritual wellness, intellectual wellness, occupational wellness, financial wellness, and environmental wellness. So that said, I think now is the time for our plenary. Can we now have some questions, recommendations for our presenter? Yes, can I see those hands shoot up? From Professor Toloko. Yes, at the back, am I seeing a hand? And maybe I'm wondering.
Yes, Chair.
Yes, please.
Thank you so much, Your Worship Kawes, and the presenter. I've listened keenly to the presentation on different types of wellness, good for us as judicial officers. But it seems one of the components of wellness seems to cut across financial wellness. Because when I look at financial and spiritual, those two, once you have the two, then it seems the rest can be sorted. Because if you have money, then you can even think of paying for gym, going for exercises and all that. If you have some money, you can create a social well-being around yourself that you can make you comfortable. If you have some money, you can also invest in these others. So, Madam President, I wanted you to confirm or relate that element of financial well-being and spiritual, if they can sort the rest. And if so, then the judiciary looks into that, because I really feel once those who are sorted, then the rest can surely be handled. Thank you so much.
Yes, Your Worship, are you saying that the financial wellness of judicial officers their terms and conditions of service are still wanting, that they need to be sorted. Please clarify. Worship Adam.
Yes, Mr. Chair, I'm saying that looking at the financial constraints that we have currently, the cost of living, okay, that most of us as judicial officers, we find it really hard to be able to manage these other aspects. So if the government can look into that by uplifting our financial well-being, then ultimately we would be in position to sort these other aspects of well-being and be able to perform our duties.
Yes. You give a response. Okay, thank you very much for that observation. Any other reaction? Yes, Professor Toloko.
Thank you. I should stand. Thank you very much. Mine is just a simple question, but it may not be a question, but it can be a shared take of that date. I just want to get to know about wellness. Yes, I know it, but to human beings, I think Madam Presenter and His Worship Kawesalva, I think the whole thing depends. It is so philosophical that the whole question depends upon an individual to how you think the narrative of your body, how you should be. It may not be necessarily how much you have. You would find you have 1 billion shillings, but you are stressed. The question of financial literacy, I think, also comes in. How do you manage the 1 shilling you have, the 1 billion you have at the end of the day? I think, to me, that wellness to your personal body can be maintained. Lastly, I think also to have a leeway to extend on the issue of wellness to human body. Some of the, I think biology still rings upon us. For one, I studied 553, integrated biology. Those hormones, most human beings have different hormones that at times generate some element of stress. So our presenter, I think he will chip in to guide us, because there are certain sensory perception in the body. At the end, given work by a supervisor, they get scared. At the end of the day, the body weakens. What can such an individual do? I think to have a solution is to continue to engage more presentations of this kind, not only necessarily in the year that we have you. We only come here once, but the whole year, what could have happened? So in a narrative, I think the question of financial, in summary, depends on the individual. The question of your body, how much food you eat to sustain a healthy body, may depend on you. That goes without saying. Some of us are familiar with the one-day gear, but that is not where I always go. You will happen to find people eating fatty foods. The body may not be maintained, but I think here we are already educated. And hopefully, next year, the councillor over, you should extend more time to engage with us. Thank you. That is what I can share with you as far as my body is concerned.
Yeah. Yes, as philosophical as always, just like any professor. Thank you very much, Your Worship Toloko. Any other concern? Yes, Your Worship? Okay. Then the presenter will respond.
Yes, my name is Olupot Pasco. I'm a magistrate grade 1, Kajiansi Chief Magistrates Court. My question is derived from a live event In a particular forum, a judicial officer, a magistrate, spoke that he used to be very interested in politics, and he grew up inspired by the political arena. But then the calling of a judicial office came in, which put particular restrictions to him. For him, it was not just something that was interested in, but was also a way of relieving stress, finding satisfaction and well-being. And that because of the judicial office, since he took oath, he's now expending that energy watching Telemundo and cartoons. Now, my question is, what can we do if we had hobbies or areas of interest that are now either banned or should be performed in limited fashion? What do we do now with all this workload? And we need to find excitement. As men, if we watch cartoons, they will say we are babies. If we watch Telemundo, they say that we have become more female than men. We are no longer masculine. How can we balance this equation? If you go to the bar, they will say that we have become too friendly to the bottle. So maybe you could guide us on the way forward so that our wholesome or holistic well-being can be guaranteed. Thank you so much.
Yes, there was a hand next to you, and then the presenter will come.
Thank you so much. Thank you, presenter, for that wonderful presentation. My humble question is that what kind of advice can you give to a judicial officer who is like the only educated person in the whole village? You have relatives, aunties calling on you for financial support. And not only that, sometimes even in the same village, they call you, they tell you, our relatives have been arrested. Then you have an extended family, relatives, and so on. And so sometimes to maintain a good name, you go beyond, but at the end of it all, it affects you. And at the same time, they say this is Africa. You have to support them. So what kind of advice can you give to such a judicial officer? In a day, you can receive like 3 calls. These ones have been arrested. There is a land matter between a particular judicial officer. Can you help talk to him? And so on and so on. And sometimes you feel like you can't let them down, you know? You have to extend a way of trying to help them. So these are things that we deal with in our everyday life. What kind of advice can you give such a judicial officer? Thank you.
Yes, our presenter.
Thank you so much for those questions. I'll start with His Worship Adam. What's his name? Where he was asking or thinking that maybe the spiritual wellness and financial wellness would complete the other pillars of wellness. There's one thing I can say about financial wellness. When we are talking about financial wellness, we are not looking at how much you have in your money, how much you have in your pockets or on your account. Even if it is 100,000 that you have received from this conference as your maybe disturbance allowance or transport allowance, must you use all the 100 if you come from Entebbe? How do you plan your money? The little you have or the much you have is what is very important. And that's what financial wellness looks at. I can assure you that even if you advocated for an increase in your pay, and you got more than what you are earning today, if you do not know how to manage your finances, budget, plan, save, invest, it is still going to it's not going to be enough, and you're going to complain. So the best thing is for us to pay attention to how we spend this money, how we use it, and how it brings that satisfaction that we want or that we are working for. Because we are all working to get money, right? I am here because I have to be paid. You're working because you want to be paid. You want to achieve certain things. So if you are working and you get that money, are you able to achieve what you have planned for? Some of us may not even have financial plans. The money comes, it now takes me to what the last person is asking about. The money comes and you're getting calls from the village, from your girlfriends, from your boyfriends, from your teachers, the teachers that coach our children. Everyone is demanding from you. And without plan, you're going to start dishing out the money. It's not going to be enough. So financial wellness simply calls us to pay attention to how we spend this money we work for. Are we doing our best to make the most out of it? Or it comes and you hear people saying, it is passing through my hands. I cannot put something to it. So let's pay attention to financial wellness. And yes, I want to say that to some extent, I think I hinted briefly on it in my presentation, that personally I've also realized that actually when you have money, you're very happy. Not so. When it has hit on your account, even if I don't spend it, I feel comfortable. I feel confident that there's something. Even if I stepped on someone's eggs and broke them, I can pay for them, right? So even you, when those people call you, you have what to give them. If there's a need that needs finances, you're able to pay. I think the professor mentioned it. We need more of these topics and coachings to talk about wellness. It may seem philosophical, as he has said, but it is not. And those are the simple things that make a difference in our lives. Because many times we pay attention to other things and we get lost. And when people come to us for support, we take them back to the basics. Basics of, for example, you're getting money at the end of the month. Do you have a plan? Because someone comes and says, I gamble all my money. Someone who gambles, do they have a plan? Because if I had a financial plan or I have something I'm working towards, before I go to betting, I have put some money aside, and this is maybe the money I have put aside for betting. So let us, I think this opens our hearts or our minds to think about some of these wellness, the pillars of wellness, and evaluate ourselves, how we are standing as individuals. And as Professor said, it is an individual responsibility to take care of yourself because you're the most important person in your life. If I get that money, if I do not pay attention to the environment in which I am working from, I am staying, then I am going to find myself in a very big problem. So responsibility starts with you. Now that you have been triggered, you now know the 8 pillars of wellness. What do you need to achieve this if you evaluate yourself and you find yourself lacking? Support is available. As I was introduced, I work with Rapport, and we do support you as an institution. So at the end of this, I will be able to share with you my contacts and the contacts of the office. We have different counselors, different experts in all these matters, be it financial, be it spiritual, all those pillars we are talking about. You should be able to call in and seek for support. Support is available, but in most cases, people do not reach out. And again, we shall meet next year for a discussion like this and then you look back and there's nothing much you have used this information with. So I want to encourage you that yes, we can have these conversations and more. If you need them, please reach out to us as a court. We can organize online sessions where we can talk about these things and talk about them in depth. For instance, the emotional wellness, it looks at your mental health. The professor was asking me to talk about the emotions and feelings and hormones that go about in our bodies. The one thing we all need to know today is that we all have levels of stress that are normal. But sometimes when we don't manage them, when we don't manage our emotions, they progress into severe levels, which becomes very difficult for us to control, and it now causes us to get into mental health challenges, problematic colleagues and judicial officers. It affects our well-being. It affects your decision-making at your workplace and in your homes or in your families. So it's very important that we pay attention to these wellness pillars, and where you feel you need support or where you feel you have not been paying attention and you need to pay attention to, then pay attention to that. And then to the colleague who was asking, how do you manage the stress that comes from your village because you're the only educated person? The advice I would give you is, first of all, you need to know that you're one person and you need to live for yourself before other people. Put yourself first. I have said you're the most important person in your life. And then family will come or will follow. Because I will assure you that even if you attended to each and everyone's need or challenges back home, it is going to drain you, and tomorrow you're not going to take care of yourself. That's where we find people breaking down. Some people are breaking down not because of their own challenges, but from challenges that stem from out. So my advice is, be honest with these people. Tell them, be honest with them when you're able to support and when you're not able to support. If someone asks you for 100,000 and in your pocket you don't even have 10K, what are you going to do? If you want to meet their need because you don't want to be labeled as someone who doesn't want to help, you're going to get into debts because you want to meet their need. And that leaves stress on your side. So talk to your family or talk to those relatives. Let them know that you earn like any other person. And sometimes your earnings may not be able to cater for everyone. Remember, you have your immediate family members as well to take care of. I have had cases where people are in that kind of situation and their children don't have school fees, but you have school fees to send back to the village for your uncle. Because you don't want to be labeled ABCD, everyone is looking at you. Set healthy boundaries for yourself, first of all, and know that you need to take care of yourself. For you to be able to do what you're doing, you need to be clear-headed. You don't need to be under pressure. So, my advice is, be honest, talk to your people, let them understand that actually sometimes you may not have money when they call. Tell them how you are stressed when they call because you have nothing to do. If you're going to keep doing that, you're enabling them and they will not give you a break. They will know anytime I'll call Uncle so-and-so, I'll call my son, I'll call my son. That is enabling them not to take care of their own responsibilities, but it also breaks you as an individual. So secure yourself by setting healthy boundaries. Know how much you can spend or how much you can give people in terms of your time. Because after your long day's work, you need to rest.
Yeah, thank you very much. we are coming to the end of our session. But before we do, Your Worship, Biarugaba Adams, and members, kindly permit me comment about our struggle for financial wellness and where we left it in 2019 when I was the president of the Uganda Judicial Officers Association, WUJOA. May I? Yes, so you've heard of the 7KT salary increments of 2019. I'm talking about the 7KT, Kaguta, Katurebe, Kahinda, Kasaija, Kagole Chivumbi, may he so rest in peace, Kawesa, and Tumweseje, the 7KT salary increments. And at page 315 of our book, The Future of Justice, it is clearly highlighted. We happened to go to State House in Entebbe, where His Excellency President Yoweri Museveni took cognizance of the fact that judicial officers work a lot and that the judiciary was marginalized in as far as finances were concerned when you look at it in tandem with the executive and the legislature. And government went ahead to make a written commitment, which is in this book, in the short term, medium term, and long term. And the structure is highlighted here. What am I saying? I think now is the time, before Honorable Chief Justice Owiny-Dollo takes leave of the judiciary, to come up with the Owiny-Dollo increments 2025, salary increments. So it is upon now WUJOA and the Judiciary Administration to take up these matters. And on that day, the President issued two very, very important directives. One was on housing. I remember he even got a calculator and asked how much can a housing unit for judicial officer, magistrate cost. Then they told him about 200 million. Then he got a calculator, calculated, and issued a directive to then Prime Minister Ruhakana Rugunda that this is feasible. We have Chinese in the country. They can put up structures for judicial officers in every district of Uganda. The second directive related to motor vehicles. He was like, how much does a motor vehicle cost? And there are not so many. He got a calculator, calculated, and it's like, these billions, it is feasible. He issued a second directive on motor vehicles for all judicial officers in Uganda. Those two directives are there hanging. They need to be extracted and executed. Then finally, at the United Nations conference I attended in Papua New Guinea, we took cognizance of the fact that judicial officers across the globe are financially stressed. The public has got very high expectations of us, and yet the pay across the globe is not commensurate to what we are supposed to be earning. Therefore, we established a movement spearheading how we can alleviate financial stress across the globe. But we also realize that governments across the globe are tired of us clamoring for salary increment from the consolidated funds. Then we realize that, yes, we should use some of our limited resources. Now that in Uganda we got a salary increment, we should be able to pool these resources, identify areas of opportunity in every country of the globe for purposes of investment. And in this book, I highlight some of those measures. For instance, at this conference, we are about 500 magistrates and registrars. Assuming that each magistrate contributed, say maybe 2 million shillings out of our enhanced salaries, that will amount to 1 billion shillings. Now, with 1 billion shillings, you can import machinery from China. Look at the consumables we have on the tables. We have water. We went and had lunch. We used cooking oil and other consumables. Paper, we have paper. These machines that make these consumables can be imported tax-free from China. We go to government and secure land The Uganda Investment Authority is ready to give the judiciary land for investment. We establish a judiciary industrial park, import machinery, set up these machines. Then we incorporate a company under Ujoa, get outsource people to manage it on our behalf because we are busy. Then we share the proceeds from the sales at the end of every year. That model works. And it is embedded in here. In here, you have concept notes to that effect. I beg to submit. Thank you very much for being good listeners and participants. Thank you very much. So, before I take leave of this stage, may I now request the PRO of the judiciary to come and receive a set of these books for the judiciary library. Thank you very much. A round of applause for our presenter.
His Worship Kawesa is handing over books to us as an institution to empower us with the knowledge that he has put in his write-ups. Let's give him a big hand of applause for his big heart. Writing a book is not easy. Some of us have even never written a script of 2 pages. Give him a big hand of applause, please. Thank you so much, Your Worship. Another big hand of applause to Mr. Shobia, Susan, for the presentation. To the PRO for receiving the books for and on our behalf as an institution. And finally, for Mr. President Emeritus for chairing the session this afternoon. Your Worships, we are moving into the closure, and the members of top management are on their way to come and close us up. But in the meantime, I want to request the JTI team to step forward, one of them to come here to tell us what we have resolved to do or what we have undertaken to do after this training. We can panel beat on each of them, and then later when the DCJ comes for closure, we can just read them to him and then go into the real closure and go for the cocktail. I am told the jam is too much. Even if we left now, we shall reach home at night. So the cocktail will be during the night or evening, transiting into the night. Or we can even go back home tomorrow morning. Good thing it's a weekend. So thank you very much. Your Worship Obizu, please come and take us through the resolutions that we have agreed on for this during this training. Thank you. Please give a bigger hand of applause as she takes the floor. You're welcome, Your Worship.
Good afternoon, Your Worships. Good afternoon. After the interactions we've had in the last 2 days, that is yesterday and today, these are the resolutions we think that we can implement as judicial officers in our various capacities, from the interactions, the presentations, and the insights that have been shared with us. So I'm just going to read them verbatim. I am unable to project them. And where you feel that it is not something that cannot be implemented, you can put up your hand, or you can use a microphone, and then, tell us and make a suggestion. Thank you. So these are the resolutions. made at the annual Registrars and Magistrates Conference 2025. Number 1 is on judicial leadership. That we, the magistrates and registrars, affirm that leadership is a core judicial duty grounded in integrity, professionalism, accountability, and service to the public. Do we agree? Do we agree? Thank you. Number 2, proactive case management. That we commit to affirm end-to-end case management to enhance efficiency, timeliness, and fairness in justice delivery. Do we agree? Your Worship, I just explained I'm unable to project for certain reasons. Sorry for that. Now we're able to share it on the screen. So we looked at number 1, which is judicial leadership, and we had said that we agree. Number 2, we're talking about proactive case management, and that we affirm an end-to-end case management to enhance efficiency, timeliness, and fairness in justice delivery. Do we agree? Number 3 is on plea bargain and ADR compliance. That judicial officers resolve to strictly follow all legal frameworks and procedures governing plea bargain and ADR to safeguard legality and fairness. This emanates from the fact that from the panel discussions yesterday, we got to know that many times judicial officers, especially at the lower bench, do not strictly adhere to the procedures in plea bargain. Do we agree with that? Number 5 is institutional support systems. That the institution commits to strengthen the administrative, mediation, and legal support system to ensure equality of arms and public confidence. We know the issue of public confidence is very crucial, and I think it was talked about over and over yesterday. Yes, I think on this I agree with you, even before you say it. Yes. Let's go to number 5. Yes, Your Worship. Can you read?
Yes, there was that resolution which was talking about strengthening institutional support. Okay, then I guess it's number 5. Sorry.
Yoshpo, good?
Yes.
Okay. So we're saying strengthen institutional support for ADR and plea bargain. I think yesterday we heard or were told about our roles as judicial officers in strengthening ADR. For example, when we have mediators at our courts, what are we doing? Are we just saying that these mediators are on their own, or are we supporting them? That's the support that we're talking about. And then number 6 is innovation, digitalization, and data-informed decision-making. We had presentations today on ECMIS and ULI, how we can navigate ECMIS, and the usage of, I mean, how we can navigate ULI, and the role of ECMIS in justice delivery. So we're saying that we're committing ourselves to embracing these innovations. And I think from our day-to-day practice, we have seen how embracing these innovations has helped us in delivery of justice.
Excuse me?
Do we? Yes, sir.
Yes, among there are many more other innovations coming. Digital innovations, we have the judgment writing tool, we have the performance enhancement tool. So ICMIS and ULI may be just examples. So we need to embrace the digital innovations or tools in whole.
Thank you so much. We shall include that. We are going to do editing. Yes, Your Worship.
Okay, it's on. Thank you. I wanted to start from the first and the second.
Yes, Your Worship.
The first, okay, the heading says resolutions. And then when we start 1, 2, 3, and I don't know where, we are saying we affirm, we commit, we aim. I think those are just like support, emotional, you know. I thought resolutions are like the actions, what we have agreed to do. Because, okay, let's see number 1. I can't recall so well. If someone can put it, and then I can explain what I mean. The first, I don't know if it's a resolution or an affirmation.
Your Worship, that is why I said if there are issues, we raise them. So
Pardon?
thank you. These are supposed to be what we want to do or what we have agreed to do. So we are committing ourselves to do these things.
Okay, just before
So
that.
they are not affirmations. They should be commitments.
They should be resolutions.
Yes.
Because they sound like
Or
these
we may say that
UN
we
things
resolve to.
and then say what we shall do, not like proactive case management and efficient delivery. What are we going to do in order to attain that? That is what I'm thinking.
Okay.
So that when we go, we can be able to review next time if we've achieved to a certain level. But I wouldn't come here to say that, yes, I'm committed, I committed, and I'm still committed. Thank you.
Thank you so much, Your Worship. After this, we are going to make all the changes following the feedback and then share. So number 7 is about strengthening public trust, and this is through credibility, transparency, consistent conduct, respectful communication, keeping proper records, and prioritizing institutional and public interests over personal considerations. Are we okay there? I think it clearly shows the actions that we are going to take. Your worships. Are we okay? Number 8 is we commit to fostering teamwork, collegiality, inclusive decision-making amongst ourselves and stakeholders to enhance effectiveness and coherence. So the key issues here are teamwork and collegiality and inclusive decision-making. Are we okay?
Your Worship, I want to propose.
Yes, Rena.
I'm proposing that we amend decision-making among judicial officers, registrars. Isn't it the same? We could
Thank
say
you.
judicial officers and staff. Thank you.
Thank you, Worship. The next is we're saying we pledge, but we have already been told the language should not be that. So we're saying that we'll uphold integrity, prevent corruption, bias, and treat all court users with dignity and respect, keep our courts accessible, inclusive, and user-friendly, especially for the vulnerable persons.
Your Worship, sorry to take you back. I
Yes.
still have another proposal on that very recommendation.
On number 8?
Yes.
Yes.
To commit fostering teamwork, collegiality, and inclusive decision-making among judicial officers, staff, justice stakeholders at regional and national level. So that we don't say court station, national levels. You can say regional and national level. I don't know.
That's noted, Your Worship. Thank you. So, number 9, are we okay? Busulwa, are we okay? Good. Number 10 is on sexual harassment, ensuring workplace safety, dignity, and zero tolerance to sexual harassment. So we're aiming to enhance sexual harassment awareness and prevention with regular trainings, because we were told that we have focal persons at our courts who we think will be the people to undertake this. And then ensuring clear reporting, prompt investigations, and support. In as much as we know there's a particular committee that does this, we ourselves are the stations who are the focal people or who are the leaders to whom a staff or a colleague may report such an issue, have a responsibility to undertake ensuring that the reporting is done and then forwarding the complaint to the committee. So this, personally, I feel also needs a few amendments with regard to the language. Yes, Your Worship, Gachara.
Thank you for the good work done, but I am seeing in your free time, maybe as a team, you sit and paraphrase most of these resolutions to be short. The recommendation should not be long, because somebody should remind them in the head than being so long and verbose. Thank you.
Yes, Your Worship. Thank you. So the last one is continuous improvement, accountability, and performance monitoring to deliver timely, efficient, credible justice, meeting constitutional standards and public expectations. Anyone? Your Worship, Jackie, I also feel like it's a bit shaky. You can say something about it, then you can edit.
Your Worship, when we say commit to continuous improvement, over what?
Exactly.
I don't understand that. And then I think that is where I have a problem. Continuous improvement. I think we need to be clear on what.
Thank you. So, Your Worships, those were the 11 resolutions, which we are going to edit, which we are going to make shorter, edit, and then we will share it on the different groups before the end of the day. Thank you so much. Then you clap for me.
Please give our worship a big hand of applause, Your Worships. Thank you very much. We are going into the closure. The Chief Registrar is here with us already. I think she's receiving the Honorable, the Principal Judge. But we humbly request that we move forward so that our closure doesn't look like people were not present. Your Worships, we request that you come and occupy the front seats. We are the VVIPs of today. No one is coming to sit in front. Please come and sit in front, Your Worships. The tags, should we remove them? Protocol team, remove the registrars, facilitators, and everything that will come forward. You don't want to become registrars. Please move forward, Your Worships. Worships seated on this row, please move forward. Come and sit near the PRO, he's here. And tap into the blessings. Their worships here recently promoted. Come and sit with them and tap into the blessings, please. Your worships, the deputy registrar, sit in front here. We don't have anyone else other than us. Protocol team, please help me move their worships. Worship tendo and group, please move forward. I can see you. Please move forward. Worship Nicholas and our team, please move forward. Look at all this space here. Next time, I think we shall have a chief whip for these trainings and workshops. So they call us back to order. They're only waiting to hear from us if we are ready, and then they come in. I have been asked by the Registrar Magistrates Affairs to inform your worships without laptops to move behind. There's a table, and then you register so that you can have your laptops. Your worships, all four, and on behalf of the Judicial Training Institute, we thank you so much for turning up in big numbers. We hope that we are going back better than the way we came. And let's please implement whatever we have resolved to do. Let us carry that knowledge with us. Let us support each other to grow career-wise and then become better judicial officers. Let us mentor and support the young ones, because all of us are products of good mentorship and support from our seniors. And especially for me, I have been mentored by the best chief magistrates. And I thank all my chiefs who are here. Thank you so much for supporting me to become who I am today. The chief registrar says they are going to be here in a while. When they come, we shall all rise up. Then we go into the closing ceremony. Our worship of Obizu will be coming back briefly to let them know what we have resolved. It is very important. Yes, they have to know that we haven't spent a whole 2 days here doing nothing. So if we need to work on on paraphrasing, and then let's do it now. After we have taken them through what we have resolved to do after this training, then we shall go into the closing ceremony, which is anticipated to last for about 30 to 40 minutes. Then we go take a shower, we go into the cocktail. I'm told some people carried clothes for the cocktail. So they will go and have a changing room, they put on those beautiful pieces, and then we come for the cocktail in the evening. We thank you so much for coming, and we thank the Judiciary Administration for making funds available for this training, especially the Magistrates and Registrars Conference. It's an activity that sometimes we would not do because there is no funding, but at least now it is happening consistently. It helps us to know each other. It helps us to bond. It helps us to know the new members of the family, and then we see who we need to nurture, or they can actually come to us to nurture and support them as we also learn from them. It is an avenue that we have to use at our level to network and become better judicial officers. I am going to be informed when the Honorable PG and the CR are coming in, and I will request you that you will rise up and receive them. Thank you very much, Your Worships. Let's give them a few minutes. I know that they are coming and they're about to make their way into this room. Thank you.
Mechanics are like that. Even this one is in the sofa one. Wash Angela gave him. It's the type that takes a vehicle. Check the bush. Check the I think my show comes up and have a guns. Now after going there, it returns the vehicle already well functional. When you drive it, you feel like trying to now. Now, fixes them and started out the other intelligence system fixed them. Tell him back how much. I'll charge you for the push. Put the brakes, then you give me my I will tried it since morning. Like a bumper now, so they have to change it. Of course, you're the one fixing them, but running around. A bumper, the van is manual oil. By my switch ignition, I have to change the switch. I have to change it. You're going to be swift clean. So you're seeing your expenditures being around 400. Maybe because I made the switch it cost me 120. The bushes are like then the brakes you put I think 6 120. 120 times is 270. The bumper we agreed at 100,000. But I'm spraying. But this is empty. Now the disc in the brakes. They told me there's a way they can fix it without buying system. But it's 400. have small books, you have things. So basically, I have the money to give big. Give them some money. Give them some money. You have to ask for paper. Maybe I can charge you like yeah, that is almost going to make us straight. You know, there's serious work up there.
My Lord, I request that we remain up so that we can have the anthem, and then we go into the official closing of the conference that we have had for 2 days now.
Sorry.
May we please take our seats? Thank you so much. My Lord, the Honorable, the Deputy Chief Justice of the Republic of Uganda, my Lord, the Honorable, the Principal Judge, the Executive Director, and the Focal Judge in charge of ADR, Your Worship, the Chief Registrar, members of the senior management of the judiciary present, Your Worships, the Registrars, the Chief Magistrates, the Magistrate Grade 1s and Grade 2s present, the staff of the judiciary, ladies and gentlemen, I greet you all in the name of the Lord. I warmly welcome you to the closing ceremony of a 2 days conference for the registrars and the magistrates. My Lord, the DCJ, we are very thankful that you're here, my Lord, to officiate over the closure of a 2 days conference where we've been all categories of the lower bench judicial officers, including registrars. Your Worships, the registrars, please stand up for recognition. Thank you so much for coming. My Lord, present with us are the Chief Magistrates. Please stand up for recognition, Your Worships. My Lord, we have the Magistrate Grade 1s drawn from the various parts of the country. Your Worships, please stand up for recognition. My Lord, we also have Grade 2s. Your Worships, please stand up for recognition. We thank you all for making time to be here. Thank you so much. My Lord, the Honorable Deputy Chief Justice, the conference that we have had for 2 days now has been organized by the Judicial Training Institute under the theme of enhancing judicial accountability and access to justice. My Lord, this is like the food that we eat in order to be able to deliver accessible justice to our people. The training that we have had, my Lord, has been organized and the modules delivered have been packaged in such a way that they are empowering us to be able to deliver a justice system that holds us to be more accountable and also to improve on access to justice for our people, my Lord. My Lord, we have been here for 2 days, and I wish to inform you, my Lord, that the Honorable Chief Justice was here yesterday in the afternoon, and he officially opened the conference. We have had a series of facilitators, my Lord, as per the program, and I believe that the participants are going back, my Lord, to their stations, better equipped than they came. We thank the judiciary top management, my Lord, for making funds available and for supporting us to ensure that this training is delivered, my Lord. My Lord, we give special thanks to the Executive Director of the Judicial Training Institute and the focal judge in charge of ADR, Professor Honorable Justice Andrew Hauka, and the team at JTI for delivering a successful training, my Lord. We thank them so much for all the efforts that they have put in place. My Lord, for the 2 days we have been here, we have made resolutions which are going to be our takeaways. My Lord, the Honorable Deputy Chief Justice, please allow me to invite our Worship Marlene Obizu to take us through the resolutions that we have made for this training, my Lord. because we know that we need the support and leadership of top management to enforce and implement the same. Your Worship, please come and take the members of the top management through the resolutions that we have made for this conference. Thank you very much, Your Worship.
You use this, don't use it.
My Lord, the Honorable the Deputy Chief Justice, my Lord, the Honorable the Principal Judge, my Lord, the Executive Director, JTI, Your Worship, the Acting Registrar. These are the resolutions that we have come up with after the two-day conference. We had read them earlier to get feedback from the judicial officers, and this is what we finally come up with. The first is on judicial leadership. My Lord, on the judicial leadership, the resolution is to exercise leadership with integrity, professionalism, humility, accountability, and ethics. The second is proactive case management, and on that, our resolution is to actively adopt and strengthen proactive case management through the use of various strategies, such as docket control, because there were issues with lawyers taking control over our courts. So take control of your docket, timely rulings, reduction of unnecessary adjournments, and the strategic use of ADR, among other strategies. The third is the promotion of ADR and plea bargaining. And under this, we are saying that we have to actively embrace and promote ADR and plea bargain, small claims, and all other judiciary innovations through sensitization, collaboration, and applying a human rights-based approach while doing this. And number 4 is on innovations and digitalization. And the resolution is to undertake leveraging all digital tools such as ECMIS, ULI. We're also informed that the judgment rating tool is coming up, and data-driven methods to improve research, decision-making, and court performance. The 5th, my Lord, is public trust and accountability. Under this, we are resolving to exhibit transparency, consistency, proper record keeping, and ethical conduct to strengthen the public trust in the judiciary. The 6th, my Lord, is collaboration and teamwork, and we are resolving to foster teamwork, inclusive decision-making, collegiality, collaboration amongst judicial officers, the support staff across all courts, and the related actors in the administration of justice. And 7, we have the integrity and court user experience. We are committing ourselves to integrity, inclusivity, respect, and accessibility with special attention to vulnerable court users. And number 8 is workplace dignity and safety. This is in relation to sexual harassment, which is a topic that was discussed yesterday. And we're saying that we shall enhance sexual harassment awareness and prevention with regular sensitization and immediate reporting, because we learned that at our courts we have focal persons who have been elected to lead the anti-sexual harassment in those different courts. And the last one, my Lord, is combating corruption practices. And here we're resolving to uphold integrity and prevent corruption and bias through adopting strategies to curb both actual and perceived corruption, and also to treat all court users with dignity, respect, and to creating user-friendly environment for all court users, especially the vulnerable. Thank you very much.
Please give her worship a big hand of applause with permission from the DCJ. Thank you so much, Your Worship, and the team from JTI that have been doing the rapporteuring since yesterday. My Lord, the Honorable, the Deputy Chief Justice, while we were having our conference, we have one of our colleagues who has decided to write a series of books in hope of empowering us. He wants to encourage us to read them, to be able to understand the various concepts, but also to empower us to become better judicial officers and better service providers in our different capacities. So my Lord, to that, His Worship Kawesa has given us copies of books for us to keep in our library of the judiciary, and also to be able to read them, but also he has encouraged us to buy copies, both personal and for the institution, so that we can read them during our free time. My Lord, while we were closing, the books were handed over to the Public Relations Officer. I take the opportunity to invite him, my Lord, to come and hand over those books to a member of the top management of the judiciary, because indeed they are ours and to be placed in our library, my Lord. I welcome you, PRO. His Worship Pereme is a Public Relations Officer. I'm actually standing here for and on his behalf. Much as is present, he is indisposed this afternoon. Thank you, Your Worship. Please.
Thank you, my Lord. And without much ado, there are a series of these books. With your permission, I will just read the titles. My Lord, we were given a book titled Bullying, Harassment and Discrimination. Is Uganda's Judiciary Safe? We equally got a book, Bullying, Harassment and Discrimination of Non-Judicial Staff, a case study of Mubende, High Court Circuit. Equally, he gave us a book on stress management and resilience among judicial officers in Uganda. We have a book titled The Future of Justice, Innovations in Uganda's Judicial System. We have a book entitled Uganda Judicial Attitude Survey 2025. We have Beyond the Courtroom, Transformative Justice for a Better Uganda. We have Delayed Justice, Case Backlog in Uganda and the Right to Due Process. We have Automation of Justice Delivery, Integrating AI in Uganda's Judicial Processes. And finally, we have Judicial Bullying of Advocates in Uganda, Myth or Reality, a survey report. My Lord, allow me present these books to the Chief Registrar for further management. Thank you.
Your Worship Kawesa, thank you very much for the donation. We are very grateful. Can we please give him a big hand of applause? Thank you so much, President Emeritus. Thank you for your big heart. My Lord, without further ado, please allow me to invite the Chief Registrar to come and give her remarks during this closing ceremony. Your Worship, I warmly welcome you. Thank you very much.
Thank you. Thank you very much, the Deputy Registrar, ADR. My Lord, the Honorable, the Deputy Chief Justice, allow me to stand on the protocol that was laid down by the Deputy Registrar.
My Lord, as we come to the close of this two-day annual Registrars and Magistrates Conference, I rise with deep sense of gratitude and renewed commitment to our shared mandate of administering justice. First and foremost, my Lord, allow me to sincerely convey our utmost appreciation to you, the Honorable, the Deputy Chief Justice, for presiding over this closing ceremony. Your presence here speaks of your deep sense of purpose with and strong support for the lower bench in administering justice. My Lord, we thank you. I also would like to thank the Honorable, the Principal Judge, for being here. My Lord, your presence here both now and yesterday is a testament of your deep interest in and commitment to the state of the registry and magistracy. We thank you for being here today and also for being here yesterday, my Lord. Thank you. My Lord DCJ, over the past 2 days, we have engaged in rich and candid discussions. We have taken stock of where we are. We have also examined practical challenges in our courts and reflected on innovations aimed at improving efficiency, integrity, and service delivery. My Lord, these discussions were not theoretical. They were grounded in the daily experiences of registrars and magistrates who are the engine room of the judiciary. My Lord, the quality of the presentations, the depth of the conversations, and the openness with which experiences were shared are a testament to the dedication, my Lord, that define us. So, my Lord, allow me to commend all the registrars and magistrates for their active participation, your worships. Your contributions reaffirm that the judiciary's strength lies not only in its structures, but in the people who daily translate constitutional ideals into realities for the citizens that we serve. Your worships, your work determines whether justice is delayed or is delivered, whether systems inspire confidence or frustration. The judiciary, we are reminded, relies on us, and this conference has reaffirmed that we are equal to that trust. Now, as we depart, your worships, let us not leave these discussions behind in this hall. Let us carry forward the resolutions that we just had, the lessons and renewed sense of purpose, because we made these resolutions together, into our respective stations. For the true measure of this conference will be seen in improved case management, in enhanced professionalism, and a justice system that continues to earn public trust. Let us return with a strong resolve to not only improve the state of the registry and magistracy, as we had yesterday, but to make judicial accountability and access to justice a reality to the people of this country. Your worships, let us also put to good use the meaningful friendships, and I know that we made some really meaningful friendships, the mentors that we met, and I hope that we did, and the mentees that we chose, and again, I hope that we did, for the betterment of ourselves, the institution, and the country at large. Allow me now to extend our appreciation to our resource persons and facilitators for their generosity in sharing their time and expertise with us. My Lord EDU will convey our appreciation to the ones that we cannot reach now. Allow me to thank again the JTI team. Our deepest appreciation goes to Chair Governing Council for the leadership and strategic direction that he gives to the JTI. I thank the Executive Director, Justice Hauka, for ensuring that these ideas are well executed, and I also thank the registrars, the magistrates, and the entire team at JTI for working tirelessly to put this together for us. making the conference a success. I wish to thank all of you for your commitment, for your collegiality, and your unwavering service to the judiciary. After here, I wish you all a safe journey back to your stations, and I wish you continued success in the important work that you do. I wish you God's blessings for this season and beyond, and I wish you a Merry Christmas and a Happy New Year. I thank you. Allow me now, my Lord, to invite the Executive Director of the Judicial Training Institute, Justice Hauka, to come and make his remarks. My Lord.
My Lord DCJ, my Lord PJ, your worships, kindly allow me to stand on the protocol laid by the CR. My Lord DCJ, the program that informed this training was informed by CR in a consultation with her constituents. I say this because I remember shortly after I was appointed to the High Court, you called me to your chambers. At that time, you were principal judge. And you told me I am deploying you at the JTI, and you gave me reasons. I remember one of the reasons was, do not come up with programs that are not consultative with the people that you are going to train. And that's the mode, my Lord, that we have adopted. I also recall asking you a question. I said, my Lord, you are deploying me at the JTI, will you give me the support? And your answer was, tell me the support you need, I will give it. My Lord, I want to tell you that the support you have given to the JTI has been enormous because we've achieved quite a lot in a very short time. My Lord, I remember when you were PJ, you called me to your office and you said you wanted me to organize a benchmarking trip to Tanzania and to Kenya to go and study the JTIs in those two countries. I did put that together in a consultation with you. You talked to the Chief Justice and he was part of the delegation that went with you to Tanzania and Kenya. I remember we sat on a bus from Dar es Salaam to Lushoto about 7 hours. The equivalence of Kampala to Arua. And one evening you called me at dinner and you said, can't we have something like this in Uganda where we can also drive a distance similar to this and have a JTI? I said, it is possible, and I told you, I remember I heard that there was some land in Nakasongola for the judiciary. Could we explore that? You told me, find out and get back to me tomorrow morning. I called the Chief Magistrate Nakasongola at the time. His Worship Kakoza. Kindly stand up for recognition. And my Lord, when I called Kakoza, Kakoza said, yes, there is land they have promised us here. In fact, if PJ can come, that will fast track the process. Early in the morning at breakfast, I briefed you, and you told me to get in touch with Julius
so that we go to Nakasongola on Monday. It was a Friday, we are in Lushoto in Tanzania. So when we came on a Sunday, the following morning, you led us to Nakasongola, my Lord, DCJ, and you chaired a meeting with members of the local government of Nakasongola in the compound of the Chief Magistrate Court in Nakasongola. And that initiated the process of the land we boast of that we are going to build a JTI. And shortly after that, the title was processed. We now have land, and the PS was telling me they had commenced fencing the property. That speaks to the support and interest you have in training, and my Lord, we appreciate you for that. My Lord DCJ, I have been EDJTI for a few months. But those few months, you have been very supportive. I traveled with you to the Gambia for Simuja. And while we were there, you told me, I can see the head of the Judicial College of London here. We need to have a meeting with him and discuss partnerships. I can see CJ Jamaica here. We need to have a meeting with him and discuss partnerships. I can see CJ Papua New Guinea here. We need to have a meeting with him and discuss partnerships. And all those meetings happen. We had a meeting with the CJ Jamaica. We had the meeting with the CJ Papua New Guinea, and we also had a meeting with the head of the Judicial College in London. All this is to agree how we can support and raise the profile of the JTI. So my Lord, DCJ, we appreciate you for that. I had occasion to work with you before you were appointed PJ closely when you were resident judge in Masaka, and eventually when you became the senior resident judge, Mbarara High Court Circuit. Your love for ADR is not in doubt. I remember you, my Lord DCJ, and PJ, who were in Bushenyi one time, doing criminal ADR, commonly referred to as plea bargaining, with Lady Justice Joyce Kavuma. You had targets to conclude, we left prison towards 9. I think it was the call of the OC to you that made us conclude, otherwise we were willing to push on. When you were PJ, you had a series of meetings with the Chief Justice to ring near and give a new direction to civil ADR. And eventually, when you became DCJ and chair of the Judiciary Case Management Committee, you have really attracted a lot of support to ADR. And in the resolutions, my Lord DCJ, that were highlighted this afternoon, ADR is coming out prominently. And we want to assure you, my Lord, that we will do all it takes to ensure that these resolutions are realized. Lastly, my Lord, allow me to appreciate Her Worship Lillian Buchana and the team at JTI. I don't know whether Her Worship Lillian is here. The team at JTI, if you could stand for recognition. I can see, my eyes always see Nakato very fast. I don't know why. I can see the JTI team, Joel. And my Lord, when I saw Joel, I remembered something I had forgotten to appreciate you about. Yuli. Yuli was being treated more or less like a child that a mother came with in a marriage. It is you, my Lord DCJ, that grabbed Yuli and attracted funding to Yuli. I think the first money you got was about $100,000 US, my Lord, if I'm to recall correctly. I was discussing with the Solicitor General. There is a pending approval, again, my Lord, arising out of your support for Yuli to a tune of close to, I think, $500 million. If my mathematics serves me right, all this is in fulfillment of the commitment you made to support the JTI. My Lord DCJ, we shall forever be grateful and commit to you that we will do all it takes to ensure that we come up with programs in consultation with those that we are going to train as per your guidance. My Lord, I beg to stop here and now invite the Honorable, the Principal Judge, Lady Justice Jane Francis Abodo, to come and speak to us. I thank you for listening to me.
My Lord, the Honorable, the Deputy Chief Justice, my Lord, Professor Andrew Kauha, Executive Director, Judicial Training Institute, Your Worship, the Acting Chief Registrar, Your Worships, the Registrars, the Chief Magistrates, Magistrates Grade 1, Magistrates Grade 2, distinguished facilitators from yesterday to today, and resource persons, ladies and gentlemen, good evening. As we come to the close of this year's annual Registrars and Magistrates Conference, I would like to thank each one of you for your active participation, contributions, and of course, commitment over the 2 days. I say that with a lot of meaning because there are some of you who did not attend, I am sure. But the fact that you who are here have made it and stayed on for the 2 days, I want to say thank you. Most of you have traveled from, yes, you clap for yourselves. Yeah. Most of you have traveled from all corners of Uganda to be here and sacrificed personal time during this festive season. The insights shared and conversations you have had have truly made this conference a resounding success. Over the past 2 days, you have delved into carefully curated programs that address the real challenges and opportunities that you people in the lower bench face. I really don't always like to say challenges. I think they are really opportunities. When you look at them that way, then you actually get solutions for them. So they are not challenges, they're opportunities which you should grab with both hands. I think they have taken you through case management to the state of the registry and magistracy, from value for money adjudication to panel discussions on alternative dispute resolution, and from discussions on combating sexual harassment in the judiciary to today's practical sessions of ECMIS and CAS, data entry, performance management as a tool for accountability, and of course the critical role of judicial wellness in sustaining productivity. We have covered ground that is broad and deeply really relevant to your daily work. I'm confident that these discussions have provided you with actionable strategies to enhance efficiency, transparency, empathy, and accountability in justice delivery. I was very happy to see that those were captured in your resolutions. I would like to take this opportunity to extend my appreciation to all our distinguished facilitators and panelists for generously sharing their expertise and their time. Your contributions have really challenged our judicial officers towards a more accountable, more responsive, and more people-centered justice. My sincere thanks, of course, goes to the Judicial Training Institute, my Lord, Professor Kauka, and your team. You're really able team. I remember that at one point, sometime, I think 15 years ago, we tried to organize a training with the Justice now, Sarah Kalibala, judge in Lira. We tried to organize a training of 40 people. And by the end of organizing that training of 40 people, we were not talking to each other.
because they were also stressed. So I can imagine the Judicial Training Institute, and they're still smiling, and they've been doing this training from Supreme Court to the High Court to the lower courts. And within just a period of 1 week, all those trainings have been happening. I don't know how you do it, but we want to say thank you, my Lord, Professor Kauka, and your team. Your worships, as of course not forgetting the governing council, Justice Chibita was here with us yesterday, and I'm sure that of course his leadership is very key in this. Your worships, as I stated during the opening, the judiciary leadership remains fully committed to supporting you, and I'm certain that we shall have the opportunity to engage further, to listen to your challenges and work together on practical solutions. In return, I once again urge you to enhance your roles as leaders at your stations, continue promoting welcoming court environments, ADR mechanisms, upholding integrity, and prioritizing the human dignity of every court user. Like I told you, not the justice, people don't see the justice in the judgments that you pass. The justice is in the lived experience from the time someone enters the courtroom premises till to the very end. If you're waiting to deliver justice in your judgments, then you're wrong, because then it will not be that justice that people feel. It's the real justice. So I am also happy that it was also captured in your resolutions. I'm confident that the insights, the networks, and the resolutions from this conference will translate into tangible improvements in service delivery, of course, backlog reduction, and public confidence across magistrates' courts nationwide. As we depart for the festive season, I want to wish you safe travels. I want to wish you all the very best during the festive season. And of course, the Merry Christmas, the New Year. Please take care of yourselves, and we want you strong and safe in 2026. I say all this for God and my country. My Lord, the Honorable, the Deputy Chief Justice, it's now my singular honor to welcome you to address us. Most welcome.
My Lord, the Honorable, the Principal Judge, let me ride on the protocol that was outlined much earlier. Good evening to you all. It's my profound pleasure to address you this evening at the closing ceremony of this annual gathering of registrars and magistrates. Magistrate courts are the bedrock of Uganda's legal system. Accordingly, you as magistrates become the core face of Uganda's judiciary. You are on the front line of our legal system. More than 70% of all cases filed in this country begin and end in the magistrate courts. Therefore, the pulse of our justice system is greatly felt both through your pens and your conduct. And I emphasize the last one, your conduct. As a consequence, your daily actions directly impact public perception and the realization of justice in our beloved country. So there was a, you know, when I was principal judge, I used to visit your courts. So there was a place where I went and they told me that the chief magistrate was drinking with the court bailiffs and the money lenders. So that after you know, they come to court and say, "Hey, chief, are you about to finish? Can we go for 1-1?" Now you imagine, you are drinking with the court bailiffs and the money lenders. Regardless of how good you are in court, no one will understand you. So your actions, daily actions, directly impact public perception and the realization of justice in our beloved country. Now, when we were young, there was a magistrate at our sub-county. Of course, they used to tell us that when you pass by the sub-county, you can be arrested. So, and they had told us that when you reach near you run and then you stop after the sub-county. But vividly, I still remember you would see people carrying chicken in their hands going to court. Goats tied near the courtroom. I was young, but you know, as I reflect, surely, and they used to tell us that when you come to court, he says, you smell a goat, you know, like that you smell like a goat, meaning that he's telling you,
It is a goat.
yeah, I want a goat. He was eventually interdicted, I think. And, but at that time, of course, communication was not as good as it is today, so it was very difficult. I come from a sub-county which you struggle to find on the map of Uganda. Okay, let me remind you that the pursuit of justice is a noble calling. Judicial power is not a privilege of office. It is a sacred trust bestowed upon us by the people of Uganda, from whom all judicial power is derived. Therefore, our collective mission of the judiciary is clear. That is to establish and maintain an independent, competent, trusted, and accountable judiciary that administers justice to all. The theme of this conference is enhancing judicial accountability and access to justice. Accountability is an essential mechanism by which we build and maintain public trust. True accountability advances judicial independence and paramount rule of law, ensuring that we apply the law fairly and impartially without fear, favor, or ill will or affection. Access to justice, on the other hand, is a fundamental human right. For ordinary Ugandan citizens who often face significant barriers, our courts are the last bastion of hope. Thus, our collective goal must be to make justice services not only available, but also easily accessible, affordable, timely, and user-friendly, especially for the poor and vulnerable. Looking at the program content of this conference, I'm confident that during these 2 days, you as registrars and magistrates have engaged in candid reflections on your performance, case management in your courts, value for money adjudication and innovations being implemented by the judiciary, especially the alternative dispute resolution, and the use of information communication technology. I must acknowledge that we have in the past 5 years made significant strides in expanding judicial structures and manpower. However, the public still demands more from us in terms of integrity and efficiency. I commend registrars and magistrates who are doing good work at their stations. I thank you for your efforts. We know the good performers and the non-performers, and I hate the latter. I hate the non-performers with a passion, actually. We study performance and inspection reports. We also get feedback from court users, stakeholders, and the general public. Always remember, hard work pays. In the last financial year, we registered a significant increase in case disposal at the magistrates, which reflects your hard work despite a number of staffing gaps. It is my hope that you will perform even better in the current financial year. The judicial administration is committed to ensuring that all our judicial officers have the tools of work needed to ensure efficiency in all our courts. As you may have noticed, we have a number of projects for court structures, ICT equipment, among others, either ongoing or already completed. We have also been, especially in this regard, we are trying to ensure that if we are constructing courts up country, in the hard to reach areas, we should also construct residences for magistrates, so that you don't have to struggle to look for accommodation. Because I happen to have visited every court in this country, so I know when you mention a court, I know where each of you works. And the picture is vivid in my head. So I remember one of the places where I went and found the judicial officer was staying in the middle of a police barracks now. And when he refused to do what the DPC wanted, he was evicted. So we don't want you to be evicted for not doing what the DPC wants. So I think those of you who come from the Karamoja sub-region, I think we are constructing accommodation in Karenga. The court buildings are finished. We have built accommodation in Biratuk. I think we are now trying to get land in all those places where we have courts, so that we can again start planning for accommodation. So your comfort should be our priority. It is our strong conviction that the situation can only get better. The administration has a clear plan and strategies to address the existing challenges of infrastructure, staffing gaps, transport, and welfare for judicial staff. I'm sure many of you now have vehicles. And when I'm visiting you, I find you are the only person with the reasonable vehicle in the entire district. So actually, people envy you out there. And we shall continue to ensure that, until we get each of you transport, for example, we shall not relent, we shall continue. We shall continue engaging the two arms of government while mindful that the size of our national cake might mean that certain aspects can only be achieved in the medium and long terms. In the meantime, let us all use what is available to serve our people better. In the end, what people are interested in are quality judicial services. Despite the notable progress that the judiciary has registered, we still face some persistent challenges. Number one, case backlog and delays. Delays in case processing remain a significant concern, contributing to public dissatisfaction and economic consequences. This includes delaying judgments after hearings are completed. When we did the court case census, we found there was a case pending in a magistrate court for 40 years. If that case is pending in your court, what do you think someone should think of you? 40 years. Some of you are it was filed before you were born. Can you imagine? So what does that show? It shows that you don't know case management in your station. Do you know what you have? Do you know what is pending before you? Because that's an indicator. Otherwise, then you should have completed the 40-year-old case. Number two, perceptions of corruption. Public trust can be fragile. Allegations of corruption such as trading bail or making decisions based on powerful or influential interests undermine the integrity of our institution. Now, bail, I'm told at the stage when someone comes to take plea, there is a thin line between going home and going to prison. So then that's where some of you enhance your bargaining power. You will never go to heaven if you are doing that. We may not be seeing you, but you will definitely go to hell. Now, you imagine if you are corrupt. I always use this example. You are corrupt. You have taken money in the morning. Okay? And then you normally take pleas in the afternoon, apparently. So in the morning, you receive the bribe. In the afternoon, you are taking plea of a person who has stolen a bunch of matoke. You are as a thief as the one who stole the matoke, who you are remanding. And then you write, remanded until. Why don't you remand yourself? Because you're also a thief. Of course, there are few apples. I'm not saying that many of you are very good judicial officers, but there are few rotten apples. And sometimes you can easily smell them even when you are when you are rotating around. The public will even tell you immediately as you are moving around. They will say, "Ah, that one is a rotten orange." Then you, okay, resource constraints, inadequate court infrastructure, sufficient operational funds, and manpower gaps impact our efficiency, particularly in upcountry courts. But like I mentioned, we have a plan in place to tackle this problem. I'm sure there are some courts I visited at one time. I think one of the interesting ones was in Katwe. You know that area where there is the salt factory or salt mining, whatever. And I sat on the table of the magistrate to sign a visitor's book. By the time I finished signing the visitor's book, the book was full of bat droppings. And when I asked him to go for a short call, he told me, "My lord, sincerely, you cannot manage." So I know resource constraints can sometimes be challenging. Then the digital divide. While the ICT initiatives are a leap forward, a significant portion of our rural population lack access to the necessary digital tools which must be addressed for inclusive access to e-justice. I think we are trying to, in our discussion on the case management, I think we are looking at establishing a local area network and what do you call the other one? The wide network. So we think that will help in the near future. We shall address these problems, especially for the hard to reach areas. Then we have poor work attitude and lack of customer care at some courts. Now, I want to mention that this poor work attitude is a very big problem. You know, to find that you don't mind whether the work is moving or not. So I've seen where the CR sometimes writes you letters. You left the station with 50 judgments. It's now 4 months and you have not delivered any. Now, so there are things which I have noted over time when I was still your direct supervisor as principal judge. One of them was the ambience at your courts. Those who have good courts, of course, the ones that we have built ourselves. You enter the registry because that's the first point of call. You look at the filing cabins, all the cabins are broken with the old files peeping, with the old toners which were used 10 years ago on top of the filing cabins, with the old typewriters which were last used by the secretaries in 1990. All of them at your reception, which is the registry. Go to your chambers, the curtains. There is one, not the current registrar in Fort Portal. There was, at one time I went to Fort Portal, there was a registrar in his chambers. I found his curtain was hanging on a thread. You know, these threads of Kamba, Saiso. And it was half. But even the half was torn. So I looked at it and said, "Your worship, what is that?" He said, "You know, my lord, we have been asking estates to buy curtains." I actually told him, "Can you remove even that one so that we know that you have no curtains?" really ambience in your courts. The compound, the grass is as tall as if you are rearing snakes. And yet you have prisoners, you convict people for, for community service, but your compound is bushy. Everywhere you go, the tiles are smiling, the chairs, smiling chairs. And those are you find some magistrates and registrars, the chairs where your lawyers and your clients sit, smiling at the. All those can be repaired by simply just using OP to have a good environment. So for me, when I enter and I look at those, I know I don't even ask for statistics. I know the statistics will also be smiling like the chairs. Okay. Of course, customer care, that is that's given. I'm sure they must have talked about that. I don't need to emphasize it. But another problem is absenteeism. Absenteeism. And let me tell you, your worships, those of you who have that habit, stop it. These people you serve up country there are poor people. To come to court, they spend 1,000, but to get that 1,000 is a tug of war. You imagine someone travels and then reaches the court. You are not at court, but not that you are sick, but you have opted not to go to court. Just opting not to go to court. Sometimes you are in a supermarket on a Tuesday, and then you see his worship or her worship pulling a trolley in Kampala when he's supposed to be. And these things actually happen to you when you don't expect. There is one I found pulling a trolley, and then when we asked them to explain why they were not at their station, she said, over the weekend I felt sick, and he had a doctor's report that she was sick. I wish both them and the doctor could be brought before a judicial officer to explain. But absenteeism. And as you know, we are going to take absenteeism seriously. Not being at your station. Some of you, Monday is for traveling. You arrive there tired. Tuesday, you come to court at midday. You work Wednesday. Thursday afternoon, you are back on your road going to where? To Kampala. And when I was a principal judge, I already knew who were doing that. It doesn't take rocket science. Just a telephone call to either a DC or I just say, monitor for me a judicial officer for 1 week. They would tell me, they will not tell you, of course. Some of them would say, that judicial officer of yours is never here. The whole of last month, he worked on 4 times a month. Now, archives. Archives, we started a system of organizing them, and I'm sure the new principal judge will continue with that together with the CR. Your archives must be organized, and no one will organize them for you. We want a system where we can get a file in 1 second. That system must continue. Lastly, exhibit stores. One time at the High Court there, I had been in all your courts complaining, abusing you for poor exhibit storage. Then I decided to visit our own at the High Court. So I told the Registrar, where is Festo? Yes. So I went with the Festo to our archive at the High Court. Now that archive, that exhibit, both archives and exhibit store are below the office of the former office of principal judge, where I was sitting. So in other words, they were under my office. What did I find there? Bombs, rifles, grenades, pistols. And then when we invited the counter-terrorism people to take those things away. One of them said, you know, these old bombs can go off on their own. So I was imagining flying through the roof. So can you imagine? So what was the problem? The problem was that we do not manage our exhibits. I'll give you another example. I went to Nakapiripirit. You know how the Karamajongo like guns. So when I entered the exhibit store, I found there fully loaded AK-47 rifles. Can you imagine? In Karamoja. And the ventilator was so huge that even who's big in this could pass there. So then I was wondering, what type of gift is this to the Karamajong? Most of us, they were not aware that the guns were there. Otherwise, they would have visited that exhibit store. To pick that, you can ask the PJ. She will tell you how those people enjoy owning those toys. So you must be able to manage your exhibit stores efficiently. Now, let me not take a lot of time. I know some of you are hungry and angry. So allow me to stop there. But your worships, one of the things I want you to always, every time you feel like you want to, not to perform or to do something wrong, always remember what I've told you here. As they are about to give you a bribe, you say, what did this just say? He say, take it away. You just look at me like your salvation. So that every morning when you are praying, God remind me what the DCJ talked about. So that and then performance. Maybe what I need to tell you is that the Director GTI is here. At the High Court level, we have been doing performance review meetings, and they are still continuing. Every quarter, we meet and we review each individual's performance. And you must explain why you have cases pending, where you have judgments pending. Why. So we are going to cascade it down to the magistrates, so that we measure your performance. If you can't measure, you can't manage. So I have to put you on notice that that will also be coming at some stage. So please work so hard. So I thank the Director JTI for organizing this training. As he mentioned, it's a passion really that I have. And as he mentioned, our land in Nakasongora is already fenced actually. The fencing is complete. We have even deployed there a police officer to ensure that the metro grills are not stolen. So, and very soon we want to build the state-of-the-art judicial training institute, which everyone in the region covets. And that's our dream. So we shall definitely have their accommodation akin to what you have been enjoying in some of these places, recreation facilities, so that when you go there, you really feel like you are in a 5-star hotel. So as I conclude, let me thank the Executive Director and the staff of the JTI for organizing and making this conference a success. It is now my honor to declare the Registrars and the Magistrates Conference 2025 officially closed.
Please give a bigger hand of applause to the Honorable Deputy Chief Justice. Thank you so much, my Lord. My Lord, we are always humbled by your words of wisdom. Let's have the anthems and then have the closure of official closing of the conference. Thank you so much, my Lord, for gracing us with your presence. My Lord DCJ, my Lord PJ, my Lord Executive Director, and your worship the Chief Registrar. Thank you so much for coming and spending this evening with us. And we pray that the good Lord grants us journey mercies as we go back home. I wish every one of us a Merry Christmas and a Happy New Year. Thank you very much. Thank you so much, my lord. The Honorable Deputy Chief Justice is inviting us for a cocktail. The protocol team is going to lead us to the venue. We had been told to be there at 6 p.m. and it's around the time. So you're welcome. My lord DCJ, thank you so much. We are now done. We need to go for the cocktail. My lord Principal Judge, thank you so much for being with us yesterday and today. We don't take your presence for granted. My lord Executive Director, we thank you so much for the mentorship, the guidance, and the energy that you put to these trainings. Your Worship, the Chief Registrar, thank you so much for all the support that you accord to us that enables us to perform and execute our mandates. Your Worships, please give a big hand of applause to everyone for being here, including yourselves. A bigger hand of applause to the Deputy Chief Justice for officiating over the closing of the ceremony. Another hand of applause to the Honorable, the Principal Judge. Another one to the Executive Director and the JTI team. Our Worship Buchana Lydian is here. I don't know. She has stepped out, I think. Thank you so much, Your Worship, for putting this together. We are very grateful, you and your team. And then we also thank the Our Worship, the Chief Registrar, for being here yesterday and today and being with us all the time. Thank you very much. You're welcome for the cocktail. Let's enjoy ourselves. Let's socialize. Let's network. And remember to go back home early and safe because it is a festive season. Thank you very much.
Why are you sending us home?